We're here in the matter of the application of Enbridge Gas Utah to increase distribution rates and changes and make tariff modifications. Let's note for the record, we're here on what we categorize as phase 2 of this general rate case. The parties reached a stipulation on revenue requirement some time ago, which we've indicated that we were going to accept and will be a part of our order, which, as I understand it, by calculating the 240 days, needs to be issued by December 27th, 2025. Does that seem to accord with everybody's recollection? Okay, good. So we appreciate the thorough preparation. We've had a chance to go through the testimony and the positions of the parties, and we'll take appearances of counsel for the record, and you could, if you wouldn't mind, tell us the order in which your witnesses are going to be presented, if that's okay. So first of all, let's turn to the petitioner here, to Enbridge Gas, and ask you to state your appearances.
Good morning, Commissioners. Ann Mitchell with the law firm Witt Sturdivant, LLP, on behalf of Enbridge Gas Utah, along with co-counsel Ronit Barrett from Witt Sturdivant and Jennifer Clark Nelson from the company. And our witnesses that we'll call in this order today are Austin Summers, Kelly Mendenhall, Jordan Stevenson, David Landward, and Jordan Parks.
Okay, all right, have that. Ms. Barrett, spell your first name for me, would you please?
Ronit.
All right, and pronounce it one more time.
Ronit.
Ronit. Okay, that'll help. Thank you. Thank you very much. It's nice to see all of you. All right, we'll turn to the Division of Public Utilities.
Good morning. Patricia E. Schmid with the Utah Attorney General's Office and Patrick Griecu for the Division of Public Utilities. We have 5 witnesses today. Patrick will be presenting 2 of them, and I will be presenting 3. Patrick will be presenting Eric Orton and Annette Orton, and I will be presenting Ryan Daigle, David Fields, and Matthew Pernicoli. Our witness...
And that will be in that order, I assume. You'll do your 2 first and then your 3, is that correct?
Yes.
Mr. Griecu's witnesses first and then
Yes.
yours, Ms. Schmidt? Okay.
Yes.
I think I interrupted you. You were going to say one more thing.
That was what I was going to say.
Okay. Well, I apologize for interrupting. Try to wait until you finish your sentence before I speak next time. Okay, good morning. Let's go to the Office of Consumer Services.
Yes, good morning. My name is Stephen Snar, representing the Office of Consumer Services. Robert Moore will be here and assisting me as well. We have 1 witness, James Daniel.
Okay, James Daniel. Okay, let's go to UAE next.
Yes, good morning. Philip Russell representing the Utah Association of Energy Users. We have 1 witness in this phase of the proceedings, and that is Courtney Higgins.
Okay. And are you okay if we go to you for your witness after the OCS? That's the order I'm planning on, is that?
Yeah, that's what I would expect, yeah.
Okay.
That's great, thanks.
Past practice seems to kind of be that way. Okay. All right, and then let's go to Nucor Steel.
Yeah, Jeremy Cook on behalf of Nucor Steel Utah. I also have co-counsel Laura Baker and Damon Xenopoulos online. And we have 1 witness today, Lance Kaufman.
Okay, thank you, Mr. Cook. And we previously issued an order that, I think for both your witness, Mr. Kaufman, and then for the federal executive agencies, that they could, and they should be online.
Yeah.
So we'll come to them in just a second. All right, let's go to next for the American National Gas Council.
Morning, Mr. Chairman, Commissioners. Mark Davidson of the law firm Fairfield and Woods, appearing on behalf of the American Natural Gas Council. We have one witness, Mr. Bruce Oliver.
Thank you, Mr. Davidson. Okay, and then the federal executive agencies.
Good morning, sir. Major Leslie Newton, representing the federal executive agencies, coming to you out of Tyndall Air Force Base in Panama City, Florida. And we have one witness, Matthew Smith, who is appearing online.
Okay. Thank you.
Thank you, sir.
Okay, and so our plan is we will proceed in the order that we just went through, with parties presenting their witnesses. We expect you'll present all of the issues and then tender your witness for cross-examination, and we'll work ourselves through this. I'm not optimistic this is a one-day hearing. I think I could be pleasantly surprised if it is, but just seems with the number of witnesses and the number of issues, it's likely to go 2 days. But we'll just see how it goes. Okay, let's turn first of all to Ms. Mitchell, and let me call your first witness.
Thank you, Chairman. The company calls Austin Summers.
Mr. Summers, it's good to see you. Welcome. Come on up. Will you raise your right arm to the square? Do you solemnly swear that the testimony you're about to give in this matter, pending before the Public Service Commission of the State of Utah, shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated. Go ahead, Ms. Mitchell.
Thank you. Mr. Summers, will you please state your full name and business address for the record?
Yes, my name is Austin Summers, and my business address is 333 South State Street, Salt Lake City, Utah.
And what position do you hold with the company?
I am the Director of Regulatory and Pricing.
Did you file testimony in this matter marked as EGU Exhibit 5.0 with accompanying Exhibits 5.01 through 5.14U, rebuttal testimony marked as EGU Exhibit 5.0R with accompanying Exhibit 5.15R, and surrebuttal testimony marked as EGU Exhibit 5.0SR with accompanying Exhibit 5.16SR?
Yes,
Do you have any corrections to make today to any of that testimony?
I do have one minor correction on my direct testimony, and it is on line 263. I'll give people just a moment if they want to get there and look at that. I'm changing one word. If you're online.
Just a second, we're not
Sure.
quite ready yet. I want to get the court reporter there. Okay, go ahead.
On line 263, it reads, yes, the company has issued an RFP to sell a portion of its Utah NGV stations. And I want to change the word issued to considered. So that sentence should read, the company has considered an RFP to sell a portion of its Utah NGV stations.
And you've made that clear in subsequent, in your rebuttal and surrebuttal testimony. I think that's in there, either yours or Mr. Mendenhall's.
I believe it's probably more clear in Mr. Stevenson's
That's probably
testimony,
right.
but
Yeah,
yes,
okay.
it is in there.
Okay, all right, okay, with that correction.
Mr. Summers, did you have any further corrections?
No,
And including that correction, do you adopt the contents of the documents that we referenced as your testimony today?
yes,
The company moves for admission of the direct rebuttal and surrebuttal testimony of Mr. Summers along with accompanying exhibits.
Okay. Are there any objections? Okay, the testimony, direct rebuttal and surrebuttal and accompanying exhibits are admitted into evidence. Thank you.
Thank you. Mr. Summers, will you please provide us with a roadmap of what the company's witnesses will testify to today?
Yes, first of all, I will be summarizing the cost of service and rate design issues that were addressed in my direct testimony and that I defended in my rebuttal testimony and surrebuttal testimony. Kelly Mendenhall will be summarizing the conservation enabling tariff and the transportation imbalance charge. All the other issues from Mr. Mendenhall's testimony were Phase 1 issues and were included in the Phase 1 settlement. Jordan Stevenson will be summarizing the proposed subsidy in the NGV class. The initial proposal for that subsidy was included in my direct testimony, but Mr. Stevenson filed rebuttal testimony on this matter. Mr. Stevenson also filed direct testimony that largely addressed Phase 1 issues and were included in the Phase 1 settlement. David Landward will then summarize the purpose of heating degree days, weather normalization, and the company's proposal to change the length of the normal heating degree day base period. Jordan Parks will then summarize the tariff changes that he proposed in his direct testimony.
Thank you, Mr. Summers. Will you please summarize your testimony at this time?
Yes, and I'm going to begin first with cost of service issues, and then I will follow that with rate design and then talk about some task force matters. Cost of service is the foundation for allocating costs and determining whether customer classes are recovering their full cost of service. While the Commission has discretion to adopt allocation factors it deems appropriate, I note that some factors proposed by other parties represent a significant departure from historical practice and would result in substantial shifts in allocated costs. There are multiple methodologies for conducting cost of service studies, and perspectives on fairness vary. Importantly, the company's overall revenue does not change based on which allocation method is adopted. With the exception of the proposed NGV class subsidy, all allocation factors recommended by the company are consistent with those used in the most recent general rate cases. The company is not introducing new allocation methodologies in this proceeding. The first allocation factor I want to address is the 60-40 blended allocation factor. That's sometimes referred to as allocation factor 230. The 60-40 blended allocation factor has been consistently applied by the company to allocate costs for feeder lines, compressors, and large measurement and regulation equipment. This approach is supported by Commission orders in the 2019 and 2022 general rate cases, which found the company's position reasonable and aligned with precedent. Arguments raised against the company's approach remain unchanged from prior rate cases. Parties continue to rely on similar language from the NARUC manual to justify alternative positions. In addition, Mr. Pernicoli revisits a design day argument that was previously rejected, and transportation customers continue to advocate for reduced weighting on throughput. The company maintains that its long-standing use of the 60-40 weighting is appropriate. Moving on to large diameter mains. Those large diameter mains are another asset that had proposed changes to the allocation. And as explained in my direct testimony, large diameter main facilities are generally sized for more than local delivery requirements and are therefore excluded from the distribution plant factor study. They are also smaller than feeder lines. The company's allocation method identifies customers not connected to the intermediate high pressure system and subtracts their delivered decatherms from commodity throughput figures. This approach is also consistent with historical practice and was used to develop the current rates. Beyond these major factors, parties proposed changes or at least raised concerns regarding allocation of numerous other costs. Where alternative proposals were offered, I addressed them in my rebuttal testimony. Many statements, however, lacked actionable recommendations for the Commission to consider. I want to talk about large customers briefly. The OCS raised concerns about the impact of large customers on existing customers, and the company recognizes that these new high-volume customers materially impact transportation class rates. Accordingly, in rebuttal testimony, I supported the OCS proposal to temporarily close the TBF class to new customers pending further analysis. Additionally, I proposed that the revenue allocation for the TBF class be set at 1.5 times the overall revenue requirement increase to mitigate cost impacts in this case. I want to move on and talk about gradualism a little bit. The concept of gradualism in rate setting was raised by several parties. And as I mentioned earlier, the company proposes to maintain historical allocation factors that have produced rates found to be just, reasonable, and in the public interest. These allocators were used in the 2019 and 2022 rate cases to bring all customer classes except the TBF class to full cost rates. The company is open to a gradual approach in this case, but does not support any outcome where a class other than the TBF and NGV classes pays less than its full cost of service. If the end result in this case is that a certain class of customers is paying less than its full cost of service, it would be a step in the wrong direction. If the Commission determines that proposed increases are excessive for a particular class, the company recommends adjusting allocation factors rather than allowing under recovery. That's everything that I have for cost of service, but so I'm going to move on to rate design issues. Similar to cost of service, the company has maintained consistency in its rate design proposals. The rate design in this case mirrors the approach adopted in the last general rate case when the transportation class was split. One theme about rate design proposals that we see in this case is that rate design modifications are easy to propose but difficult to implement. For example, Mr. Pernicoli discussed in his direct testimony some of the practical limitations associated with splitting the GS class. Dr. Kaufman discussed in his rebuttal how splitting the transportation class was proposed in one case, discussed in a working group, then effectuated in the next case. In this case, we also will have limited time between the timing of the Commission order and the effective date of the rates. Not all interveners proposed changes to rate design. However, those who did generally advanced proposals that would benefit their respective constituencies. While I will not address every proposed change, I will summarize 5 key items. Those are the basic service fee, the administrative charge, the billing determinants in the TBF class, block breaks in the TSL class, and the low pressure surcharge. So first is the basic service fee. The basic service fees proposed by the company were originally established in the 2013 general rate case and have been consistently applied in every subsequent case. While the company recalculates the basic service fees during each filing, it generally does not propose adjustments. This approach has historically been acceptable to other parties, and the company believes it remains appropriate in this proceeding. Moving on to the administrative charge. That charge applies only to customers in the transportation classes. Unlike the basic service fee, the administrative charge has been updated in every recent rate case due to volatility in transportation class growth and associated costs. Each case has reflected current conditions, and this proceeding is no exception. Costs have increased because Enbridge had reasonable increases, including taking on a full share of costs that had formerly been shared with Mountain West Pipeline. These changes necessitated a modest increase in the administrative charge. Moving on to the billing determinants in the TBF class. On behalf of UAE, Ms. Higgins proposed changes to billing determinants for the TBF class. Her proposal would significantly impact revenue collection during the test period. The company designed its rates based on known information in the test period to achieve a specific revenue target. Any deviation from those determinants would alter cost allocation among classes and reduce revenue recovery from TBF customers during the test period. Moving on to the block breaks in the TSL class, Dr. Kaufman, on behalf of Nucor, proposed modifying the TSL block breaks and increasing discounts for later blocks. These blocks were set in the 2022 general rate case when transportation classes were split, aligning with TBF block breaks that have been used for similarly sized customers. This structure also reflects the design used prior to 2013. My rebuttal testimony supports rejecting Dr. Kaufman's proposal and retaining the current structure. Finally, Dr. Kaufman also proposed a low-pressure surcharge that would apply to customers in the TSL class that are connected to the intermediate high-pressure system instead of the high-pressure system. In rebuttal testimony, I explained why this proposal conflicts with the principle of average rate making and recommended continuing the company's existing rate design. So moving on now to a working group, there were several parties that suggested that certain topics be studied before the next rate case. The company is open to evaluating some issues in a collaborative setting, but believes others have been sufficiently addressed and would not warrant additional resources. The company is willing to study methods to ensure the GS class costs are accurately recovered without intra-class subsidies, and the impact of large customers and strategies to prevent adverse effects on existing customers. However, issues such as weather normalization, the transportation imbalance charge, and the conservation enabling tariff have been thoroughly examined in prior cases and during this proceeding. The company does not think it would be an efficient use of resources to open these topics, or to reopen these topics. The company's proposals for cost of service and rate design are consistent with historical practices and will result in rates that are just, reasonable, and in the public interest. Accordingly, the company respectfully requests that the Commission approve its cost of service and rate design proposals as filed and as adjusted in the rebuttal and surrebuttal testimony. And that concludes my summary.
Thank you, Mr. Summers. Turn back to Ms. Mitchell.
Mr. Summers is available for cross-examination and the Commission's questions.
Okay, thank you. All right, Ms. Schmidt, are you going to do the cross-examination?
I am.
Summers?
Mr. Grecu is passing out what's been pre-marked as DPU Cross Exhibit 1. This packet contains the cover or title sheet of Mr. Pernicoli's surrebuttal testimony and DPU Exhibit 6.01 SR that was attached to that surrebuttal testimony. I'll represent that they are true and correct copies of what was filed in his surrebuttal testimony with the addition of the DPU Cross Exhibit sticker in the upper right-hand corner.
Okay. Well, the testimony is on file, but I think we'll go ahead and admit all of the exhibits that come in on cross-examination just as part of the record. So you want to move for admission of DPU Cross 1?
Yes, we request admission of DPU Cross 1.
All right, is there any objection? With no objection, we'll admit DPU Cross 1.
Mr. Austin, or Mr. Summers, have you had a chance to take a look at DPU Exhibit Cross 1?
Yes.
I have just a few questions. Did the company provide the peak day data the DPU requested in DPU Data Request number 29.01, which was attached as DPU 6.01 SR? DPU 601 SR contained not only the request, but the company's response.
Yes. Sorry, I believe was the question that you asked if I've reviewed that?
That was the first one. Now I'm asking if the company provided the peak day data that the DPU requested in that data request.
So this data request is asking for an allocation matrix from the model. That allocation matrix is not just peak day, I believe there's a lot of other information in that allocation matrix that is basically the results of all of the cost of service studies that would be in the company's model. So the question here is to provide the same information that is in that allocation matrix. The company does not update its cost of service studies on an annual basis. We only do those cost of service studies for a general rate case. There's a considerable amount of work that goes into those, and so they're only updated in rate case years.
Thank you. Those are all my questions.
Thanks.
Okay, thank you, Ms. Schmidt. Let's turn to the office.
We have no cross-examination.
Okay, well, maybe this is going to go faster than I thought. All right, what's that? Oh, Commissioner Harvey said he'll take care of it for us. That's what I expected, so. But before we come to you, Mr. Harvey, we'll finish with Mr. Russell.
And I also have a list of questions.
Great, thank you.
Mr. Summers, let's start with one of the items you mentioned in your summary, which is allocation factor 230. You mentioned that that this is a blended allocation factor. What do you mean by that?
Yeah, what I mean by that is that there are two components of that allocation factor. One is the average throughput, and the other is the design day component. So you've got, when I'm saying a blending, you're blending or weighting both of those factors to make one allocation factor.
And in your pre-filed testimony, you've advocated for the continued use of a blended allocation factor. Is that right?
That is right.
And tell me why you think it's important for that allocation factor of those facilities subject to allocation factor 230 to be a blended one.
Yeah, the reason I think that that's important is that those assets, things like large feeder lines, kind of the backbone of the system, are used for two different purposes. They are used to meet the design day requirements on a really cold day, so those assets have to be built large enough to meet those needs on a design day. And they are also used to meet the average throughput during the rest of the year, just the day-to-day natural gas that needs to move through those facilities.
Thank you. And you've also referenced in your testimony and have responded in your testimony to some proposals to modify that allocation factor. Is that right?
That is right.
Okay. And I think you pointed out that all of the proposals to modify that allocation factor use some measure of a blended factor. Is that right?
In this case, yes. I think all of those proposals used a blend with different weightings.
That's right. So the debate in this rate case is whether the weighting between demand and throughput is appropriate, right?
That's correct.
Okay. And on behalf of UAE, Ms. Higgins proposed using the system load factor, is that right?
That is right.
To set the throughput.
That's right.
And is that the method that is described in the NARUC manual?
I didn't take a position on that in rebuttal or surrebuttal. I think that all of the parties have used similar portions of that NARUC manual to justify their positions, and I never took a position on that. I think that there are different ways to read that language to decide what it means.
Okay. In your rebuttal testimony, you indicated that of all of the proposals that parties other than the company had made, that Ms. Higgins had carried the most analytical weight. Is that right?
That is correct.
Okay. And tell me why you think that is.
I think that Ms. Higgins' approach is looking at how the system is being used by calculating like a system load factor and the consistency at which people are using the system for design day versus average throughput. there's a quantifiable reason to get to that number, and so I think that it carries some weight without being, without using kind of an arbitrary number.
Okay, thank you. I'm going to move now to another topic that you mentioned in your summary, which is the allocation of large diameter IHP mains. We've just discussed why you think it's important to use a blended allocation factor for allocation factor 230, but you've resisted the use of a blended allocation factor for these facilities. Why is that?
Yeah, I think there's two reasons. One is that those assets are used for different purposes, whereas the allocation factor, the assets that allocation 230 applies to, those large feeder line mains and those large measurement regulation assets they have different purposes. They're the kind of the backbone of the system, whereas these large diameter mains they're used more for local distribution or getting gas to that local distribution system. So I think that they're used kind of for different purposes. That's one reason that I think that it should stay as the company has proposed it. The other reason is that it's consistent with the company's method in all of the recent rate cases, that we've continued to use that, the same allocation factor. And so I think that consistency is another important reason.
In the way that you currently allocate those costs is based on the distribution throughput allocator, right?
That's right.
And that's just a measure of throughput, right? There's no demand component, right?
That's right.
And the large diameter IHP mains are used to help meet the system demands on a design day, though, right?
I think that any asset on the system could be argued to be used during those design days, those really cold days. But I don't think that they are as significant. They're really designed more for, I think they're used more for that average throughput.
Okay, I want to move to a different topic also discussed in your summary, and that's the rate design with respect to the transportation bypass firm, or TBF class. To help illustrate a point, I want to have you turn to Ms. Higgins' direct testimony, actually it's exhibit in her direct testimony. Do you have that?
I don't.
Okay, I saw a really big binder
I know
up
it's
there.
massive.
I thought maybe you had it all.
Comically large binder, but.
I'm wondering if your counsel has exhibit 2.3, which is attached to Ms. Higgins' direct testimony.
I believe we have it. Just give us a moment. Thank you.
Yeah, sure thing.
Yes, I'm sorry, I didn't.
Thank you.
And I appreciate the help. Mr. Summers, I'm going to have you turn to page 8 of 9 of that exhibit.
Okay.
That should be a table. Is that what you've got?
Yes.
Okay, and that is a table. I'll just represent to you that table was produced in response to a data request from UAE to Enbridge. That data request is there in page 7 of 9, the page before this table. Do you recognize that table?
Yes.
Okay, and just generally speaking, can you confirm that what that table represents is the monthly projections for send out to the TBF class in the test period?
Yes.
Okay, and that shows a pretty significant increase from the months at the beginning of the year to the months in the second part of the year. Is that right?
Yes, these are the volumes that the company is projected to be in effect in the test period.
For the whole TBF class, right?
That's correct.
Okay. And can you confirm for me that what's happening here is that a single existing TBF customer is increasing its demand starting in June of the test period by a pretty large margin, right?
That's correct.
Okay. So the difference between the front half of the year and the second half of the year is based almost entirely off of this increase for one customer?
That's correct.
Okay. And as we discussed in our conversation about the allocation factors earlier, the allocation factor for quite a few of the facilities on the system are this blended factor with demand and throughput, right?
Yes.
Okay. And so for purposes of cost allocation, the demand component that you're using is the one that's the high one towards the end of that year, right? For purposes of allocating demand to the TBF class.
Yes, we used the demand that would be in place at the end of the year.
Right. For throughput purposes, though, it's a mix of all of the months of the year, right?
Are you still talking about cost of service? I want to make sure that I'm answering the question if we're talking about cost of service allocation or if we're talking about rate design.
We'll get to the rate design
Okay.
shortly, but yeah, for purposes of cost of service, is that how the throughput allocator is used for, you know, when you're looking at this, you know, monthly send out, is that how you would do it?
Yes.
Okay. And then for rate design purposes, how are the billing determinants determined?
So the billing determinants would be it's the total decatherms that we are planning to that we're planning to have go through the system. So it's that total decatherms. It's the sum of all the decatherms through the year. That's the volume of gas that we would use to collect the revenue requirement for the year.
Okay. And so the billing determinants generally follow the expected throughput.
Yes, it's that way for the TBF class and all of the other classes.
Sure. But given the unique circumstances of this class in this rate case, the result of that is that the peak demand allocator, which is spread across the whole year, and the throughput there's something of a mismatch there, right?
I'm not sure if I would call it a mismatch. I think that we're doing two different things. We're trying to determine how much cost should be allocated to that class, and that's one thing. But then making sure that we collect the right amount of revenue in the test period is another issue.
Sure, but the peak demand allocator is not the peak demand for each month of the year. It's a one-time thing that then is used to determine the peak demand allocator for all of the year, right?
That's right.
Okay. And Ms. Higgins, in her testimony on behalf of UAE, has proposed a mechanism to address this issue. Is that right?
Yes.
Okay. And the mechanism that she has proposed is to have the TBF volumes and the firm demand billing determinants be adjusted to apply the higher projected TBF load to each month of the year rather than just the last 7 months. Is that right?
That is her proposal, yes.
Okay. And you have disagreed with that proposal, right?
That's right.
Okay. And tell me why you disagree.
Yeah, I disagree with that proposal because it's, I think that it strays from what the company has always done, and I think that it's important, again, to keep consistency, but the company's proposal was a conservative estimate based on known information at the time. The volumes that we put in there, the reason I say it's conservative is because we did put it in. We have an estimate of when that customer would be coming onto the system. So we could have calculated the rates without putting that customer in, but putting that customer in seemed like the most accurate thing to do. Now the way that we set those rates for the rate design is we have to look at the volume of gas that's available to collect the total revenue requirement. So kind of that becomes our denominator, if you will. And then we're looking at the costs that need to be collected as the numerator. When you divide those two, that gives you your rate. The problem that I have with the UAE's proposal is that it adds more volume to that denominator, which effectively reduces the overall rate, and therefore it reduces the amount of revenue that the company will collect in that over the course of the year. So it's just I feel like the information that we have for the test period is what's shown in this exhibit that you're looking at, and that is the most accurate amount of volume that we know about in the test period.
A couple of follow-up questions on that. By the mechanism through which you've done this, put this into rates, won't that lead to the other TBF customers? Won't that lead to their rates going up, even though they're not contributing to this this much higher peak demand towards the end of the year?
When we're doing the whole cost of service and the rate design, I mean, you're looking at it from a perspective of how much is allocated to that class, and then to make sure that it's all allocated correctly, or that it's collected in full. Assuming that if you add a big customer in the cost of service process, they're going to be bringing their some cost with them. And so everything should follow that customer, so that we're collecting on an average basis, we're collecting the correct amount of revenue in that test period. Whether or not it affects other customers in the TBF class, I don't think there's anything on the record that really shows what that is.
Have you considered any mechanisms? Now, we've talked about the mechanism that Ms. Higgins proposed. Have you considered any other mechanisms to maybe mitigate the effects of this one-time increase in demand from a single TBF customer?
One of the proposals actually in Ms. Higgins' testimony that would be a good option, maybe it's not explored enough on the record, but she proposed a phased approach to this whole problem, where there would be 5 months of rates at one level, and then 7 months of revenue at the new level. And if you were to do that right, it would charge customers for correctly for those first 5 months, and then correctly for those last 7 months too, and maybe be more accurate on the assignment of costs. Like I say, that didn't get a lot of attention in rebuttal or surrebuttal, but as I look at the options that the commission has available to it, that would be a possibility that would work.
In your rebuttal testimony, you also offer a proposal to cap the revenue allocation to the TBF class so that it's equal to 1.5 times the overall increase in revenue requirement, right?
Yes, I did propose that.
Okay,
And that
tell
would
me.
work as well.
Oh.
I did propose that. I don't remember what else I said after that.
I think you
I
said,
did propose that,
I think you said, and that would work as well.
and that would work as well.
Okay.
Thank you, Mr. Russell.
Always happy to put words in a witness's mouth.
Well, there is no objection to it, so proceed.
And tell me why you think that would work.
The reason I proposed that is that that one large customer does have a significant, as that exhibit we're looking at shows, they have a significant change in volume to the class. And looking at Ms. Higgins' proposals and then combined with proposals from the OCS, that maybe we need to look at ways to make sure that customers are protected, other customers are protected. It seemed like it might be a good option to kind of push the pause button, if you will, on the TBF class and let the parties have some time to develop, look at that class and see what needs to be done to protect those customers. So what I proposed would be that we would still use the company's proposal to make sure that the company isn't harmed by a change in the rate design, but also to limit the effect on the existing TBF class. And that's why I felt like that was a reasonable compromise.
And you mentioned previously that the TBF class is a subsidized class, right?
It is a subsidized class, that's correct.
And so the result of capping the increase to that class means that some other costs are going to be leaking out to other classes to provide that subsidy, right?
That's correct.
Okay. Thank you. That's all I have.
Thank you.
Okay, thank you, Mr. Russell, appreciate that. We'll turn to Mr. Cook.
We have no questions.
Okay, Mr. Davidson, do you have any questions?
Yes, I do, Mr. Chairman. Thank you. Good morning, Mr. Summers.
Good morning.
I hope I don't steal Commissioner Harvey's thunder, because I have a little bit for you today. So, Mr. Summers, I'd like to start with a consideration of the basic service fee portion of your testimony in your direct at pages 15 and 16, if you have that in front of you. And there you suggest that the basic service fee should be set at a level sufficient to collect the minimum required amount to service an average customer in that basic service fee category regardless of usage. Do you see that reference?
Yes.
And am I correct that in that portion of your direct testimony and EGU Exhibit 5.08 explains how the company ensures that such a minimum required amount is recovered from the average customer in each meter category, correct?
Correct.
And as you explain at lines 399 through 401 of your direct testimony, the company's average gross investment was reduced in the analysis presented in EGU Exhibit 5.08 to show only relevant investment amounts to be included in the basic service fee, correct?
That's correct.
Now, at lines 422 through 425 on page 16 of your direct, you conclude your discussion of the basic service fees, at least in this part of your testimony, noting that although your analysis in EGU Exhibit 5.08 shows basic service fee costs for all meter categories higher than the company's current basic service fees, you state that the company has determined that the existing fees are sufficient. Do you see that reference?
Yes.
Now, am I correct, and I think you mentioned this earlier in your summary, that there's been no change in the basic service fee in 12 years. Is that correct?
Yes.
Okay. Have your costs to serve customers changed at all in those 12 years?
Yes, in all of the recent rate cases that we've done since 2013, there have been changes in costs. And those costs, though not collected in the basic service fee, have been collected in volumetric rates or other charges.
Other components of your rate, your standard rates other than the BSF, correct?
That's correct.
Okay. Now, would you agree that the basic service fee analysis presented in EGU Exhibit 5.08 indicates that all the company's current BSF fees collect noticeably less than the company's identified basic service fee costs?
Yes.
And why is it that the basic service fee hasn't been adjusted in 12 years to catch up at least on covering those costs?
Yeah, and that's a good question. I feel like that I explained in, maybe to some extent in my testimony, but in the 2013 case, it was something that was highly contested. That was a settled case, and the parties kind of, there was kind of an agreement that there was a reason to keep those basic service fees lower than what they were calculated at. And so since then, the company has just not viewed it as an important change that hasn't been, hasn't got a lot of attention. And so those basic service fees have just stayed. The company's proposed for those basic service fees to just remain flat.
And why is it not important to adjust those basic service fees on at least a periodic basis over a 12-year period?
I guess the reason we leave those, have proposed to leave those alone, is that that is something that, I don't know, I guess it garners a lot of attention from the GS customers. There are a lot of people who are on fixed income that they try to save money on their bill by using less gas, and if the basic service fees go up, they are able to, their ability to save money by trying to use less gas, that ability is diminished.
Is that the main reason why it hasn't been adjusted in 12 years?
I'd say that's one of the reasons. Again, I think that probably the most important thing is that it just hasn't been a key issue that the interveners in the case have been concerned about.
Okay. I'd like to move on to this brief discussion about the administrative charge. If you would like to turn to your rebuttal testimony at page 18.
Apparently, my comically large binder is just direct. I do have my rebuttal on my desk. I don't know if I'm permitted to get that.
You're
Fine with
permitted
me
to
for this, Chairman.
Sure, Ms. Clark can bring it to you, but you can go get it.
Okay, you said my rebuttal.
Correct. At, let's see, page 18, the administrative charge testimony that begins at line 385.
Okay.
So would you accept that for the large users of transportation service such as Nucor, FEA, UAE, the level of the company's administrative charge has generally a lesser impact on a customer's total distribution service charges than it would for ANGC, which represents greater numbers of smaller transportation service customers, the TSS customers?
I want to make sure that I am answering the question or that I'm understanding the question. If you're saying that the administrative charge is a more prevalent portion of the bill, of the overall bill for a small TS customer than for a TSL customer?
Correct.
That is true.
Okay. And at lines 390 through 420, at your rebuttal testimony, you begin a list of 16 separate assertions regarding the company's calculation of the administrative charge that you attribute to ANGC witness Oliver. Do you see that portion of your testimony there?
Yes.
And when I reviewed that list of 16, I didn't see any page references or number citations to Mr. Oliver's direct testimony. Is this just sort of your general thoughts about what he's proposed in his direct testimony without any citation to specific portions of that testimony?
No, though I did not put in citations, those are all issues that were raised by Mr. Oliver.
All right, well, at page 19, line 407 of your rebuttal, you suggest that Mr. Oliver asserts the company cannot provide backup regarding metering and billing issues. Is that an accurate representation of that portion of your rebuttal?
Yes.
Now, you mentioned your extra large binder there. I assume you do not have a copy of Mr. Oliver's direct testimony in it?
I do not.
Mr. Chairman, may I provide Mr. Summers with a copy, or perhaps his counsel can, so I can ask him a few questions about that?
Sure, you can provide him with a copy of the testimony
Thank you.
approach.
I know.
And again, this is the pre-filed direct testimony
of Mr. Oliver, yes,
of Mr.
Mr. Chairman. All right, Mr. Summers, let me have you turn to page 56 of Mr. Oliver's direct testimony and take a minute to look at lines 1186 through 1200.
Okay.
So when I looked at the list of 16 items that you had, that we spoke about a moment ago in your rebuttal, would you accept that Mr. Oliver's testimony is that the company has not provided support for its position regarding metering and billing issues, and nowhere does he state that the company cannot provide such supporting information?
In the paragraphs that I've read here, that you've referenced, he does not say that the company cannot.
Okay.
I would agree that it says in those, in that reference.
Okay. And am I correct that in your rebuttal testimony, other than page 19, line 407, we don't find any further discussion to support the company's claims regarding costs for employee time incurred to monitor or troubleshoot metering and billing issues? Is that correct?
Let me look at, and you said that was my rebuttal?
Your rebuttal, yes, page 19.
Also those, the list that we're looking at of those issues?
Yes.
Now that I'm looking at that, can I have you restate
Sure.
your question?
The point here, I guess, is that we don't find any discussion or support by the company regarding claims that costs for employee time incurred to monitor and troubleshoot metering issues, as reflected in your direct testimony, are difficult or problematic for inclusion.
Are difficult,
Excuse me.
that's what he said. Go ahead, yeah, but. Yeah, State your question again, please, if you would, Mr.
Sure.
Davidson.
Sorry for that. We've gone through this question several times. I'm not sure where I left off.
Would you read back what you have, and then he'll pick up from there?
Point here, I guess, is that we don't find any discussion or support by the company regarding claims that cost per employee time occurred to monitor and troubleshoot metering issues as reflected in your direct testimony.
Are problematic. Sorry.
Yeah, so to answer your question, I would be in my rebuttal testimony, and I believe I addressed that in a question on line 508 of my rebuttal testimony, where I talked about such an exercise of keeping track of all of those visits and the work that was done for specific customers in different classes would take an enormous amount of time by EGU employees, which would likely increase the administrative charge.
Okay, and one of the things that I noted from your discussion of the administrative charge and the response to Mr. Oliver is it appears that there's not a, I'll call it timekeeping system that the company uses for employee time dedicated to certain functions. Is that correct?
That's correct.
And why is that? Isn't that an important aspect of determining labor costs and in the aspect of rate making?
I don't think it's something that needs to be done. Nor do I think there would be a good use of time. When we have maintenance that needs to be done, for example, on these meters, if a technician needs to go out and change a battery in equipment, or if a technician needs to go out and check for why equipment isn't responding, they're recording their time in ways that are logical. But if you were asking that employee to then track their time for which class of customers were they serving, and I think there's no end to how deep you could go, how detailed you could look. A lot of these, as I've mentioned in my rebuttal, it would take more time for that employee to be recording their time in all of these detailed ways, and for purposes of cost allocation, the way that we're doing it, using studies and asking for maybe a survey of the people who are doing that work for how much time they spend on those are accurate ways to get those costs allocated.
And I think in your answer, you are concerned about the level of detail, but as I understood your prior response, there is no timekeeping system at all, regardless of the level at which the detail is reported.
That's correct.
Okay. At page 50 of Mr. Oliver's direct testimony, the copy I've provided to you, at lines 1062 through 1069, he observes that the administrative charge analysis more than doubles the percentage of gas supply costs assigned to transportation service customers compared to the analysis the company presented in the last rate case. Is that correct?
You're on page 50. What was the line reference?
1062 to 1069.
So in the answer that Mr. Oliver provides there, I don't think he says that it doubles. Oh, you're saying that it doubles just that?
Yeah.
That one component?
Correct.
Yes, and I believe we addressed that in rebuttal, that there were personnel changes in certain departments. There was a sell of, as we've separated ourselves from Mountain West Pipeline, there are certain costs that used to be shared that are now just company. They're not shared with anybody else. They're just directly from the company. So I think we explained why those costs have increased.
And the costs that you just mentioned, are those labor costs that are now, that were shared but are now just the responsibility of EGU?
Yes.
Now, other than the separation that you just mentioned of EGU from its prior relationship, in your rebuttal, there's no explanation that caused the increases in labor and labor overhead from some departments to be flagged as abnormal, is it?
I think I feel like we did an adequate job of explaining increases.
So back to your rebuttal testimony at page 22.
Okay.
Lines 486 through 492.
Okay.
In that question and answer, on those lines, you ask yourself a compound question and the answer with a no. Do you see that reference?
Yes.
Is that no to the question, is EGU's nomination process highly automated? Or a no to the notion that marketers do most of the nomination work for customers, or both?
It is an answer to both.
Both, okay. Do you agree with Mr. Oliver when he cites from EGU's response to ANGC data request 2.05, which I'll reference, it may be in your big binder, but I'll reference that states currently there is only one customer who is not set up to be nominated for by a gas supplier, and indicates there's 12 nominating agents submitting daily nominations for more than 1,250 customers. You remember that?
Yes,
That's correct?
that's correct.
How are the daily nominations for the company's 1,250 transportation customers we just spoke about submitted? Is that done through paper submission, verbal communications, electronic format? That's a standardized format. How do you do that?
It is through electronic means is how those nominations are made to the company. And then those nominations need to be, they're reviewed. It's not just an automatic, when they come in, that's what happens. But we have company personnel that will review those nominations, make sure that everything looks good for the next gas day and that everything's lined up.
And do they review each nomination individually, or do they batch them? How do they do that?
I'm not sure. I've never gotten that involved in that process.
Okay. I want to turn a little bit now to your rebuttal at lines 501 through 507, the hold burn to scheduled qualities topic.
Okay?
And is it correct that EGU's not had to curtail service to transportation service customers in recent years, but does issue these hold burn to scheduled quantity requirements multiple times a year?
Yes, that's what my testimony says.
Is there any documentation in your testimony or attachments that documents the frequency of the hold burn to scheduled quantity events?
No.
Do you have an estimate or a sort of back of the envelope number as to what multiple times every year refers to? Is it more than 2?
I would think it's more than 2, and I feel like I'd be speculating, but in the meetings, and the meetings that I attend, where I'm with them and things that I hear that they're talking about, it is a tool that they can use frequently so that they are not, it protects our system by not having them over-nominate or under-nominate on days when it might be cold or a holiday, when those nominations need to be accurate.
But you don't have a number in mind as
I do not.
like an average number of times per year that this has occurred?
I don't.
Does anybody else, any other witnesses today have that information?
I don't think any of the witnesses here today would have that.
Okay. So the company's tariff at page 5-21 allows customers or nominating parties to exchange or aggregate imbalances at a given receipt point in order to avoid or mitigate penalties during hold burn to schedule quantities. Do you recognize that reference?
Yeah, I don't have, well, I might have the tariff in this. That is probably what is in my binder.
That's my paraphrase of it, but
Yeah, but that sounds
familiar?
familiar, yes.
Okay.
I believe, for the record, I believe it is attached to Mr. Park's testimony.
Will you give me your tariff page again?
5-21. It deals with aggregation.
Okay, I'm at 5-21.
And in that paragraph that starts on the prior page, about 7 lines up from the bottom, there's a sentence that begins, penalties incurred. If that's helpful.
Okay. Maybe for the record, do you want me to read that?
Sure.
That sentence says penalties incurred during hold burn to scheduled quantity restrictions that are not totally avoided by aggregation shall be borne by the customer or prorated among the customers causing the penalty as directed by the nominating party. If no direction is received, the company will assign the imbalance to each of the nominating party's accounts on a pro rata basis for all such accounts that are contributing to the imbalance that adversely affected the system.
Thank you. So as I read that language, it provides that if penalties are not totally avoided by aggregation, a nominating party, in other words, a marketer, can prorate the penalty among the customers in an aggregation causing the penalty. Is that correct?
That's correct.
All right, let's go back to Mr. Oliver's direct testimony at page 52. And the issue regarding maintenance material that's included in the administrative charge. And I'm looking at lines 1102 through 1109.
Okay.
All right, and that indicates that the maintenance materials represent essentially the second largest component of EGU's claimed administrative costs. Would you agree with that?
That is what Mr. Oliver's testimony says, yes.
And do you agree with him in that regard?
I would need to look at my own exhibit, the calculation of the administrative charge to see if it's the second largest, but that cost for maintenance material of $609.10 does look correct. If you'll give me just a moment, I can verify.
Sure.
Yes, I would agree with that.
Okay. And I didn't see anywhere in the testimony or attachments that there's support for that $609.10 per customer value. Is there any backup for that you can provide with respect to the calculation of the maintenance material cost?
I believe the only data that would be on the record is what I've proposed in my direct testimony and backed up with rebuttal and surrebuttal.
Okay. All right, so let's say continuing with equipment, let's talk a little bit about the telemetry portion of your testimony at rebuttal, your rebuttal at page 20, lines 430 through 432.
Okay.
And there you represent that those responsible for maintenance of telemetry equipment report needing an extra hour for maintenance every year, and these costs have been included. Do you see that reference?
Yes.
Is there any further justification for the additional, I'll say, labor expense for this telemetry maintenance function?
I think the answer to that would be just what's in the evidence that's in my direct testimony and rebuttal and surrebuttal. Again, the way that was determined is that we talked with the actual technicians. We surveyed them and we talked with them and said, how long are you spending on these? And they said, it's I think it was 4 hours instead of 3 that had been used in the prior case. So I have no reason to inflate that number. It was just a question that we asked of them.
And do you have any knowledge as to what added a third of the time to would go from 3 to 4 hours for that function?
No.
Okay. Page 26, lines 592 through 596 of your rebuttal. Your answer to the question of whether telemetry equipment is a disincentive for customers to join the transportation classes is no. And you suggest that telemetry is an absolute necessity for the company. Do you see that portion of your testimony there?
Yes.
Isn't the question of whether the cost of telemetry to serve transportation customers as a disincentive is a different question than whether telemetry is necessary to serve transportation customers?
I guess it depends on what you're looking at as a disincentive. If you're looking at it as the company is intentionally causing a disincentive for customers to join the transportation class, the answer to that would be no, and that equipment is necessary. If your question is do expenses act as a disincentive? I think that's something that individual customers need to look at to see if it's something that can save money by going to the transportation class, or if they can stay where they're at, or whatever. But I don't think that there's an intentional disincentive in mind when the company is charging for that equipment.
And as far as the cost goes, would you agree, I think you've stated at page Mr. Oliver's direct testimony at page 68 references a $7,600 per customer telemetry cost. Does that sound familiar to you?
Yes.
At page 24 of your rebuttal testimony, lines 553 through 557. Is it your position that the company's transportation service rates and tariff provisions are designed to ensure customers who elect transportation pay their fair share of the costs incurred to serve them, so as not to cause operational burdens or gas supply planning challenges to the company?
Yes, that's what it says in my testimony.
Okay. And should the commission conclude from that statement that large firm sales service customers served under the company's GS and FS rate schedules who do not establish contract demands and who are not subject to daily nomination requirements cause no operational burdens or supply planning challenges?
I would not say that. They are, I would just say that they are handled in a different way.
And in what way is that different from the transportation service function?
Yeah, so rather than having a marketer that nominates the customer's planned gas usage, like in the transportation class, in the sales classes, the company's gas supply group is the one that's out purchasing gas for those customers. So those costs are not charged in through an administrative charge. They're just charged as part of general rates to those customers.
Does the telemetry that we talked about a moment ago that's used for the transportation service function reduce the operational burdens and planning challenges for the company?
The telemetry equipment is used to read the meters. So and it might be used in purposes of, to track penalties and that might be happening due to imbalances, or in the case of a hold burn scheduled quantity. That's why the company needs that telemetry data on a daily basis, whereas the sales customers, those processes are managed by the company's gas supply group on an aggregate basis.
Okay. Would you agree or accept for a customer using 3,000 decatherms a year, an upfront cost of $7,600 for telemetry equipment equates to more than the total annual charges EGU would bill to the customer for distribution service under the sales or TSS rate schedules?
I don't think I've seen the math running those volumes through the blocks, so I don't think I can answer that.
Okay. Now, if a customer switches from transportation to sales, transportation service to sales service, the telemetry that we've been speaking about that the customer is paid for up front, as I understand your rebuttal testimony, is not reused by the company.
That's correct.
And why is that? Isn't there another function that equipment can be applied to be used for?
And I've asked that question before as well. The answer that I was told is that, and this makes sense, that there's a lot of different needs for a lot of different customers. So if one customer no longer needs their telemetry equipment, it's not something that we want to just have sitting in a warehouse, taking up space, waiting for another customer to come along that has that exact requirement. The warehouse would just be, we would need more space to keep all of that equipment. So once the equipment, if a customer says that they no longer want to be a transportation customer, that equipment is no longer used.
Is that because the particular telemetry equipment for an individual customer is customer-specific with respect to their defined needs?
Yes.
And if in my example, our transportation customer switches to sales service for some period of time and then decides to come back, I assume that their piece of telemetry equipment is no longer available. They have to start all over with a new purchase and a new installation of telemetry equipment. Is that correct?
That's correct, and that's how it's laid out in the company's tariff.
Right. Can the customers keep that telemetry equipment since they've paid for it?
I don't believe so. I think that equipment belongs to the company, is what the tariff says, and so that equipment is also taken by the company.
So you don't pay for it, but it's yours.
Yes.
And why, how does that work? Does it go into your rate base when it's paid for by a customer?
It's not included in rate base, but for purposes of maintaining the equipment, the company is responsible for maintaining that equipment, and so that equipment belongs to the company.
Okay. We covered a few of these things already, so let me skip ahead here. One question that has come up, at least from my client's perspective, is whether the settlement of phase one in this case and the revenue requirement agreed to by the parties in that settlement agreement has flowed through the rate design in phase two.
It has flowed through the most recent model that the company has filed is in my SIR rebuttal testimony, and that model does flow all the way through, so it would include all of the cost of service and rate design changes applied to that phase one settlement amount.
And just for the record, am I correct that that's EGU Exhibit 5.15R?
It is actually 5.16 SR.
Okay. I was close.
Yeah.
All right. And in that correct exhibit, am I understanding that the company's full 7.61 overall rate of return was used for computing class revenue requirements?
The way that we modeled it, we left, because we did not want to put in a return on equity or any specific accounting adjustments, because the phase one settlement did not have any of those included. So we left the return on equity and all of the cost of capital the same as it was proposed by the company in the general rate in phase one, but we added just an adjustment to the overall revenue to get the overall revenue down to the correct amount.
And does the 7.61 rate of return, percent rate of return factor into what you just told me at all?
So remind me where you're getting the 7.61 before I...
So, well, let me back up here.
If that's the company's current
Yes.
proposed capital structure, that is not in the model. The company used what it proposed originally in phase one in the model. But again, that return does not have an impact on the overall revenue that is being collected, because there's just a one-time adjustment to the model.
Okay. So in the final version, EGU Exhibit 5.16 SR, did you say?
Yes.
SR. Does that reflect the proposed monthly demand charge per decatherm of contract demand at $5.64? Do you know?
That sounds like the right rate. I would have to verify. It's the company's proposed.
Okay.
It doesn't reflect any changes for any of the other parties' proposals in the SIR rebuttal or anything. It's just the company's calculation.
Okay. Let's say subject to check, $5.64 sounds right?
Right.
Okay. Now, the company's initial proposed demand charge for the TS customers was $4.69 per decatherm per month. Is that correct? Subject to check again?
Yes, and an important thing to note is that in that 5.16 SR, there was an adjustment made. So I'm gonna do my best to explain the history on this. When we did 5.15 for my rebuttal testimony, there was, we tried to include a lot of the different parties' proposals in that model. And then as we were doing that, we broke a formula that was referring to the 60-40 split. And I talk about this in my SIR rebuttal testimony. So in the SIR rebuttal testimony, we fixed that formula in the spreadsheet so that it's referring to the 60-40 correctly. So I would really have to check to see what the rate is for that demand charge. Because there was a correction made to it. That was something that Ms. Higgins pointed out to us that we corrected.
And in the company's previous electronic model that was filed as EGU Exhibit 5.14U, I think that's where you were referring, okay? That indicated that the company's TS demand charge at current rates is $3.37 per decatherm per month. Does that sound familiar from that exhibit?
Maybe look at one thing, and I think I can get you that. In the company's original proposal, I am looking at my direct exhibit 5.10. I'm looking at currently page 4 of 5 on that. This is a summary of the proposed rate design. And I'm looking in column D, line 14 on page 4. And that shows that the current effective rate was $3.37. And then if I look on that same line in column H, the company's proposed rate was $4.69.
Exactly. Thank you for checking that. Now, what I'm interested in, Mr. Summers, is how you explain that despite the reduction in the company's revenue requirement request that's now been settled in phase 1 of this proceeding, you're now proposing a significantly higher demand charge for transportation service customers.
And again, I think I would have to verify in the most recent model what that rate is, because in the rebuttal model, there was a math error, and so I would need to verify what it is in the surrebuttal model to make sure that that was corrected. It did make the rate too high in the rebuttal model, so I would need to verify what it is in the surrebuttal model.
So it was too high in the rebuttal, but perhaps moderated some in surrebuttal?
That's correct.
But is it still higher than the proposed $4.69 per decatherm per month value?
I would have to check.
Have you presented any assessment of the bill impacts that would result for TSS customers with respect to the increased monthly demand charge?
No, there was no analysis showing a typical bill.
Is that something that you think would be important information for the commission to be aware of in this proceeding?
It would be important, and let me back up a little bit on saying that, because there weren't exhibits showing a typical bill, but that exhibit that I was just looking at, that 5.10, does show the effect of the increase on rates. Overall, it shows the effect of the increases that they would see. It just does not show customers of different sizes, and that's where you get into kind of a hard exhibit to show is what is a typical TSS customer, because you've got customers that are using varying amounts of gas, you've got customers with different amounts of firm demand. So saying what does a typical customer look like, it depends on the customer and what you would call typical. So I think that's why we haven't included that.
All right, but I guess regardless, subject to check, you and I have agreed that the rates have gone up, the proposed rates, I should say, have gone up in the information you've provided in your SIR rebuttal in phase 2 here as a result of the settled revenue requirement in phase 1, correct?
Yes, because there was an increase in the revenue requirement, all classes have seen an increase in rates.
Let me have you turn to page 26 of your rebuttal testimony.
Okay.
And there you have a discussion of parallel service provisions. Do you see that reference?
Yes.
Have you presented any evidence in this proceeding regarding the manner in which other gas distribution utilities price sales service and transportation service in other jurisdictions?
No, all of my testimony is just relative to our company.
Have you ever looked at other jurisdictions and how they set forth sales and transportation service rates for their customers?
I haven't explored it very deeply. I think that when there's a lot of things that go into how one state might do things versus another state, and in our case, I know that we rely a lot on precedent and what we've done in the past. That's what I've said that multiple times. So it's hard for me to look at another state and to get some value out of that, because I just don't know the whole history and what parties are concerned about, what has been a hot topic or what's been settled in the past, those kinds of things. I just don't know.
So you haven't looked at any other states that maybe lean heavily on precedent like you'd indicated is done here to see how you compare to that?
No.
Would you agree with me that if a customer shifts from firm sales service to firm transportation service, the company gets greater certainty in terms of the demand expected on the system through the nomination process?
No, I don't think there's more certainty. Our gas supply group has a pretty good process in place to make sure that they're buying just enough gas and not too much gas on any given day based on weather forecasts and how much gas we typically need to buy for certain situations.
So there's no real benefit for the nomination process and the transportation service function of the company?
There certainly is, because our gas supply group does not purchase gas for those customers. They need to, so their nomination process is critical. They let us know how much gas they intend to use on a day and how much we are expecting to bring onto our system.
With respect to restrictions on the timing for new transportation customers, as I viewed it, the shift to transportation service is only permitted on one date each year, July 1st. Is that correct?
That's correct.
And why is that?
The tariff spells it out that way. The reason the tariff spells that out that way is because of the company's IRP process. There are, we want to make sure that as we are looking at how much gas we need to buy for our customers, how much gas, we need to make sure that we have enough supply sources. We need to know how many firm sales customers we will have. So if they are following the guidelines in the tariffs and those deadlines that are laid out, that gives us the information we need to properly model our forecasts for the integrated resource plan.
And how often do you file your integrated resource plan?
We file it early June every year.
Okay. So that requires the knowledge from the prior July determination of whether you're going to be a transportation customer to be included in your June IRP filing?
It's more current than that. So we need to know, in the tariff, it talks about how they need to notify the company by, let's say it's February, there's a date in February that they need to notify us, and then they have to have certain agreements in place. There are other deadlines that happen before they become that TS customer or that transportation customer in July. So as we are getting their information between February and March, April, that gives us the information that we need to plan for the IRP year, which runs from June of one year to May to the next.
Are there any adjustments to the IRP during its 12-month life till the next filing?
No,
It's fixed?
it is.
All right, at page 25 of your rebuttal testimony, and we're almost getting to the end here. Lines 570 through 577, you respond to Mr. Oliver's proposal regarding purchase of receivable program.
Correct.
See that reference?
I do.
Okay. And you state that the company has had experience with other programs that involve billing of service for other entities, and it, quote, has no appetite for doing it again, close quote. You see that?
I do.
Can you give me some background or reference as to what those experiences are that you're referring to here involved?
Yes, there was a home warranty program that the company has billed for in the past and is getting ready to step away from that. And I don't know if I don't want to, again, put words into everybody here's mouth, but I know it wasn't something that everybody agreed on. Just say that.
Okay. Any other examples?
No, that's the only company that the company has, that Enbridge prior Dominion has billed for.
And are you aware that utilities in other parts of the country do offer such purchase of receivables programs for transportation service customers and do so without major problems?
Wouldn't be surprised if they did, but I think, again, it depends on what what is happening in those other states. If they have, I mean, we have an affiliate in Ohio that doesn't have, they don't have a gas supply team in the way that we do. They have customer choice, where customers have to find a supplier. Even residential and firm sales customers have to find another supplier. So in a case like that, a purchase of receivables program might be a different, might have different merit. In ours, I think that it's a company, it's that marketer's responsibility to deal with problems that they have with their customers.
Okay, but would you agree with me that the home warranty program that you mentioned a moment ago is significantly different than a purchase of receivables program that might involve transportation gas service or some other type of function that you could use that program for?
I think it's a different program, but with that said, I would still stick with what I said before, that I think it's the marketers, part of the marketers operating their business to manage their customers in that process.
So, Mr. Summers, you may need to check on this, but am I correct that in your initial rate design proposal for the TSS rate schedule, that increased the volumetric charges for TSS customers by a uniform 0.47516 cents per decatherm? Does that sound familiar?
I would have to check. Again, I could go to Exhibit 5.10 in my direct testimony, maybe to verify that that's what the original proposal was. I don't know if that's something you want me to.
Well, does that sound vaguely familiar, at least, subject to check?
I would have to check.
Okay. So let me just ask another couple questions here, and then if you need to go look, we can do that. Would you agree that the current Block 3 charge for rate schedule TSS is 0.19707 cents per
Again,
decatherm?
subject to check.
Okay. And your initial proposed Block 3 charge for rate schedule TSS was 0.67223 cents per decatherm.
Yes, and I will also say that a lot has changed since the company's original proposal, and in the company's SIR rebuttal, in my SIR rebuttal, we agreed with Mr. Oliver's, that would have been his rebuttal testimony, where we agreed that those, the changes in those block breaks should follow a different percentage increase.
And prior to changing the percentages in the block rates that you mentioned, you agree with Mr. Oliver on, would you accept that the company's initial proposed Block 3 charge for rate schedule TSS represented a 241% increase in that charge?
Yes, and that's why we changed that in the SIR rebuttal.
Okay, thank you. Mr. Summers, has the company provided any quantitative analysis to support the assessment of the full costs of the product you believe EGU's transportation service customers are purchasing?
Can I get you to restate, just to re-ask that question?
Sure.
You have it read back if you'd like, or you can restate it.
I can happy to restate it, Mr. Chairman. Okay. Has the company provided any quantitative analysis supporting the assessment of what I'll refer to as, quote, full costs, close quote, of the product you believe the company's transportation service customers are purchasing?
Yes, the entire cost of service study, all of those studies that we've done, whether it's the 60/40 allocator or the throughput allocator, customer assistance expense allocator, all of those combined provide a very quantitative analysis showing that the rates charged to all of the customer classes are reasonable and justified.
And would you agree with me that the primary service transportation service customers purchase from the company is the delivery of third-party gas to their facilities within the company's service territory?
Yes, yes, and that's why in the tariff, those customers are, the primary rate that is on their tariff sheets is the distribution non-gas cost.
And would you also agree with me that the commission doesn't regulate the cost of acquiring gas by third-party transportation customers, but they regulate the distribution service that you provide?
Yes.
If the commission doesn't regulate the prices for the gas that the transportation service customers pay, do you believe that the full cost of the product purchase, including commodity costs, is relevant to the commission's determination of rates for transportation customers?
I think it's important for them to consider what their gas costs are. And the reason I would say that is because when you're looking at a typical sales customer, you're looking at, typically when we show a typical bill calculation, like we've shown in the company's exhibits, that includes their commodity, so that the commission can see what the total cost to that customer for total gas usage would be. So I think it'd be, in times when you're comparing maybe a transportation customer to a sales customer, I think it might be good to include the cost of the commodity, an estimate for that cost.
So is it the company's position that transportation service customers that purchase gas supplies at lower cost per decatherm than firm sales customers, assuming that that's the case, justifies charging transportation service customers more for the delivery services they receive from the company?
No, that's absolutely not how it should be. The company doesn't consider where a customer gets its commodity supplies. We're just doing cost of service studies that look at the total cost of the distribution system, and it allocates those costs to the various classes without regard to where the gas is coming from.
Okay. Thank you, Mr. Summers. Mr. Chairman, those are all my questions.
Okay, thank you, Mr. Davidson. We'll turn to Major Newton. Do you have any cross?
Briefly, Commissioner. And that's not just for the sake of your neck, Mr. Summers. Would it be accurate to say that the company uses design day demand of its customers to design the capacity of the distribution main system?
Yes.
And does that design day capacity include the capacity or commodity volumes contained in the throughput factor?
I think you're looking at two different things, and I'm going to use just a little scenario since we're so close to Thanksgiving that might help maybe explain this a little bit. But my family, we eat turkey sandwiches all through the year, and so on our grocery list there's always deli meat. We're buying turkey all throughout the year, and that's kind of our average turkey throughput. But when I was, I know, that's a good one. But preparing for next week, we are buying a lot more turkey for Thanksgiving, and so that is our peak day turkey that we have to get. Now my kids are still going to eat turkey sandwiches next week, and so it's hard to say that that the two are separate, but we still need to be buying average turkey, but we need to buy peak day turkey as well. So I think that they're two different things that we're looking at.
And Mr. Summers, I went to public school, so I really appreciate that scenario. So if I'm understanding you correctly, your system is being built for the amount of processed bird as well as full bird that you're going to use throughout the year.
That's correct.
Thank you. That's all my questions.
Okay, I'm going to have that printed out so that I have that part of the transcript I can refer to in the future.
You can frame that on your wall.
Both your comment and Major Newton's. Okay, let's turn to Ms. Mitchell, see if she has any redirect.
Just one set of questions, Chairman, thank you. Mr. Summers, do you recall that Mr. Davidson was asking you about the administrative charge to transportation customers?
Yes.
And one of the topics of conversation was about increases in the costs experienced that led to an increase. Increases in costs experienced by the company that led to an increase in costs in that administrative charge, rather.
Yes.
And you mentioned, as an example, labor costs had increased because of the EGU separation of from Mountain West Pipeline, as far as having shared a particular group of employees, and that feature was no longer a shared element, and so EGU is bearing the full costs.
That's correct.
And did the company also experience an increase due to no longer sharing any software costs?
Yes.
And what was that software platform and the change that led to an increase in costs?
Well, I hope I remember the name of the software. I'm going to look at Exhibit. Oh, sir, there's a lot of things going on this desk right now. The software is used for the nomination process. If I can get there. That is called Quorum software. I'm looking at EGU Exhibit 5.09, and that is row 17.
And the costs of that Quorum software were originally a shared cost? Is that correct?
That's correct.
And they are now, the costs of that Quorum software are now fully borne by EGU?
That's correct.
Okay. I have nothing further. Thank you.
Okay, does those questions generate any recross?
I have a very narrow area of recross I'd like to explore.
You may do so, Mr. Snar. Thank you.
Mr. Summers, in your rebuttal testimony at page 5 and following over to page 6, you have some charts that you've presented that demonstrate the Phase 1 settlement amount, and you've worked through your modeling to demonstrate the impact of, as I see it, embracing your historic allocation of 60-40 versus some of the other parties' proposals. Is that right?
That is right.
Now, you've answered some questions that Mr. Davidson propounded to you, suggesting that from your rebuttal testimony to your surrebuttal testimony, there'd been some tweaking or refining of your model and certain results.
That's correct.
My question is, do those refinements affect the accuracy or validity of these charts that I've identified on page 5 and 6?
The answer to that would be no. There is no effect to these tables. These are cost of service results, and the mathematical error was in the rate design side of of all of the calculations.
Thank you.
Thank you, Mr. Snar. All right, let's turn to the commission. Commissioner Clark.
I don't have any questions, thank you.
Okay, dare I ask? Commissioner Harvey, do you have any questions?
I do.
Okay, we remember we're coming up on a lunch break and just,
What time do you want?
no, we'll finish, Mr. Summers. Go ahead. Just teasing you.
All right. You mentioned that you, in I think your direct testimony, had talked about the natural gas vehicle program, but you then mentioned that a different witness, I believe you said Stevenson,
Yes.
had talked about it later in the case. Which witness should I address NGV questions to?
Oh, that's a fun question. I could pitch, I suppose. But I think if it's something that is a cost allocation question on how, or maybe how the subsidy is allocated, I can address those. If it's related to the NGV program and the NGV stations, that might be better for Mr. Stevenson. But if you want me to take a crack at them, I'd be happy to try, and if I can't answer them.
Well, it's, one line of questioning is about the stations, and I can certainly defer that. The other, yeah, well, I'll give you a crack at this one. Other parties' testimony talked about that if what they termed the full cost, I believe this was DPU's testimony, was allocated to that class, that the gallon of gas equivalent price, whatever that saying is, would be about $3.10. Do you remember that testimony?
I do.
Do you think it's reasonable for an NGV customer to pay something that's close to the current gasoline price?
I think ultimately we want the class to be successful. We want to encourage people to use that. In the past, we have had that, just historically, that rate has been lower than the price of gasoline. I think that is something that has encouraged people to use that class, or use that product. Whether or not it's appropriate for that price to be equal, I don't know that I have. I do think that it would threaten the success of the class if it was close to gasoline.
I hate to say it, but your answer has prompted more questions.
Okay.
You intimated you'd like that class to be successful. My line of questioning about is whether that's possible. The same testimony that supplied that $3.10 figure also talked about the total registrations of automobiles capable of using natural gas. Do you recall that?
Yes.
And that is on a pretty significant downward trend from what it had been?
It is, and that was in my direct testimony, shows that downward trend too.
Are you aware of any major automobile manufacturers that are producing a natural gas model currently in North America?
Not for consumer cars, for just consumer vehicles, but in the transportation sector, I believe there are some advancements toward using natural gas more and more. In fact, if you look at, I know the garbage truck that comes around to my house is a natural gas truck, and a lot of UPS trucks are also natural gas as well. So the engines that they're using would use natural gas. But the consumer vehicles, I'm not aware of any OEM natural gas options.
And in the past, the company, under whatever name it was at the time, has tried to pursue fleet contracts with those larger vehicle users.
On that, I might defer to Mr. Stevenson.
Okay.
I think he might know more on that.
All right. I think the rest of my questions on NGV I'll direct to him.
Okay.
All right. Couple of questions that are somewhat related to the idea of peak versus throughput and allocation, those type of things. I'd like you to think for a minute about the many and various types of equipment that make up the Enbridge system in Utah. And can you identify in just very general terms what types of equipment wear out because of some type of stress or strain that would happen during a peak day?
I would say that our equipment is designed to handle what I'm going to refer to as a design day.
Okay.
And the
Sure,
only reason I'm
yeah.
making that distinction is that we've had peak day
Yes.
arguments in prior cases. So our system is designed to handle those design days. I don't know if there's anything that would wear out as a result of having that design day. I mean, the equipment is made to handle those extremes.
So would you say for the, say, vast majority, maybe 95% of the equipment on the system, that it wears out because of actual use or just simply time rather than a peak day?
I would say it's,
Or a design day?
yeah. When we're looking at, that might be a good question to ask an engineer sometime on what does cause a system to wear out. I know that there are circumstances where time is an issue, where, you know, the longer something is in the ground, the sooner it's going to need to be replaced. So time is certainly an issue, but you've also got gas flowing through it, and it's being used during that amount of time. So it's, I guess I don't really have a great answer for you on that. It's a combination of time and of use.
And just to clarify, when you say use, are you talking throughput use?
I would say for average throughput use and design day use, it's going to be used for both of those.
Well, I guess what I'm asking is a therm a unit of gas going through a given part of the system? Does it matter if it's going through at the middle of the summer, or does it matter if it's going through on the design day?
I don't think it matters.
Okay, thanks. All right, one of the items that was talked about in the cross was the possibility of closing the transportation class to new customers.
That's correct. This is the TBF class.
Just the
TBF
bypass
class.
firm. Just the bypass firm. Any thoughts on how an action like that relates to an utility's obligation to serve?
Yeah, I think that those customers, if there was a bypass, a customer that was a bypass risk that came to us in between now and whenever that moratorium ended, we would have to tell them that the rates that are available to them are the other transportation classes. They could join the TSL class, or if it was something that warranted it, we could explore the option of doing a special contract with that customer, similar to what we've done with the Lakeside Power Plant.
So you're testimony is you would still view it that the utility themselves could still serve that customer, just possibly not in the exact way they wanted.
Yeah, I think we could absolutely serve that customer. And the rates that are available to them are still tariff rates. And assuming that the TBF class, if we do look at that between now and the next rate case and find a way to make sure that that class is still protecting other customers, then if that customer qualifies for the TBF class, then they would be able to join that after the moratorium ended.
Okay, thank you. All right, I'd like to talk for just a minute about the GS class and the basic service fee. Remember that line of questioning from Cross?
I do.
assume? I'd like to talk about the interactions between the basic service fee, the CET, and the 191 pass-through. So when I'm looking at the GS class, I think there's a revenue requirement amount that's assigned to that class. And whether the revenue requirement amount is assigned to that class as part of a basic service fee or something that's going to be guaranteed recovery through the CET or guaranteed recovery through the 191, Enbridge is still going to recover that revenue. Is that correct?
Yeah, let me speak to it a little bit, because when we're in a general rate case, I don't know if you have a copy of the tariff in front of you, but I have a binder full of it.
I'll take your word for it.
But there are, in the GS class, the rates that we're looking at in a general rate case is just the base DNG. So it's the top line of a tariff is the base DNG, or distribution non-gas. So that is the amount that we are setting rates for today. The basic service fee is included in non-gas in those distribution costs. But the way that we do it is we look at all of the revenue we're going to collect through the basic service fee and look at the revenue requirement, the overall revenue requirement. Anything that's not collected in the basic service fee is going to be collected in that base DNG volumetric rate. The commodity has no, or the 191 account has no play. It's not used at all in these distribution rates. That's just for the commodity. The place that the CET fits in is we are going to charge these base DNG rates, and we're going to collect revenue from our customers based on those DNG rates, and that will be our booked revenue. Then we compare that booked revenue amount to our CET revenue amount, the allowed amount, and we're going to see how close those two numbers are. And if we need to give money back to customers, as has been the case for the last couple of years, then we'll do that through an amortization rate. Or if we need to collect a little bit more due to the CET, we would do that through an amortization rate as well. So it's more of the CET is more of an accounting mechanism after rates are set.
But the CET ensures that you collect the required revenue.
Right, that's correct.
So regardless of what level the basic service fee is set, Enbridge would collect what has been assigned to that class.
Yes.
After the true-up is done.
That's correct. So even if the basic service fees, and there are jurisdictions that have higher basic service fees, even in our Wyoming jurisdiction, the basic service fee is a little bit higher. And that just means that the volumetric rate will be collecting less.
So if a commission had an objective of trying to encourage conservation, having a low basic service fee and a relatively higher volumetric rate would accomplish that.
Yes.
And then, do you know off the top of your head how much we currently spend on the energy efficiency programs?
Well, they just filed their new budget, and I read it. I would have to check, Commissioner Harvey. There's a number in my head that I want to say.
Is it in excess of 20 million?
Yes.
Okay.
Yes.
So currently ratepayers are paying approximately $20 million plus to encourage conservation
Yes.
through those other programs?
Yes.
Okay, thank you. Through those other programs, sorry. One of the items that occurred during cross was the low-pressure surcharge. Do you remember that?
Yes.
Regardless of whether you think it's a good idea or a bad idea, is that something Enbridge could do?
So I will say that it's not something that we could do with short notice. Like if the order is a December 27th deadline, and then the rates are going to be effective on January 1st, we would need to know about it well in advance so that the billing department can build that rate into the system, test it, make sure that we're assigning the right customers to it. And it couldn't, well, I don't even know if we could do it if we started today, if I'm being honest. That's, you know, as in my summary, I was talking about how some of the rate design things are issues are easier to bring up than they are to implement. So we've had the TS customers, you know, that happened in, it was brought up in one rate case. We studied it during the off season, if that's the right word, and then and then filed it in the next case. And I think that low pressure surcharge would require that same level of analysis to make sure that it's done right.
All right, thank you for that. This did not come up in cross, but the change to the 10 years of weather data, is that proposal restricted in terms of where the company would use that shorter period, or would that go across all the different types of forecasting the company's doing?
I'm going to definitely pitch that one to Dave Landward. He'll
Okay.
be the witness on that.
And then in the testimony, but not in the cross, the idea that the previous rate case, there was in the order said to go from a 50% discount to a 40% discount, I believe for the bypass?
Yes.
Okay,
You've got it.
But then the DPU witness alleged that had not happened. And I was unclear from reading the testimony. There was certainly a lot of discussion about why a discount was relevant, but I was unsure from reading the testimony whether that, if EGU was agreeing that hadn't happened, or whether they said it did happen.
It did definitely happen, and I'll testify to that. I did not address that clearly enough in my rebuttal. Ms. Higgins did have some rebuttal testimony that addressed that, but it's on there's a tab in the model called COS input, and there's a cell that references how much that discount is, and that's used to calculate the discount, and it's 40%.
Okay, thanks.
As it was filed.
And I think I understand this from the cross, but I want to clarify. For the nomination penalties, do those go to the customer or to the nominator?
And that's a good question, because in the section that Mr. Davidson asked me to read. It actually talks about how it eventually needs to end up at the customer level for those penalties, but the marketer is the one who I guess determines how that is allocated to their customers.
So EGU assesses the penalty to the marketer, and that's who they're collecting it from?
You know, I'm gonna have to go with, I don't know
Okay,
on that one.
all right. And I think my last question, you mentioned in the cross that there was an agreement, that EGU agreed with the witness Oliver about certain costs. Do you remember that bit across?
The part we agreed with was how much increase should be in each of the blocks in the rate design process. The original proposal had kind of an unequal weighting into each of those blocks, and so the way that we proposed it and what's included in my rebuttal model is more of an equal increase to each of those blocks.
And so my question is, as a result of that change, was there any change to the total amount of cost assigned to that class?
No, no change.
That's all the questions I have. Thank you.
Just a couple of issues to clarify for my benefit, Mr. Summers. On page 14 of your rebuttal testimony, where it's discussing the potential splitting of the GS class, you, on lines 273 to 275, you stated that Mr. Pernicoli, I hope I pronounced his name right, I was close, correctly pointed out that there are constraints relating to the billing system that would make any change to the GS class in this case impossible. Would you explain that you adopt that, you believe that, you've set that forth, you believe that's true?
I do believe that's true.
And why is that?
Yeah, and this is something in our weekly meetings with the division, we actually had the billing department come in to explain this, because there's people like me, again, public education maybe is the issue, I don't know, but in my mind, it would have been something as simple as you know, if the customer is this large, then they go to this class of customers. But the billing department personnel explained to all of us that it's not an if-then statement in the system, that you've kind of got to monitor. You've got to come up with ways to monitor every month, every billing cycle, who has changed from one class to another. If somebody, you know, one of the proposals was on the basic service fee, and so you're constantly monitoring to see if somebody changed they increased their meter size because maybe they got a pool that they're heating, so that increased their meter size. You'd have to look at that every month, and not just, there's not a lot of people maybe that fall into that, but you still have to check 1 million customers every month, every billing cycle, and make sure that there aren't any changes. Those are the kind of limitations that are in the billing system, that the billing system would have. Now, there's ways to write new code to implement those systems, but it takes a lot of effort to make those changes. And I think Mr. Pernicoli's testimony even pointed out that some of the billing department is working on changing our billing system over to work with Enbridge accounting, and there's a lot of things going on right there. So those are some of the limitations that we have right now.
Okay, so as I surmise from that, your essential position is it's too complex to do in a short term and to implement it in this case.
Right.
While you don't believe that the GS class should be split, you acknowledge that that is an issue that could be explored in a working group.
Absolutely.
And you've stated that in the, in pages, let's see, on pages 27 through 28 of your testimony. I just want to explore if, on a couple of these issues, if or a working group is a feasible way to evaluate further some of these issues that have arisen in this case. So you've already indicated that you'd be willing to explore a split in the GS class, and a working group could be put together for that. On line 628 through 630, you say, Mr. Pernicoli and Mr. Daniel both proposed that the company should explore the TBF class and other large use customers to make sure customers are not being negatively affected by the use of their system. So you've indicated then on the same page, line 638 through 69, for example, the company would be willing to explore ways to protect customers and give large customers a fair rate. In exploring the TBF class and other large use customers, make sure they're not negatively affected. Is that something that you think could be done in a working group?
Yes,
Okay, and you would support that?
I would.
Okay. With respect to the conservation enabling tariff, you've indicated that you believe that's been fully discussed in past cases and see no need for it to be subject to a working group. If in fact the commission were to consider seriously the Office of Consumer Services position to discontinue the CET, or the DPU's position to continue it but implement additional guardrails, that would be something that could be kicked down the road to be considered in a working group, could it not?
It could. I think that there, and actually I think there was progress made in this case on the conservation enabling tariff. I think that, and Mr. Mendenhall will probably address this a little bit more, but I think that with the proposal, the division witness Mr. Daigle put out, and then the rebuttal of, well, there's a lot of witnesses in this case, aren't there? The OCS, Mr. Daniel, I think that we're in a good place now to go forward with the conservation enabling tariff. But if it's something that the commission still thinks that there's more information required, then sure, let's work on
And remind me, did the company indicate that they were amenable to the guardrails that were suggested by Mr. Daigle?
I'm gonna let Mr. Mendenhall address that if that's
fine.
If that's okay. I think
yeah,
he's
that's
more prepared on that.
Perfectly fine. All right. So other than those that I've described, are there any other issues in this case, given their complexity or the divergence of viewpoints of the parties that you think could be deferred until the next rate case, and in the meantime have a working group established to consider?
The only one, and it's kind of come up here a little bit today, is that low pressure surcharge. I don't think I spelled that out in my rebuttal testimony.
It's not in there.
But in the conversation with with the ANGC this morning and with Commissioner Harvey, that might be something that also could be addressed in a working group. And then what we've done in the past, and I think it worked out well, is the parties will meet, talk about all of these issues, and there still may be disagreement in how to do something, but the company will propose what it wants in the next rate case, but it will also include the positions of the other parties, so that when we start the rate case, the division already has its proposal included in our model. The ANGC, if they wanted, or Nucor, whoever wants us to include a low pressure surcharge, even if we don't agree with it, we would include that as an option in our modeling. And it seems to have worked out. pretty well in the past.
Okay, thank you. So a low-pressure surcharge could be subject to a working group.
Sure.
With respect to NGV class, you've suggested on page 28 of your testimony that the company continues to evaluate solutions and doesn't see value in assembling a working group before it has exhausted these efforts. I assume one of those efforts is the RFP to sell your stations where NGV class vehicles would be serviced. Is that correct?
Yeah, we're continuing to look at different options, and the sale, outright sale was, turned out to be a kind of complex issue. And so we're exploring other options right now, but we continue to look at those, and we would certainly let the commission and other regulating parties know when we have an updated plan. And I think that could even be outside of a rate case.
Okay, but Mr. Stevenson is the person I would probably want to get into the details of questions on the NGV program. Is
Yes,
that correct?
I'm sure he's getting jealous of all the time I'm getting to spend up here. And he
Well,
might wanna-
then, well, if we don't want to increase his jealousy, so I'm done. And if there's nothing else, we'll dismiss you, Mr. Summers. Thank you very much for your long suffering to work through what would have
Happy to.
been a normal break time. Well, I propose that we take a break. It's probably inhumane to not have allowed a break before now, but what I would like to do, if possible, is have Ms. Mitchell put on Mr. Mendenhall for, to introduce his testimony, and we'll see how long his summary takes. We might then break right after his summary and come back for cross after lunch. Would that be okay?
That's fine, Chairman. And Ms. Clark will be introducing
Oh,
Mr. Mendenhall.
Okay, that's great. Yeah, I was just looking to you because you're sitting in that seat. Okay, that would be great. But let's take a break till 1:45, if we can have a short break, and then we'll come back and go for a half hour or so, or how long it takes with Mr. Mendenhall, and then we'll break for lunch. We'll go back on the record. Thank you. Ms. Clark, you can call your next witness.
Thank you so much. The company calls Kelly B. Mendenhall.
Welcome, Mr. Mendenhall. Will you raise your right arm to the square? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You may be seated. Thank you.
Mr. Mendenhall, would you please state your full name and business address for the record?
My name is Kelly B. Mendenhall, and my business address is 333 South State Street, Salt Lake City, Utah.
And what position do you hold with the company?
I'm the Vice President of Regulatory for Enbridge Gas Distribution Services.
And Mr. Mendenhall, are you the same Kelly B. Mendenhall who submitted direct testimony in this matter as well as rebuttal testimony in this matter?
I am.
And was the application and accompanying attachments, were those all prepared either by you or under your direction?
They were.
Do you have any corrections to any of those documents?
Yes, in my rebuttal testimony on page 17. Give everybody a moment to turn there. Actually, correction, line 17. So my rebuttal testimony, line 17, I refer to Mr. Fields as Mr. Matthew Fields. His name's Mr. David Fields, so my apologies to Mr. Fields. I think I used his middle name instead of his first name.
And with that correction, do you adopt the contents of your pre-filed direct and rebuttal testimony as well as the contents of the application and its attachments as your testimony today?
I do.
The company moves for the admission of the application and accompanying appendix, the direct testimony of Kelly B. Mendenhall, labeled EGU Exhibit 1.0 with accompanying exhibits 1.01 through 1.07, the rebuttal testimony of Mr. Mendenhall, which is labeled EGU Exhibit 1.0R with accompanying exhibits 1.08 and 1.09R.
Okay, is there any objection to the admission of those items that have just been read off? Seeing none, we'll admit the application, direct and rebuttal testimony, the appendix, and the exhibits that you referred to in both the direct and rebuttal into evidence. Thank you.
Thank you. Mr. Mendenhall, would you please summarize your testimony and the company's positions on the matters you address?
Certainly. In my testimony, I addressed one Phase 2 issue, and that's the issue of the conservation enabling tariff. And specifically, I addressed the question of whether the CET has removed the disincentive for the company to pursue energy efficiency programs. And on page 21 of my testimony, I provided evidence that over the life of the energy efficiency programs or the life of the CET, the company's paid out 1.4 million rebates to customers, which resulted in about 284 million decatherms of lifetime savings. Additionally, I talk about the benefit, I guess, unintended, but the benefit of revenue stability, both for the customer and the company. The CET has allowed the company to collect the allowed amount of revenue, and the net benefit of this has actually been in the customer's favor. We've returned customers, to customers, $45 million of over-collected revenue during the life of the CET. So there were three witnesses that addressed the CET in their testimony. The first one's Mr. Daigle, and he made three proposals. The first was to require filing when a balance exceeds plus or minus 10 million. In my testimony, I stated that the tariff already allows flexibility for the company to file multiple times a year if they want, and so we don't believe that this change is necessary. It could also be administratively burdensome if we're required to file multiple filings just because we've hit this threshold. The second proposal was to increase the cap 2.5%. Well, the current cap is based on a 2.5% of applied to the under collection. Mr. Daigle's proposing to increase that cap to 5% on both the under collection and over collection. And I didn't address this in testimony, but the company agrees with this proposal. I actually think it's a more fair calculation than what we've had in the past, but I didn't address it, but I just want to put on the record that we have no issue with that proposal. And then the third proposal was to, anytime there was an excess of 5% in the account, the CET balancing account, to transfer that to the 191 commodity balancing account. In my testimony, I explained that actually the CET account is also a 191 balancing account. So moving it from the CET 191 account to the commodity 191 account really doesn't provide any benefit. In fact, if anything, it reduces in less transparency because now you're mixing CET revenues with commodity revenues. So we would propose that recommendation be denied. And then Mr. Daigle also addresses the transportation and balance charge. Well, that's not a rate that's being addressed in this case, this base rate case. I do in testimony point out that from our standpoint, if you go back to 2014, the charge was really created to help our gas supply group to manage transportation and customer imbalances. Since that time, we've added some additional tools for those gas supply folks. They also now have the ability to issue hold burn to scheduled quantities and put customers on restriction. So because they have more tools in their toolkit, as we've talked to them about, do we need to make changes to the TIC, they seem to be pretty satisfied with the tools they have now. So for that purpose, we don't believe that a working group will be necessary on that issue. The next witness that discussed the CET was Mr. Daniel. And he originally proposed that the CET be discontinued based on his analysis that it didn't seem like energy efficiency programs were providing a benefit to customers anymore. In my rebuttal testimony, I provided some evidence showing that we did a quick analysis of 1,800 customers that received rebates in 2023 and showed that they actually were reducing usage as a result of those measures that were implemented. And additionally, I talked about the idea of, and we've done this in the past, of creating having a third-party evaluator come and do an assessment on all of our rebate programs to see actually how cost-effective they are and whether they are actually helping customers to save money and reduce their usage. So I mentioned that we plan to propose that in our budget, our energy efficiency budget. And in docket 25-057-22, if you look at that budget, there is a component of that for that third-party assessment. So after reviewing both my testimony, Mr. Daigle's testimony, Mr. Daniel seems to be content with the conservation enabling tariff going forward, so long as Mr. Daigle's recommendations are approved. And he looks forward to reviewing the results of the third-party evaluation. Mr. Fields had a very similar testimony to Mr. Daniel that more comprehensive assessment needed to be created. And so I think I've hopefully addressed that as well in my testimony. So I guess to summarize, the company's position would be to request the commission to approve the conservation enabling tariff going forward, with the one recommendation from Mr. Daigle that the caps be adjusted. And that concludes my summary. I'm happy to answer any questions you might have.
Mr. Mendenhall is now available for cross-examination and also questions from the commission.
Okay, thank you. We'll get an estimate of cross to the extent people have it to decide how long we're going. Let's turn first of all to Ms. Schmidt.
The division has no cross for Mr. Mendenhall.
Okay, Mr. Snar.
OCS has no cross.
Okay, Mr. Russell, do you have an estimate of how long you have on cross?
It'll be real brief. Regrettably, I have no cross for Mr. Mendenhall.
Oh, well,
I'm on a roll here.
I just assumed there would be cross-examination comparing you to Mr. Harvey, and I'm sorry, it was. uncalled for, I think, but, okay. All right, wait a second here. I've got to make sure I've got everybody. So, this is Mr. Cook.
Yeah, Nucor has no cross.
All right, Mr. Davidson, Cross.
No questions for Mr. Mendenhall.
Oh,
Thank you.
boy. Okay, Major Nelson, down to you.
FEA also has no questions.
That's great. Okay, we'll turn then to the commission. There's no need for redirect, so across.
I have no questions.
Remember that you're keeping about 75 hungry people from lunch. Okay, all right. Commissioner Harvey, do you have any questions?
Given that the parties seem to be in agreement and that it may be a thing where they talk about with the working group, I'll wait until another proceeding for my questions.
Okay, all right, so, Mr. Mendenhall, I don't have any questions of you, but before I let you sit down, I just want to bring this issue up for all of council and for all the parties here. There are a number of items, you've referred to some, where it appears that you've reached agreement with some or all of the parties. I think it would be, and there are others that will come up, I think it would be very helpful to the commission, and I'm happy to talk to you about the timing on this, for you to, as council, give us essentially a matrix of issues that are in phase 2 that are now agreed upon. That'll help us in drafting the order. So just the issues that have been raised in phase 2 of the case, there are some sub-issues, I would call them, or some major issues even, where there's an agreement been reached, either among everybody or among for example, the division in the office will have reached agreement with you on some issues. So I guess the question is, and there may be others that come up in the course of this hearing, I'd like to get some idea of when you think you could provide us that list.
If we could have the lunch hour, we can give you an estimate. I would suggest that the company take a first crack and circulate it.
Okay.
But I'd like to confer with my clients to see how long that first crack might take.
Yeah, I think that's great. We'll talk about it after lunch for just a moment to see what your estimate is, and then obviously for us, the sooner the better would be to know what issues we are narrowing in this case. And it may be in the course of today and tomorrow, there may be others that the parties do come to an agreement upon. Okay, so I have no other questions, Mr. Mendenhall. We'll excuse you. Thank you for being here, and good luck in your new position in Toronto.
Thank you.
All right. It's Mr. Stevenson next. Let's go ahead and do his summary, and we'll see what we get on cross-examination.
Okay.
All right. Is that back to you, Ms. Mitchell, or you?
Yes, it is. Thank you,
Okay.
Chairman.
Okay.
The company calls Jordan Stevenson.
Okay. Welcome, Mr. Stevenson. Would you raise your right arm to the square? Solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please be seated.
Mr. Stevenson, would you please state your full name and business address for the record?
Yes, it's Jordan Stevenson at 333 South State, Salt Lake City, Utah.
What position do you hold with the company?
A manager of regulation.
Did you file direct testimony in this matter marked as EGU Exhibit 4.0 with accompanying exhibits 4.01 through 4.33 and rebuttal testimony marked as EGU Exhibit 4.0R?
Yes, I did.
Do you adopt the contents of those documents as your testimony on Phase 2 issues today?
Yes.
Your Honors, Mr. Stevenson's direct testimony as it related to Phase 1 issues was admitted into evidence at the hearing on October 22nd, 2025. For today's purposes, the company moves for admission of that direct testimony and accompanying exhibits on Phase 2 issues only, and also Mr. Stevenson's rebuttal testimony.
And the rebuttal testimony is limited to Phase 2 issues.
That's correct.
Okay. Any objections? Okay, seeing none, we'll admit Mr. Stevenson's direct testimony exhibits as it relates to Phase 2 and his rebuttal testimony.
Thank you, Mr. Chairman. Mr. Stevenson, will you please summarize your testimony in this matter regarding Phase 2?
Yes, I will. Chair and Commissioners, thank you for the opportunity to speak today. My testimony addresses concerns raised by several parties in this docket regarding the natural gas vehicle, or NGV, class cost of service and the associated subsidy proposed by the company in this case. The NGV subsidy is outlined in my rebuttal testimony and as filed in our direct application should remain in place for the 2026 test period. The subsidy is just, reasonable, and in the public interest. The NGV stations continue to provide clean, reliable fuel and help reduce emissions throughout the state. While electrification is advancing, as has been pointed out by parties in this docket, natural gas itself still plays a critical role for certain vehicle classes where electrification is costly or impractical. Utah's legislature recognized this role and codified it in Utah Code Section 54-4-13.4, which directs the Commission to find NGV infrastructure expenditures as just and reasonable when specific conditions are met. And I outlined these conditions in my testimony, but just to reiterate, our investments do meet each of those conditions. They were prudently incurred. They have never exceeded the $5 million annual spending cap specified in that statute. They are in service, and they continue to meet the revenue objectives, with NGV station users currently generating 70% of the class revenue requirement. My testimony also clarifies that the costs included in this case are for the construction and maintenance of the company's legacy. I refer to them as our legacy NGV stations. We are not proposing an expansion to or growth in the NGV class infrastructure or adding new stations, and we haven't included any additional capital expenditures through the forecasted test period through 2026. The last station was added in 2012, and all of our fleet of stations were built under strong policy and regulatory support at a time of growing demand. Past decisions should be judged based on what was known then, not on today's market shifts or volatility in usage. Finally, I did want to mention regarding the RFP mentioned in the direct testimony of Mr. Summers. The company did explore that option to sell the stations and ultimately decided against it due to hurdles that we identified at the time that Mr. Summers has mentioned previously. The company continues to evaluate options in operating the stations, but in the meantime, we remain committed to operating the stations for customers who rely on them and to supporting Utah's energy and transportation goals. In conclusion, the NGV subsidy is consistent with legislative guidance and remains in the public interest and should be approved as originally filed by the company. And this concludes my summary.
Mr. Stevenson is available for cross-examination and questions from the commission. Thank you.
Okay, thank you, Ms. Mitchell, and thank you, Mr. Stevenson, for your testimony. Let's see how far we get. I may end up calling a lunch break partway through this, but if it goes like Mr. Mendenhall, we may be able to get through this. But I'm not as optimistic on this one. All right, Ms. Schmidt, any questions?
No questions.
Okay, that's one down. Mr. Snar,
2 down, no questions.
okay. Mr. Russell?
No questions.
Oh, wow, this is just great. Okay, Mr. Cook?
No questions.
Mr. Davidson?
No questions, Mr. Chairman.
Major Nelson?
No questions, Commissioner.
Okay, let's turn to Commissioner Clark.
I have a question for you. Could you elaborate on your phrase, the significant hurdles that were encountered in attempting to or contemplating issuing an RFP for disposition of the stations?
Yeah, so the hurdles, there are several different kinds of hurdles, but, you know, as the operator of these stations for years, Enbridge has a certain reputation, and we were concerned about the impact to the market potentially of Enbridge signaling to the market that it would sell. So there were some market concerns and what may happen with the existing customers that rely on the stations. And we weren't quite sure how to address some of those hurdles. And then the others were that we have contracted relationships with property owners throughout the state, all over our service territory where these stations are located. Each of those contracts have their own terms associated with them and you know, what we're obligated to do as we explored that RFP. And I can't get into real specific details on those, just to say that each contract had its own terms, and to put this into a clean, tidy package to be able to release an RFP in a way we thought would be most effective was just challenging to work through, so.
Thank you.
Okay, Mr. Stevenson, I think I may just ask you a couple of questions, so I can do it fast, well, then we'll see what Mr. Harvey has. So my understanding from the division's testimonies, there are only about 2,200 compressed natural gas vehicles on the road now in Utah now. Do you agree with that?
So I would agree that there's 2,200 that I'd say are registered in the state of Utah. We know that our stations provide fuel to a lot of traffic that comes through the state that may not be captured in the 2,200. So I guess I would just maybe clarify, maybe it's not 2,200 on the road in Utah, but specifically registered within the state. So with that clarification, I would agree. I don't have any concerns about the 2,200.
Okay, all right, thank you. Do you know how many of those vehicles are owned by Enbridge as part of its fleet of vehicles?
Not off the top of my head.
Can you give me just a rough estimate? I mean, just more than 500, more than 1,000?
Probably less than 500.
Okay, let's just see if we can range it anymore. Less than 250? Do you have any idea?
I really don't. I would have to check, but I'd be happy to if we're gonna have a break. That's something I could track down.
Yeah,
That's something I
you can
could
let
track
us know
down.
that.
Yeah.
And then you've indicated that there've been efforts to, I don't know if you indicated this or if it came up in Mr. Summers' testimony, but I think you did say that there are certain fleet vehicles. You've worked, I assume, with other entities. For example, I think maybe UTA has some natural gas powered buses. Is that correct?
Yep, that's one example of several.
Can you give me other?
Sure. Yeah, we're kind of the backbone for fuel at the airport. So if you've ever parked and taken a shuttle, you've likely used our services. We know UPS, FedEx, Matheson Trucking, just to name a few. South Jordan School District has a pretty large program.
With their school buses, I'm assuming.
School buses, right. Yep, and that goes to the theme of the day for our stations, is that we're in a period of transition. I think a lot of the testimony in this case is focused on the transition on the electrification side and that switch over, but we're even seeing a transition in the types of vehicles using our stations. We had originally built this backbone out to serve kind of lightweight vehicles, and it has been iterated in this docket that those vehicles are going away or dwindling. In the meantime, we're seeing kind of a transition over to larger class vehicles and fleet vehicles, and we don't see and expect that to follow the same trend as the lightweight vehicles at this point, so.
Okay, with respect to the lightweight vehicles, the passenger automobile or truck, car or truck, for example, you haven't built a station. Demand is since 2012, so it's been 13 years. The amount of natural gas usage just declined by, my understanding is by about 75%. Is that accurate?
Yes.
Okay. If the commission were to adopt rates that are based upon full cost of service, what would be the result in the cost, equivalent cost for natural gas as compared to gasoline at the pump?
Yeah, thank you. It has been noted, I think, in the testimony of Ms. Orton in this case, $3.10. I did refresh that number just recently because we've had a few shifts in our rates since that time, and I come up with around $3.20, just over $3.20.
Okay. All right. Thank you. That's helpful. And you've indicated that you're still, that it was stated in Mr. Summers' testimony, I believe, that didn't see a need to have a working group because you were still exploring other options, at least until those options had been exhausted. Can you tell us what other options you're exploring? Is there any of that that's not sensitive commercial information that you can share?
Some of the specifics, there are specifics that would be privileged at this point, and we hope to see movement on some of those. But generally, at a high level, I've been involved with these discussions for years on the stations, and right now, I think everything's on the table. We don't have anything concrete to share at this point in time, but we've obviously have reviewed an RFP to package up and sell the stations. We've looked at partnering with large commercial fleets. We've even had a transportation service through the stations for a little bit of time that was kind of unique in an effort to bolster demand at the stations. So we're also exploring, the renewable fuel standard offers credits for renewable natural gas, which 100% of the fuel coming through our stations is now coming from renewable resources, renewable natural gas. And we're looking at ways to, there's programs that help monetize through there that we're evaluating. So all options are on the table. Some were a little farther along than others, but nothing necessarily concrete that I can share today.
Okay, well, even that's helpful. I appreciate that. So would you just give me your best estimate of how many of those 2,000 vehicles that are Utah-based, take your word that there are some who transit through Utah and use your stations. How many of those, give me an estimate, are not fleet vehicles used by the airport, UTA, by the school districts, or by Enbridge itself? How many vehicles do you think are currently on the road if there hasn't been new OEM natural gas systems for private customer trucks or passenger cars, how many vehicles would you say are on the road that are owned by, you know, the Joe down at the end of the street type of thing, private citizens?
Residential vehicles.
Yes, residential vehicles.
So just contextually, I know that Honda was the last manufacturer to take their vehicle off the line as a direct, and that was in 2014, I want to say, so it's been 11 years. I would be guessing, but I'm assuming the percentage of residential vehicles on the road driving today of the 2,200 is probably less than, I don't know, 30%, but I'm not supposed to guess on the stand, but if you're asking me my opinion, and I don't have any analysis or numbers to back that up,
No,
but just based on the age of vehicles that would have been an option, I'm guessing it's definitely a minority.
Yeah, there is a point where it's functional obsolescence, people want a new vehicle, that's a factor in driving consumer behavior, so that your best estimate, I understand that's all it is under 30% are owned by residential users. Okay, all right, thank you. That was a shake of your head, yes. You should answer
yes.
audibly.
For the
Okay,
transcript.
all right, I guess we'll see. Mr. Harvey, how many minutes do you think you'll need for questions? Although it sometimes could be construed as cross, couldn't it? All right, how many minutes do you think you need? Are you under 10 minutes, or do you think you're more than that?
Probably under 10.
All right, we're gonna try to finish you, Mr. Stevenson. We'll apologize for everybody. We're taking a late lunch, but let's let Mr. Harvey finish. Mr. Harvey.
Good afternoon. But I will try to be quick. Do you have any idea how much rate base is left that hasn't been depreciated for these assets?
I believe Mr. Summers has an exhibit that shows the cost of service summary by class, and I want to say we're around $18 million of gross investment. The net depreciated amount, let me see if I can find that reference real quick, and we can tell you. Gotta get out the big binder. Let's see.
For convenience, I'd offer that 5.07 may be the exhibit you're looking for.
507, thank you. I was close, I was at 510. Okay, so looking at exhibit 5.07, if you turn there, you'll see the rate base shows up midway down on that exhibit. The gross investment's 19.8 million, and the net plant is 19.2. I will say, this gets into a little bit of the nuance of our modeling. We do an allocation of depreciation expense rather than kind of a direct assignment by class. So I think the way it works is each class receives an allocation of accumulated depreciation based on that class's share of gross plant in service. So I think that's the allocated amount. The actual depreciation, I think, is higher than what we're seeing here.
I would hope. That's not much depreciation in 15 years. All right. So when we're talking about the subsidy to this class, I'm assuming, and tell me if I'm right here, we've got whatever is assigned for depreciation costs, whatever operations and maintenance expenses are incurred, whatever the commodity cost is, minus whatever revenue is generated. Is that the basic accounting for this class?
Sorry, will you repeat one more time? I was catching up with you. So the way the subsidy is calculated?
Well, just what it's covering. So there's some amount of depreciation,
Oh, yeah.
hopefully more than that chart is implying.
Right.
And then you've got operation and maintenance costs, to actually run the stations, take care of them,
Yep.
make any repairs. And then you've got the commodity cost.
Yeah.
You're
so-
not getting the gas for free.
Right.
If you are,
And in
that's
this
great.
case, I didn't mean to interrupt you.
No, and then minus that, the revenue.
Right. So in this case, the subsidy is calculated to cover the distribution non-gas portion of costs. So what it includes is all the operating and maintenance expense associated with the class, the rate base piece, net of depreciation. I'm missing other expenses such as depreciation expense, which is also allocated, so that's lower. O&M or other taxes, things like that. So all of those distribution non-gas costs are tallied up, and then the subsidy covers the difference between what it'll take to recover all of those versus what we think the class will generate on its own.
And so when you say that the revenue is covering 70%, I believe that's the number you said earlier,
Correct.
that's 70% of that total amount.
Yes.
Okay, that's great. Just trying to see if I can drop some of these. So there are a number of private, non-utility owned, both compressed natural gas and renewable natural gas stations in the state, correct?
Correct.
How does the price that Enbridge charges its customers compare to those establishments' price?
So there's private stations that are publicly available. There may be one or two of those, subject to check. And in meetings that I've been involved with those folks, they generally tend to match up with what we're charging at our stations. So setting commodity aside. So oftentimes they're transportation service customers, so they're out finding their own source of gas. But setting the commodity portion aside, I think they target kind of a price at the pump similar to the utility price.
So the subsidy that the rest of the customer base is supplying to this class, is it Enbridge's position then that that should be increasing compared to the last rate case, or decreasing, or remaining constant?
So the subsidy, actually, we have not had a subsidy in place since the 2013 general rate case. We actually removed it at that time because volumes grew to the point where it was self-sustaining. And we have not introduced a subsidy in 2016 or 2019 or 2022. Those are the three cases we filed in between then and now. I don't know what the level of the subsidy had been prior to the discontinuation in 2013, so I wouldn't be able to compare necessarily this that we're proposing here with where it was in the past without checking on that.
And that's fine. But the class wasn't covering all of its costs in the past, was it?
No, not prior to that 2013.
Well, no, I'm just saying for those last three cases you mentioned.
Oh, you're right. It has not kept up with its full cost.
So whether we name it a subsidy or name it a shortfall or whatever, is this proposal to make that, whatever it is, bigger? Is that what the company's proposing?
So I think, I see what you're saying, and I would say the revenue requirement of the class isn't growing over time. I don't see that as the trend. The revenue we're collecting from existing customers is decreasing, and so that's where the size of that subsidy is going to fluctuate. To the extent that the trend we've seen over the last decade were to continue, I would anticipate that the size of that subsidy would continue to follow that trend until these are depreciated off, like you mentioned. There is depreciation to consider with these, so.
And then the last one, what is, accounting for both commodity and DNG, what is Enbridge's current gasoline gallon equivalent price that they're charging?
I think we're right around $2.40 and some change, probably $2.43 or $2.44, I don't know exactly, but right around the $2.40 mark.
Okay, thank you.
One final question, Mr. Stevenson. How long do you think that the NGV class should continue?
Well, my opinion on that is that it continues to serve the public interest. I know that the vehicles we see on the road now are not as high in quantity as we've seen in the past, but I think it's shifted towards larger class vehicles driving around on the road. And I think, to answer your question, as long as there are customers who need the service and are supporting, going back to the statute that I talked about, there are safeguards around this class in that 50% revenue threshold. I think that's a good check. I would say if we were to fall below 50%, it would probably be worth revisiting how much, how much of that subsidy is justifiable at that point. But I think, as long as we do have customers using the stations and generating enough revenues to stay within those boundaries set forth in that statute, I'm not sure how long that may be. I'm hoping that we're going to find a floor and the declining trend won't continue, but I would just say as long as we're meeting those, those metrics or those guidelines in the statute.
You're not prepared to agree to what the division proposed, that it should be phased out by the next rate case, or at least that the subsidy should be phased out by the next rate case, and that an NGV class should be based on the full cost of service?
I'm not ready to agree. And I do appreciate the clarification between the NGV class as a whole and the subsidy itself.
Yeah, two different things.
I think it would just depend on the volumes we're seeing and the support we're seeing from users of the stations. So as I sit today, it's hard for me to put a timeline on it.
Do you think it requires a statutory change for the commission to end the NGV class?
To end the class as a whole, meaning discontinue service at the stations altogether?
Yeah.
I don't know that our service at the stations relies on the statute as much as the subsidy itself relies on the statute.
So let's ask it a different way. Do you think it requires a statutory change to eliminate the subsidy?
I think you could eliminate it through a statutory change. I don't know that it's required. I think that, like I mentioned, there are safeguards around the subsidy. There's the 4 points, 4 checks in place.
Right.
I think if we were to fail to meet those thresholds at a certain point, then the statute already includes kind of an off-ramp for that subsidy.
Okay. All right. That's all. We'll excuse you. Thank you, Mr. Stevenson.
Thank you.
All right. We'll break for lunch. Should we say be back here by 1:45? Does that give you enough time to get whatever you need to do? An hour and 15 minutes, essentially. Does that work? Seeing no objection, we'll be in recess until 1:45. I made you wait. You can all send me your bill for your billing rate. Probably can't afford that if they got that from every one of you. You're gonna tell me you don't bill less than 1/10 of an hour increments, so it's gonna be a pretty big bill. Okay, let's go back on the record. I think our next witness will be Mr. Landward, who's conducting, Ms. Clark.
I've
Sorry,
got him.
Ms. Clark.
Thank you so much. The company calls David Landward.
Mr. Landward, welcome. You raise your right arm to the square. You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. You may be seated.
It's broken anyway.
Still works.
Mr. Landward, would you please state your name and business address for the record?
Yes, my name is David Christian Landward. My business address is 333 South State Street in Salt Lake City, Utah.
What position do you hold with the company?
I am a regulatory consultant with the company.
Mr. Landward, are you the same David Landward who submitted pre-filed testimony in this matter, pre-filed direct testimony labeled Exhibit 6.0 with accompanying Exhibits 6.01 through 6.03, as well as rebuttal testimony labeled EGU Exhibit 6.0R and surrebuttal testimony labeled EGU Exhibit 6.0R, 6.0SR?
Yes, I am.
And did you also submit with your rebuttal testimony Exhibit 6.04R?
Yes, I did.
And do you adopt the contents? Well, let me ask you this. Do you have any changes to any of those documents?
I do have one minor correction. In my surrebuttal testimony, that will be Exhibit 6.0R, page 6 on line 120. The last phrase in that line reads, "The last 14 years have established." I believe that should read, "The last 11 years have established."
And with that correction, Mr. Landward, do you adopt the contents of all these documents as your testimony today?
Yes, I do.
The company moves for the admission of EGU Exhibit 6.0 with accompanying Exhibits 6.01 through 6.03, EGU Exhibit 6.0R as corrected with accompanying Exhibit EGU 6.04R, and EGU Exhibit 6.0SR.
Okay, thank you. Is there any objection to the admission of the testimony exhibits? Okay, we'll admit Mr. Landward's direct rebuttal and surrebuttal with the accompanying exhibits into evidence.
Thank you. Mr. Landward, can you please summarize the testimony you've offered in this matter?
Certainly. Mr. Chairman, Commissioners, thank you for the opportunity to testify before you today. My testimony addresses the company's proposed adjustment to normal heating degree days used for its weather normalization. The goal in normalization of any kind is balance, finding a middle ground through the unpredictable spikes and dips that create noise in data. The best barometer the company has to assess balance in weather normalization is the history of the aggregate monthly results. As I note in my direct testimony, it has become clear in those results that normalization has fallen out of balance. It has been favoring the positive side for some time, meaning usage is being adjusted upward to meet the normal heating degree days target much more often than it's being adjusted downward. The company has also observed a concerning recurrence of large variances between actual and currently established normal heating degree days. The reason is simple. The normalization is truing up to a baseline that is sitting above the level where average heating degree days have been residing since the last baseline was set in the 2019 general rate case. A new reset is needed to realign and rebalance, to find that middle ground again. Bear in mind that weather normalization always targets history. It's always backward-looking. Lowering the normal baseline by updating the history it references does not assume that colder periods in the future will not occur. If the current trend reverses course and colder periods become more common, a course correction will be made through a subsequent baseline reset. Normal heating degree days are never permanent. Such adjustments are part of the weather normalization operation among all utilities that use it. Delaying an adjustment to allow further study on this issue will not offer additional clarity to the problem or its remedy. It will only unnecessarily postpone its resolution. When a vehicle's wheels are out of alignment, causing the steering to favor one direction, the driver doesn't postpone realignment, hoping future roads will curve in the direction of the drift. The effect is real and tangible, and the solution is known. The effect of a misaligned normalization baseline is also real and tangible. Suspending action to undertake further empirical analyses needlessly delays the realignment for 3 more years. Unless heating degree days reverse course, the large and consistent upward adjustments may only persist. I've documented the problem, and I've proposed the remedy. The Commission should view this as prudent, ongoing maintenance of the company's long-running and well-established weather normalization mechanism. It will afford greater alignment and billing normalization adjustments, and it will put weather-normalized forecasts closer to where the normal usage midpoint currently lives. Regarding the division's concerns about resource constraints connected to the company's customer-level weather normalization billing adjustment, I simply remind the Commission that this method has been in place for decades, implemented and maintained by competent and experienced professionals. The company is happy to arrange interviews of some of those experts by division personnel who would like to better understand software and hardware configurations, testing, and other measures in place to ensure efficient execution and preservation of data accuracy and integrity. This concludes my summary. Thank you.
Thank you very much. Appreciate that, Mr. Landwehr.
Mr. Landward's available for cross-examination and any questions from the Commission.
Thank you, Ms. Clark. Ms. Schmidt,
No questions.
Mr. Snar.
No questions.
Okay, Mr. Russell.
No questions, thank you.
Okay, Mr. Cook, I should have that memorized by now, I apologize.
No questions.
All right, let's see, we'll go to Mr. Davidson,
No questions, Mr. Chairman.
okay, and Major Nelson.
Newton, but no questions.
Newton, I knew that. I wrote it down wrong here, I apologize, that's
I've been called worse, Commissioner.
inexcusable. I either can't read my own handwriting or wrote it down wrong. All right, well, starting to get more optimistic we're going to get through here today. I just want to say one thing. I appreciate the colorful analogies that you and Mr. Summers both used. You had the process versus full bird versus your automobile analogy. That was very helpful. Okay, we'll turn to Commissioner Clark.
I just have a question or two.
Yes, sir.
In the company's long history of tracking and normalizing, has the Commission approved adjustments like this in the past in either direction?
Yes, sir. The last adjustment was approved in the 2019 rate case. I cite that docket number in my direct testimony. I don't recall it off the top of my head. There have been adjustments prior to the normal heating degree days baseline predating that as well. I don't know, I don't think the spacing has been regular. I think it's evaluated ongoing when it appears that adjustment is needed as proposed by the company.
That's my only question, thanks.
Yes, sir.
Okay, Commissioner Harvey.
To start, a follow-up on Commissioner Clark's question, when you say adjustments before, is that just basically running the calculation, or is that changing the number of years?
The first time the company has altered the length of the window to derive normal heating degree days, changing the number of years, the length of the window used to derive normal heating degree days. Sorry, I get you. Was the last adjustment, which occurred in the 2019 docket. That shortened the length from 30 years, which the company had been using, to 20 years. Prior to that, the company had consistently used a 30-year length.
And then just one clarification question. You had mentioned in responding to the other parties in testimony that EGU uses an individual customer level adjustment. And I'm just, this is based on my recollection to see if I understand it right, but when you say individual customer, I think that means it's done for each account, but it's based on a large number of monitoring stations around the territory that are recording the temperature at specific locations and elevations?
Yes, sir, that's correct. We employ in our Utah service territory 8 weather zones, the largest being the Salt Lake City weather zone, which takes its data from the National Weather Service station located at the Salt Lake City International Airport. Each customer, based on their geographic location, is assigned to one of those 8 weather zones. And then the heating degree days and the actual heating degree days used to make that normalization adjustment for that customer are taken from that specific zone.
So there's 8 adjustments that are applied to one of those 8 is applied to each individual customer?
Yes, sir.
Okay. And then my understanding is if a customer wants to, they can opt out of weather normalization if they let the company know?
Yes, sir. That's correct.
Okay. That's all the questions I have. Thanks.
Thank you, sir.
Mr. Landward, the office didn't ask any questions on this, but it's my understanding that was it, I can't now remember whether it was the office or the division proposed using a 15-year versus a 10-year baseline. Why do you think that the 15-year baseline is not an appropriate compromise between the current 20 and the 10 you're proposing?
The 15-year window continues to absorb higher levels of heating degree days that I would call residual, that were more frequent in the past, but have not been frequent in the last 11, 10 years. So when we're trying to establish an average, which is what normal heating degree days essentially are, we want to make sure that average best represents the population, well, the members of the sample. And a heating degree days window that we select to derive that average is essentially a sample of contiguous data points. But if you can imagine not treating them as a continuous timeline of data points, but arranging them in sort of a bell curve, ideally you would like to see them distributed fairly equitably across the middle, where the average sits right in the middle, and then they're distributed fairly evenly from side to side. That's the ideal. Data in the real world is never beautifully perfect like that, but that's what we're hoping for. The problem with a 15-year length or longer is that it leaves some, let's call them stragglers, out on the tail of the high side. And that pulls the average over in their direction. And the result is that average continues to kind of hover on top of where the majority of the other members are. And the result of that, as we've been observing, is that more often than not, weather normalization is reaching upward. It's adjusting usage upward. It's insisting that even though the last 11 years, heating degree days have been down here and customers have acclimated their usage to that level, we still want to represent those in the outer lying years. And so we want to keep moving up, as if those outer years with higher levels of heating degree days are still at play when they haven't really been. 20 years certainly does that to a larger extent. 15 years is a marginal improvement because those higher heating degree days have less of an influence, but they're still there. In the exhibit that I offered in my rebuttal testimony, I gave a visualization of that and showed how even the 15-year line still keeps that average a little closer to the top than I would like to see it. It is an improvement because we see that it's approaching the middle where we get some points that are above the normal line and some that are below. I think it was about 4 points above and 6 points below. The 10-year normal doesn't let those outer lying higher levels that aren't really at play anymore influence. So it sits in the middle better and represents the majority of the members of that sample of the last 11 years better. Then you have, I believe in that graph, you've got, and these are annual heating degree days totals, you've got about 6 that are above the normal, meaning colder than normal, and about 4 that are sitting below. So that's what I'm trying to target in weather normalization. Now, I want it to be in the middle. It's never going to be perfect, but if I have to err on the side of a little bias one side or the other, I would prefer to see more downward adjustments to usage than upward, because I think that's what customers would prefer to see. They'd rather see their bills going down for an adjustment than up. So that's why I'm favoring 10, because I don't want those outer years that just don't seem to be typical of what we're seeing these days, what customers are used to adjusting a thermostat to. I don't want them to have undue influence.
So is one of the factors then upon which you base this 10-year baseline the existence of climate change that the Earth, the United States, that Utah is becoming warmer over time?
Well, I'm only observing what's been happening. I'm not trying to imply or infer anything about the climate per se in shortening this window. I'm just trying to be responsive to a changing target that's throwing my normalization off. So it's more of a pragmatic matter. I don't know what will happen in the future if we've entered a period that's going to be a permanent shift downward, that we're always going to have warmer heating seasons than what we were used to 20, 30 years ago. If that may reverse course or if it may be a mix, but weather normalization is, the practice of it is like driving with the rear view mirror. I'm always looking backwards. What's been happening? What does the road look like that I've just passed? And if you can imagine, we were at a higher level and then we came down a hill, and then we've been on a flat road that seems to still have a downward gradient, and that hill is getting further and further in the rearview mirror. So it's clear to me that the road now that I'm on has changed from what it was miles back. And so if you think of weather normalization in that context, I need to adjust to the road that I'm on now and assume that since that's where I'm at today, that's my best gauge for weather normalization. I always know what the past is with 100% certainty. I don't know what the future is, but a long persistent set of heating degree days at a certain level is it tells me that that's what customers are seeing and that's what I should be normalizing to. That's what's normal for them. 10 years may not be a good normal for a meteorologist or a climatologist who wants a broader view. It may not be good for someone looking for a broader range for even some natural gas applications like gas procurement, where they want to see what is possible, even on the extremes. What's the worst that can happen? I want to see what's typical for the customers. That's what I'm calling normal in this context. And that's what I want to hit. What's happening with the client, what's driving it, I don't know. I'm not making any judgments on that. I'll leave that to the scientists. I'm in a reactionary state as a weather normalization analyst.
Okay, that's very helpful. I appreciate that further explanation. One last question. You said you would be willing to arrange experts to, to sit down with the division if they were interested in that. Is that an offer that you've already made in the past, or has that not been made previously?
I did extend that offer in my rebuttal testimony. I appreciate the division's interest and wanting to understand all of this better. That's helpful to us as a company. Anytime we can engage with the division on what we're doing, and they can get insights, deeper insights, and understand the mechanics under the hood. So yes, we'd be happy to have them sit down with billing system specialists and information technology specialists that can answer those questions, talk about the tests they do, the upgrades they make to facilitate this customer level weather normalization and make sure it's working correctly every time for every customer.
Okay, thank you for that additional clarification. I think that's it, Mr. Landward. Thank you. You may be excused.
Thank you, sir.
That's going to be on there. Do you have one? I think this one, I'm sorry. I think. On the record, thank you, Mr. Landward. The last witness is for EGU's Jordan Parks. Okay, and that's Ms. Barrett.
Yes, the company calls Jordan Parks.
Okay. Mr. Parks, will you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated. Ms. Barrett.
Thank you. Mr. Parks, please state your full name and business address for the record.
Jordan Parks, 333 South State Street, Salt Lake City.
And what position do you hold with the company?
Regulatory analyst.
Did you file direct testimony in this matter marked as EGU 7.0 with accompanying exhibits 7.01 through 7.04, rebuttal testimony marked as EGU 7.0R with exhibits 7.05R through 7.07R, and surrebuttal testimony marked as 7.0 SR with exhibits 7.08 SR through 7.10 SR?
Yes, I did.
And do you adopt the contents of those documents as your testimony today?
Yes.
The company moves for the admission of Mr. Parks' direct rebuttal and surrebuttal testimony along with the accompanying exhibits.
Okay. Is there any objection? Okay, without objection, we'll receive the direct rebuttal and surrebuttal testimony of Mr. Parks with the accompanying exhibits and evidence.
Mr. Parks, can you please summarize your testimony in this matter?
Sure. Good afternoon, Mr. Chair and Commissioners. Thank you for the opportunity to speak today. The purpose of my testimony and exhibits were to clean up and propose modifications to the company's tariff. My summary consists of the 6 applicable changes being proposed in this docket. Number 1 is in section 5.01 of the tariff. The company is proposing to add a section to address transportation customers who fail to nominate gas supply for 15 or more days in a month. After a grace period, customers who continue to fail to make nominations will be moved to a sales rate schedule, which will allow the company to plan for the customer's needed supply. No parties objected to this change. Number 2 is in section 5.04 through 5.06 of the tariff. The company proposes adding maximum usage thresholds to the TSS and TSM rate schedules. The tariff currently only addresses customer usage falling below the minimum usage level. This change prevents customers with usage far outside the intended range from continuing to receive service on an inappropriate rate schedule. No parties objected to this change. Number 3 is in section 8.03 of the tariff. The company is proposing to modify language to clarify the eligibility and administration of the Energy Assistance Program. OCS witness James Daniel raised concerns in his direct testimony regarding the clarity of the language related to energy assistance eligibility and the Heat Assistance Program. The company worked collaboratively with the OCS, and I proposed revised language in my surrebuttal testimony to better reflect program intent and address those concerns. No other parties objected to this change. Number 4 is in section 8.09 of the tariff. The company is proposing to remove the two-way carrying charge for interest expense on the Green Therm balancing account. This change ensures that customer contributions to the Green Therm program go directly towards the purchase of RNG green attributes and not for covering interest expense. No parties objected to this change. Number 5 is in section 9.02 of the tariff. EGU has encountered a number of large-scale projects that require significant upfront engineering costs. Sometimes, after the company has incurred these costs, the customer opts not to proceed with the project. In order to place the burden of these costs on the requesting customer, the company proposes to require an upfront payment for the preliminary engineering work on projects over $50 million or that require contracted engineering support. In direct testimony, DPU witness Eric Orton recommended changing the language in the tariff to clearly define the type of projects that will require the upfront payment. He recommends changing the language from, open quote, particularly complex, close quote, to, open quote, requires contracted engineering support, close quote, which more accurately represents the type of projects the company would require an upfront payment for preliminary engineering work. I agreed to this change in my rebuttal testimony. In direct testimony, OCS witness Daniel recommended changing the language in the tariff from, open quote, the company may require the customer to make an upfront payment, close quote, to, open quote, the company shall require the customer to make an upfront payment, close quote. In my rebuttal testimony, I agreed with this change. OCS witness Daniel also recommended lowering the $50 million system improvement threshold for requiring upfront payment to $10 million. In my rebuttal testimony, I disagreed with this change because lowering the threshold to $10 million would significantly expand the number of projects subject to this requirement, including many that are routine and whose upfront engineering effort is minimal and not overly burdensome. This could increase administrative overhead for the company and would lengthen the overall project siting process for potential customers. Number 6, the last change is in section 10.02 of the tariff. This revision clarifies how the municipal energy sales and use tax is calculated and references the applicable statute. No parties objected to this change. Lastly, other proposed changes throughout the tariff include rewording, updated references, punctuation, formatting, and grammatical corrections that do not affect the substance of the tariff. Changes related to the distribution non-gas rates and administrative charge have been addressed in Mr. Summers' testimony. The proposals are just, reasonable, and in the public interest. This concludes my summary.
And Mr. Parks is now available for cross-examination and the commission's questions.
Okay, thank you, Ms. Barrett. All right, let's turn to Ms. Schmidt.
No questions.
Okay, Mr. Snar.
No questions.
Okay, Mr. Russell.
No questions, thank you.
All right, Mr. Cook.
No questions?
Mr. Davidson.
No questions, Mr. Chairman?
And a United States Air Force officer deserves to have her name pronounced correctly, so I apologize last time. Major Newton, any questions?
No, sir, thank you.
Okay, thank you very much. All right, let's turn to Commissioner Clark.
I have no questions.
Commissioner Harvey.
I'm ruining the record.
Somehow I knew that.
Just a couple of quick questions on the green therm interest expense changes you mentioned.
Yeah.
Those expenses are integral to the program being able to function, are they not? The green therm program?
The Green Therm program, those, sorry. could
The
you-
interest charges occurring because there's a balance, is that integral to the program being able to function?
No, it's not.
I mean, but the interests are on assets that the program needs to function, aren't they?
That's correct. I think the main reason behind this tariff change is the company recently purchased a very large amount of these green attributes, which will result in the account being significantly undercollected for a significant amount of time. In order for that interest expense not to build up a significant amount, the company is proposing to remove that. And so the contributions made by customers are more directly used for actual green attributes and not for covering interest expense.
But the interest expense still exists, correct? The company spent the money and it assumes it's going to get its interest on it?
Yes.
So the proposed tariff change would just shift that interest expense from people that use that particular program to the general customers of Enbridge?
From my understanding, it would not. That burden would just be on the company.
Is there a way we can clarify that to be sure?
Yes, I can check on that.
Okay.
Subject to check.
Okay, thanks. That's all I have.
Thank you, Mr. Parks. Just one question with respect to clarification. You agreed with the divisions and to change the language and that language was to require contracted engineering support. But also the issue was raised whether the threshold would be lowered from $50 million to $10 million for projects. Was that raised in your rebuttal? And what I'm getting at is if you had an opportunity to talk with the division about that threshold and your rationale for not lowering the threshold for $10 million that they proposed.
Yeah, I addressed that in my rebuttal testimony, the reasoning behind not lowering that threshold from 50 to 10.
Okay, in your rebuttal, not in your rebuttal testimony.
That's correct.
Okay, all right. I think that answers my question then. Okay, you may be excused. Thank you.
Thank you.
All right, while we're moving to the next party, to the division, let's address the issue I raised right before lunch. And Mr. Parks' testimony is a good example of where you've reached agreement with respect to some of the tariff language. And I raised the issue with respect to the explanation on why you wouldn't lower the threshold from, you would not agree to the lower threshold that the division requested. There's an example of an issue that's outstanding and we understand still maybe disagreement on. But what we'd like to know is what issues, and give us a matrix of, if not all the parties have agreed. If all the parties have agreed, you can just say this issue is resolved. If not, who has agreed to it and who hasn't. You're going to talk about that. I think we need to get an idea of when we anticipate we could get a document to that effect. You did have a chance to talk about that issue over lunchtime,
We did.
Ms. Clark. Go
Yeah,
ahead.
we did. We did. And to be clear, what the commission is looking for is a matrix that reflects where we have agreement and not
Yes.
necessarily a comprehensive list of all issues and positions.
No. I think we know the issues we've got.
So we can have a draft of the matrix out to parties by the end of this week. And I'm reluctant to commit the parties to a turnaround time, but we can certainly prepare a first crack at that by the end of this week and have it to everyone.
As to the issues which you think are resolved.
That's correct.
Okay. And then for the parties to turn that around, it is Thanksgiving week coming up, but we also have a December 27th deadline on an order. What do you think? If Ms. Clark does takes the laboring oar on identifying issues that have been agreed to, could it be done by Wednesday? Or maybe some of you are taking the whole week off. Can we have a list before Thanksgiving? What do you think? I'm looking around for shakes of the head, acquiescence or non-acquiescence.
Yeah, I was going to suggest Wednesday.
Yeah.
That would work for me and for UAE.
Okay, I think that work for us? It works for us.
The office can do Wednesday.
Okay.
The division can too.
Okay, I see no objections to that. I think we'll be okay. And most of those are going to be issues that I think you probably agreed with the division or the office on, maybe not with the other parties as much. But I think that would be helpful for us as we plow forward with drafting an order. So, and as we've just heard from Mr. Parks, we've got some of those issues that have been laid out already in his testimony. So, and that doesn't preclude you from seeing if there are other issues, sub-issues that can be resolved, like, and maybe not, but that 50 million to 10 million threshold is one that seems to me perhaps there could be a discussion about that, but perhaps not. Okay, we will proceed now with the witnesses for the Division of Public Utilities, and they have 5 witnesses as well. And remind me, Ms. Schmidt, which witnesses you're covering?
I am covering Mr. Daigle, Mr. Fields, and Mr. Pernicoli. Mr. Grecu is presenting the Ortons.
The Ortons. Okay. Are the Ortons related? I assume that means.
No, not
No?
to my knowledge.
Okay, I just was asking because of the way you phrased it. I was curious. Okay, well then we'll turn to Ms. Schmidt. No, we're going to turn to Mr. Grecu. Mr. Orton is the first witness that you have listed to present. Is that correct?
That's correct.
Okay. Mr. Orton, if you'll come to the stand, be sworn. Mr. Orton, welcome. Will you raise your right arm to the square?
Thank you.
You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you very much. You may be seated. Mr. Grecu, we'll turn to you from now.
Thank you. Mr. Orton, could you please state and spell your name for the record?
My name is Eric Orton. That's Ericorton.
And by whom are you employed and what is your position?
I'm employed by the Utah Division of Public Utilities. I am a utility technical consultant.
And what is your business address?
160 East, 300 South in Salt Lake, here in the Hebrew Wells building.
And have you participated in this docket on behalf of the division?
I have.
Did you review the company's application, supporting exhibits, and pre-filed testimony, along with the other parties' testimony in this docket?
Yes, I did.
Have you also reviewed responses to data requests in this proceeding?
Yes, I have.
Did you prepare and cause to be filed your Phase 2 direct testimony and Phase 2 surrebuttal testimony?
Yes.
Do you have any changes or corrections to those filings?
No, they're accurate.
If I asked you the same questions posed in that testimony today, would you provide the same answers?
I would.
And do you adopt the contents of your pre-filed testimony as part of your testimony today?
Yes.
I'd like to move to admit Mr. Orton's Phase 2 direct testimony marked as DPU Exhibit number 1.0 DIR and his Phase 2 surrebuttal testimony marked as DPU Exhibit number 1.0 SR.
Okay, without objection, your direct and surrebuttal testimony are admitted.
Thank you. Mr. Orton, do you have a summary to share today?
I do.
Please proceed.
Thank you. Today, I will present the division's recommendations regarding certain tariff changes proposed by the company. In this Phase 2, the division has carried out an extensive investigation and analysis of the company's cost of service and rate design proposals and its proposed tariff language, reviewed the testimony from other parties, and conducted considerable discovery. The division reached the conclusions presented in its testimony based on its analysis of this information. The purpose of my summary today is to provide the reasons why the Commission should adopt the recommendations presented in my Phase 2 testimony. My first recommendation is that the Commission adopt the company's proposal to delete duplicative language in the tariff section 8.03 related to language under the Energy Assistance Eligibility heading. The company initially proposed to eliminate the language in item number 2, which states, quote, customers that receive HEAT assistance during a heating season will be exempt from the energy assistance rate in that same heating season, unquote. Because it is duplicative of existing language in item number 3 that explains, quote, customers who receive the credit will not be assessed the energy assistant charge for 12 months following qualification, unquote. I noted that it is not necessary to have both provisions that address the same concern. In surrebuttal, company witness Jordan Parks testified that EGU has worked with the Office of Consumer Services on changing additional language in this section to address some of OCS's broader concerns, and he presented the revised language in his exhibits with his surrebuttal testimony. The division has reviewed these revised language in the tariff and the testimony and supports the direction it is going and does not oppose these changes. Second, I recommend that the Commission adopt the company's proposal to remove the interest expense for the under-collected balance in the Renewable Natural Gas Green Therm Program in Tariff Section 8.09. The company states that it has purchased enough RNG credits to have a sufficient reserve that should last several years at the current rate of customer block purchases. Under the current tariff, RNG customers pay interest on the balance of RNG credits, which is currently large, and requires RNG subscribers to incur interest expense on a balance they didn't cause. It is unjust and unreasonable to burden RNG customers with this charge until the pool of RNG credits is balanced with the RNG block purchases. My third recommendation is for the Commission to adopt the company's request to include language in Tariff Section 9.02 that requires customers who request cost estimates for large-scale projects to pay upfront for the preliminary engineering costs of the project. In my Phase 2 direct testimony, I noted that I agreed with the concept of Enbridge's proposed tariff language to require upfront payment for preliminary engineering costs if the project would require system improvement costs equal to or greater than $50 million, or if the project was, quote, complex, unquote. However, I thought the language was too vague to be effective, and I recommended that the word complex be replaced with, quote, requires contracted engineering support, unquote. In his rebuttal testimony, Mr. Parks agreed with my recommendation and would, quote, more accurately represent the types of projects for which the company may require an upfront payment for preliminary engineering work, unquote. Therefore, I recommend that the Commission adopt my proposed language as represented in Mr. Parks' rebuttal testimony. Finally, I recommend the Commission adopt the company's proposed change to Tariff Section 10.02 that clarifies that the municipal energy sales and use tax is to be calculated and charged in accordance with the applicable state statute. That concludes the summary of my testimony. However, I also recommend that the Commission adopt the recommendations offered in the pre-filed testimony of the other division witnesses, Annette Orton, Matt Pernicoli, Ryan Daigle, and David Fields. Thank you.
Thank you. The witness is now available for cross-examination and questions from the commission.
Okay, let's go first to EGU.
No questions from the company. Thank
Okay,
you.
no questions from the company. All right, I'll turn to you in case you have anything, Mr. Snar.
No questions.
Okay, Mr. Russell?
No questions, thank you.
Okay, Mr. Cook?
No questions.
Mr. Davidson?
No questions, Mr. Chairman.
Major Newton?
No questions.
Commissioner Clark?
No questions, thank you, Mr. Orton.
Thank you. Commissioner Harvey?
Just a quick follow-up on the Green Therm program again.
Sure.
You heard my exchange with the company's witness a few moments ago on that program.
Yes, sir, I did.
Given that I'm uncertain what type of follow-up I might get back from the company on that, I was just curious if you had, in your analysis, any information on what might happen to that interest expense if the company shareholders weren't adopting it? Or if you could generate any light on that?
The only light I can shine is what I think you already have determined, and that is, I asked the company the same question: what happens to that interest expense? They told me and then showed me the amount. I forget the amount, but they told me that they would be eating that expense.
Thanks, that's very helpful.
Okay, Mr. Orton, I only have one question as a follow-up on what I asked Mr. Parks. If I characterize his testimony as they want to keep the threshold for paying for contracted engineering support at $50 million, and you propose that that be lowered to $10 million. Is that correct?
I think it was the office that proposed that.
What did I say? How did I say
You
it?
said you said he did, but it's the OCS that proposed the 10.
I have Mr. Orton, did you, I apologize. This was the EG, okay. So what do you think about that as far as I'm trying to cover for my own misreading.
I'd like to come up with some sort of turkey driving a car analogy.
That'd be good. You have no opinion on that?
I don't know what the proper amount is. I don't know if it's 10 million or 40 million or 20 million. I don't have an answer.
Okay, all right. We'll ask that of the officer's witness then. I apologize for that. That's all I have. You may be excused. Thank you, Mr. Orton. Okay, we'll next go to, this will be also Mr. Grecu. This is Annette Orton. Ms. Orton, will you come to the stand? Welcome to stand. Thank you. Would you raise your right arm to the square? Ms. Orton, do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated. Okay.
Good afternoon.
Good afternoon.
Ms. Orton, could you please state and spell your name for the record?
My name is Annette Orton. It's spelled ANNETTEORTON.
And by whom are you employed and what is your position?
I'm employed by the Utah Division of Public Utilities, and I am a utility analyst.
And what is your business address?
It is 160 East, 300 South, Salt Lake City, Utah.
And have you participated in this docket on behalf of the division?
Yes.
And did you review the company's application, supporting exhibits and pre-filed testimony along with the other parties' testimony in this docket?
Yes.
And you also reviewed responses to data requests in this proceeding?
Yes.
And did you prepare and cause to be filed your Phase 2 direct testimony and Phase 2 surrebuttal testimony?
Yes.
And do you have any changes or corrections to those filings?
No.
And if I asked you the same questions posed in that testimony today, would you provide the same answers?
Yes.
And do you adopt the contents of your pre-filed testimony as part of your testimony today?
Yes.
At this point, I'd like to move to admit Ms. Orton's Phase 2 direct testimony marked as DPU Exhibit Number 8.0 DIR and her surrebuttal testimony marked as DPU Exhibit 8.0 SR.
Okay, seeing no objection, we'll admit Ms. Orton's direct and surrebuttal testimony.
Thank you. Ms. Orton, do you have a summary of your testimony to share today?
Yes.
Please proceed.
The division maintains that Enbridge's natural gas vehicle NGV program no longer serves a broad public interest in advancing an alternative fuel. Enbridge's own data shows declining NGV volumes, limited customer use, and a shrinking market. The program now relies heavily on ratepayer support to remain viable, while the costs borne by ratepayers exceed the benefits provided. Although Utah law allows the Commission to approve the subsidized NGV rate, it does not require continued subsidization, particularly when market and technological conditions have changed. Electric vehicle infrastructure is expanding rapidly, while NGV use and vehicle availability continue to decline. These trends indicate that ongoing ratepayer support for NGV stations is no longer just, reasonable, or in the public interest. In conclusion, while subsidizing the NGV class may be permitted under statute, the division continues to recommend that Enbridge phase out the NGV program by the next general rate case, or alternatively, increase NGV rates to eliminate the subsidy. If the program is phased out, the company should also evaluate selling some or all NGV stations to private or public operations as part of that transition. This concludes my summary.
Thank you. The witness is available for cross-examination and questions from the commission.
Okay, thank you, Mr. Grecu. All right, Ms. Mitchell or Ms. Clark, questions of this witness?
Thank you, Chairman. The company has no questions.
Okay. All right, Mr. Snar.
No questions.
Probably don't even need to ask you on the division witnesses, but I will do for the record. Okay, Mr. Russell.
No questions, thank you.
Mr. Cook.
No questions.
Okay, Mr. Why am I drawing a blank here again?
Davidson.
Davidson, I'm so sorry.
That's no problem.
Once I mess it up, then I'll always get it right, like Major Newton.
Thank you, Mr. Chairman. I do have a few questions
All right,
for
I'm
Ms.
really
Orton.
glad to hear that.
There we go. So, Ms. Orton, all my questions are directed at your rebuttal testimony this afternoon. I just have a handful of things to discuss with you a little bit. At page 2, lines 36 through 40 of your rebuttal, you state the division's position regarding continued subsidization of the company's NGV services. You see that reference?
I'm sorry, can you give me those lines again?
Sure. Page 2,
Okay,
lines 36 through 40.
okay. And what was the question?
You state the division's position regarding the potential continued subsidization of the company's NGV service. Do you see that?
Mm-hmm.
All right. And that is presented, as presented in your direct testimony, you call for a phasing out of the program or increasing charges to the NGV class, as I think you just mentioned in your summary, correct?
Mm-hmm.
All right. So the discussion at page.
Just a second, so you'll have to give an audible,
Oh, sorry.
doesn't
Okay.
help the court reporter. So is that a yes or a no?
Yes.
It was a yes, okay.
Okay. I'll slow down a little bit because you need to turn to the mic. I
know.
get it now. Okay. Is the representation in your rebuttal testimony intended to modify the division's position in your direct testimony regarding the NGV program?
No, no.
Over at lines 50 through 54 of your rebuttal, you reference the testimony of EGU witness Stevenson. You see that reference?
Mm-hmm.
And that asserts that EGU's existing NGV stations continue to meet the requirements of Utah Code subsection 54-4-13.4, paren 1, close paren small b, close paren, and remain in the public interest. You see that?
Yes.
Am I correct that Mr. Stevenson's filed direct and rebuttal testimonies included no quantitative analytics to support the company's assessment of its compliance with the Utah Code section I just read you?
Can you repeat that question?
Yes. Am I correct that Mr. Stevenson's direct and rebuttal testimonies that you referenced included no quantitative analytics to support the company's assessment of its compliance with the Utah Code section?
That's correct.
Okay. Am I also correct that you have provided no independent analysis of the company's compliance with the Utah Code subsection I just referenced?
Correct.
Now, I'd like you to take a look at your reference footnote 10 on page 3 of your rebuttal testimony. Do you have that?
Mm-hmm.
Am I correct that footnote 10 on page 3 is the full language of the Utah Code subsection 54-4-13.4, paren 1, close paren?
Yes.
Okay. Is it your understanding that a commission finding that the company's NGV station investments must meet all the requirements in parts A, B, and C of that subsection?
Yes.
Okay. Now, focusing on subsection B, we find that language that addresses, quote, the estimated annual incremental increase in revenue related to the stations and facilities, close quote. You see that?
Yes.
And am I correct that nothing in your rebuttal explains how either the Utah legislature or the division defines the phrase, quote, estimated incremental increase in revenue related to the stations and facilities?
Correct.
Okay. Now let's look at footnote 14 at the bottom of page 4 of your rebuttal. Are you with me?
Mm-hmm.
Okay.
Yes.
Does footnote 14 have the entirety of your rebuttal testimony, include the entirety of the company's response to DPU data request 30.1?
Yes.
Okay. Now, nowhere in the company's response to DPU data request 30.1 is there a reference to, quote, estimated incremental increase in revenue related to stations and facilities, is there?
No.
Now, back at page 3, sorry to make you go back, lines 55 through 56 of your SIR rebuttal, you reference, quote, declining NGV volumes, limited customer usage, and diminishing market demand. You see that reference?
Yes.
Can you explain how there could be any increase in estimated incremental revenue when usage and market demand are declining?
Can you repeat that question?
Sure. And then let me just simplify it. Is there any way that you can think of that there can be an increase in estimated incremental revenue for the NGV program when usage and market demand of that program are declining?
I cannot think of it.
Okay. Would you agree that the concept of incremental increases in NGV revenues was a product of the perception at the time the legislation was enacted?
Yes.
And that there would be a growing market for NGV refueling services?
Yes.
Now, if EGU should elect to sell some or all of its NGV stations, subsequent to a final ruling by the commission in this proceeding, but before the company's next gas rate case, has the division addressed the manner in which other Utah ratepayers would be compensated for the subsidies included in their rates for plant and equipment associated with the NGV stations that are sold and would no longer be used and useful?
No.
Okay. Now over at page 4, lines 84 through 85, again of your SIR rebuttal, you reference Enbridge's issuance of an RFP to sell a portion of the Utah NGV stations. You see that reference?
Yes.
Okay. If that were to occur, am I correct that nothing in your either your direct or rebuttal testimonies in this proceeding addresses how the potential sale of the NGV stations should influence the commission's rate determinations in this proceeding?
Correct.
Okay. And if NGV subsidies are continued after this proceeding concludes and EGU sells some or all of its NGV stations subsequent to a final order, but before the company's next general rate case, does the division believe that Utah ratepayers who have subsidies for EGU, for Enbridge's NGV service included in their rates should be compensated for subsidies no longer required or justified, but rates approved in this proceeding?
Can you repeat that question?
Sure. Let's assume the subsidies continue after the conclusion, the NGV subsidies conclude after continue after the conclusion of this rate case. Do you have that in mind?
Mm-hmm.
Okay. And then before the company's next rate case, does the division believe that Utah ratepayers who have subsidies for NGV service included in their rates, right, should be compensated for subsidies no longer required or justified, but rates approved in this proceeding remain in place?
Yes.
And if EGU sells some or all of those NGV stations prior to the next rate case, does the division believe Utah ratepayers who subsidize the company's NGV operations through their rates should share in the proceeds from any sale of those assets?
Can you repeat that question?
Yes. If the company sells some or all of its NGV stations, as it's said it's considering doing, right, prior to the company's next general rate case filing, does the division believe that Utah ratepayers who subsidize the company's NGV operations through their rates should share in the proceeds from any sale of those assets?
No.
Okay. Why not?
Because it would be taken into effect in the next general rate case and worked out through that.
So would they get a benefit from the sale in the next general rate case, in your opinion, should they?
I think we would need to cross that bridge when it gets there. Right now, it's not even sold.
So we just wait to see what the company does in the next rate case and
Yes.
address it then?
Mhm.
Okay, thank you, that's all I have. Thank you, Mr. Chairman.
Okay. All right, thank you very much, Mr. Davidson. Major Newton, any questions?
No, Commissioner, thank you.
Okay. Commissioner Clark.
I don't have any questions, thank you.
Commissioner Harvey.
I do. I'm curious if you've thought about if there's a level of subsidization that is acceptable to you for the NGV program?
I haven't thought about that.
Okay. Let's talk a little bit about the idea of prudence. Do you agree that prudence needs to be evaluated based on the information that was known when the utility decision was made and not in hindsight?
No.
Okay. Given that an investment has been made in the infrastructure to have these stations operating, if the program were discontinued, that investment would still be on the books, correct?
Mm-hmm. Yes.
You'll get it eventually. That's all right.
I hope.
All right. So can you envision a case where program is terminated and ratepayers end up, paying that full amount that's in rate base over time plus the rate of return and all that? Is that what would happen if the program was terminated?
It depends if these stations were sold.
Okay. Now, the premise of your testimony is that it's a declining market.
Mm-hmm. Yes.
In a declining market, would you expect there to be a lot of willing buyers that were happy to pay top dollar for these assets?
Probably not.
Okay. So in the situation where a program continues and the customers that are using that are paying, we've heard in today, 70% of the ongoing costs, is it possible that it's cheaper for ratepayers to keep up a small subsidy with some revenue coming in versus having to pay for the entire rate base?
That's possible.
All right. Okay, thanks very much.
Okay, I neglected to give Mr. Griecu an opportunity for redirect if you had any after Mr. Davidson's cross.
I do not. Thank you, though.
Okay, I have no questions. We'll excuse you, Ms.
Okay.
Gordon. Thank you. Okay, we'll turn to Ms. Schmidt. This is, the next witness is Ryan, did I pronounce it correctly, Daigle?
Daigle is correct, thank
Okay,
you.
Mr.
The
Daigle.
division would like to call him, please.
Okay, Mr. Daigle, if you'll come to the stand. Welcome, Mr. Daigle. Will you raise your right hand? Thank you. Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Thank you. Please be seated.
Good afternoon.
Good afternoon.
Could you please state and spell your full name?
It's Ryan Daigle, RyanDaigle.
By whom are you employed and in what position?
The Division of Public Utilities, and I'm a utility technical consultant.
Could you please provide your business address?
160 East, 300 South, Salt Lake City, Utah, 84114.
Have you participated in this docket on behalf of the division?
Yes, I have.
Did your participation include reviewing the application and testimonies filed by the company and interveners, and data requests and responses insofar as they pertain to the areas upon which you are testifying.
Yes.
Did you prepare and cause to be filed DPU exhibit number 7.0 direct with accompanying exhibits 7.01 direct, 7.02 direct, and your surrebuttal testimony, DPU exhibit number 7.0 SR, and that surrebuttal testimony had no exhibits?
Yes, I believe that's correct.
Do you have any changes or corrections to your pre-filed testimonies?
I do not.
If you were asked to prepare and file your pre-filed testimonies today, would your answers be the same as they are typed in your pre-filed testimony?
Yes, they would.
Do you adopt the contents of your pre-filed testimonies as part of your testimony here today?
Yes, I do.
The division would like to move for the admission of Mr. Daigle's exhibit number 7.0 DIR with its exhibits 7.01 and 7.02, and his surrebuttal testimony pre-marked as DPU exhibit number 7.0 SR.
Okay, without objection, we'll admit Mr. Daigle's direct testimony for his two exhibits and his surrebuttal testimony. Thank you.
Do you have a summary to share with us today?
Yes, I do.
Please proceed.
Good afternoon, Chair Finn, Commissioner Clark, and Commissioner Harvey. Division recommends the Commission adopt the adjustments proposed in my direct testimony and supported in my surrebuttal testimony. These adjustments include an increase to the filing frequency of the Conservation Enabling Tariff, or CET, if the account balance falls outside the proposed plus or minus $10 million threshold. Secondly, an increase to the amount the company is allowed to annually amortize. And finally, a provision to expedite the return of large over-collected balances in the CET for any amount beyond the 5% of the Utah jurisdictional-based DNG GS revenues. I also suggest a working group to look into the transportation and balance charge to determine the efficacy of the calculation and the behavior of the TS class customers. This concludes my summary. Thank you.
Thank you. Mr. Daigle is now available for cross-examination questions and questions from the Commission.
No questions, thanks.
No questions.
No questions, thank you.
No questions.
No questions, Mr. Chairman.
No questions.
No questions. Thank you, Mr. Daigle.
Just for you. I will save my CET questions for another venue. All right.
I have a series of questions I'd like to ask. No, that's not true. I have none. I just wanted to see if I could get a rise out of Commissioner Harvey. All right. All right, well, that's great. You're finished. How was that? That was pretty painless, wasn't it?
Wonderful. Thank you very much.
Thank you. You may be excused. Okay, I'm starting to revise my estimate that we can finish this in one day, so don't disappoint me. All right, Mr. Grecu, we'll turn to you for your next witness.
I'm sorry,
Oh,
the next
that's
witness
Ms.
is
Schmidt.
mine.
Ms. Schmidt, I knew that. Wait a second, I just have to look.
The division
This
would
is
like to
Mr.
call Mr.
Fields.
Fields, yes.
Okay, all right. Thank you. Apologize. Ms. Fields, welcome. Would you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. Schmidt.
Thank you. Good afternoon.
Good afternoon.
Could you please state and spell your full name?
Sure. My name is David Fields, D-A-V-I-D, F-I-E-L-D-S.
By whom are you employed, and what is your position?
Sure. Division of Public Utilities, and I'm a utility analyst.
And what is your business address?
It is 160 East, 300 South, Salt Lake City, Utah, 84114.
Because you are new to our world, could you please provide a very brief summary of your educational and professional experience as they relate to your position with the division?
I just want to interrupt for a second. What does that mean, you're new to our world?
I'm an alien.
Recently employed, is that?
Recently employed and has not testified before.
Okay, all right, thank you. All right, that's, clarification was probably only needed for me.
I come in peace nonetheless.
Okay, okay, all right, thank you. I apologize for interrupting you, Ms. Schmidt. Go ahead.
Certainly. So I'm originally from Massachusetts. I've been in Utah for about... Yeah. I'm originally from Massachusetts. I've been in Utah for 15 years. I got my graduate degree in economics at the University of Utah. My undergraduate was in economics at the University of Massachusetts. And here I am, working for the Division of Public Utilities as a utility analyst. I'm mostly dealing with economic problems. That's my specialty.
Thank you. Have you participated in this docket on behalf of the division?
Yes, I have.
Did you prepare and cause to be filed your direct testimony pre-marked as DPU Exhibit Number 9.0 DIR with its Exhibit 9.01 DIR, which is your resume?
Mm-hmm. Yes, I did.
Did you also prepare and cause to be filed DPU Exhibit Number 9.0 SR, which is your pre-filed sir rebuttal testimony?
Yes, I did.
Do you have any changes or corrections to that pre-filed testimony?
No, I do not.
If you were asked to prepare and file the same pre-filed testimony today, would your answers be the same?
Yes, they would.
Do you adopt your pre-filed testimony as part of your testimony here today?
Yes, I do.
The division would like to move for the identification of Mr. Fields' direct and sir rebuttal testimony as previously identified.
Yes, for the admission of Mr. Fields' direct testimony with one exhibit and sir rebuttal, seeing no objection, we'll admit them into evidence.
Do you have a summary to share with us today?
Yes, I do.
Could you please proceed?
Certainly. Good afternoon, Commissioners. My testimony addresses Enbridge's proposal to change the time span for calculating the normal heating degree days, HDD, for the General Service GS class, and the company's implementation of its customer-specific weather normalization adjustment, the WNA. Based on its review of the information provided in this case, the division recommends the Commission direct the company and other interested parties to further study revising the period used to establish the NHDD and the customer-specific WNA. In this case, Enbridge proposes a change to the time span for calculating the NHDD from its current 20-year period ending in 2018 to a 10-year period ending on December 31st, 2024. The company asserts that this change is needed to reflect recent warmer winters and better balance upward and downward monthly WNA adjustments. Enbridge witnessed Mr. Landward's testimony supporting this proposal provided evidence that demonstrates shortening the period used to calculate NHDD lowers the NHDD baseline. The division remains unconvinced that the company's proposed shift to a 10-year period for calculating the NHDD is adequately substantiated. The company has not provided sufficient empirical evidence for this modification. A comprehensive time series analysis or longitudinal data analysis, for example, would be essential to effectively confirm the necessity of a change to the proposed 10-year period concluding on December 31st, 2024. Mr. Landward's testimony does not show that the difference in average NHDD values, 20-year versus 10-year, is statistically significant. In the absence of a proper statistical test that demonstrates the difference is unlikely to have occurred by random chance, the apparent variance between the time frames cannot be reliably used as evidence for a material change or trend. This lack of statistical significance undermines the evidentiary weight of Mr. Landward's comparison. The National Oceanic and Atmospheric Administration, NOAA, employs a standardized 30-year baseline for calculating NHDD to establish a normal climate, which constitutes a robust, long-term standard. Mr. Landward did reference a recent 15-year set of climate normals by the NOAA. However, this serves to supplement the standard 30-year normals to facilitate multivariate investigations into recent climate changes. The downward trend in temperatures cited by Enbridge on the surface could manifest an isolated occurrence or a cyclical pattern. Consequently, utilizing it to form a general conclusion would constitute a fallacy of composition. Therefore, the company would need to provide a more representative sample for an inferential, cross-sectional statistical analysis to be conducted to justify the 10-year period for calculating the NHDD. In addition, I have concerns regarding the company's implementation of the WNA itself. The WNA serves two critical functions for Enbridge. It acts as a monthly true-up mechanism to align revenue with budgetary projections and serves as a safeguard to prevent revenue under collection from approaching the ceiling established by the Conservation Enabling Tariff, the CET. Enbridge claims that the WNA significantly mitigated undercollection that the CET would otherwise have to rectify. In my testimony, I raised concerns about the implementation and computational resources related to the WNA and questioned the efficiency of EGU's methodology. Mr. Landward asserts that the company calculates a distinct normalization adjustment for each individual customer's bill every time a new bill is generated using the company's customer care and billing mechanism, software. However, I believe that this assertion is provisional because details on the methodologies, specific testing protocols, and granular specifics of the individual adjustment calculation and application are significantly absent. The company has not precisely detailed the extent to which its approved revenue stream is maintained irrespective of consumption, suggesting that a comprehensive and persistent assessment of the CET's efficacy is appropriate and necessary. I also respectfully disagree with company witness Austin Summers' assertions that no benefit would be gained from further study of this issue and continue to recommend that the Commission order further study of the company's proposal before revising the NHDD baseline, as the division is not convinced the proposed change to a 10-year period is adequately supported. This concludes my testimony. Thank you.
Thank you. Mr. Fields is now available for cross-examination questions and questions from the Commission.
Okay, thank you, Ms. Schmidt. Thank you for your summary, Mr. Fields. Turn to the company, to EGU.
No questions, thanks.
Thank you, Ms. Clark. Mr. Snar.
No questions.
Mr. Russell.
No questions, thank you.
Mr. Cook.
No questions.
Mr. Davidson.
No questions, Mr. Chairman.
Major Newton.
No questions, sir.
Okay. Commissioner Clark.
I have no questions, thank you.
Commissioner Harvey.
You can't fool me twice.
I would be disappointed if I did.
All right, just a couple of quick ones. You talk about a statistical significance.
Yeah.
The data involved here is a population, not a sample, is that correct?
Yes, that's true.
Okay. So what particular type of statistical significance would you be looking for?
I would have to go back and review the confidence intervals, but if they did I would have to go back and look at the confidence intervals to estimate the statistical significance, especially if they did a time series study. So at this moment, I do not have that answer. I would need to go and check.
Okay. You probably don't have an answer to this one either then, but I'm going to ask it.
Sure, go ahead, by all means.
In looking at the table in your testimony, I think it's the SIR rebuttal, It's on line 25, starts on line 25.
Yes.
There's a change there from 5350 normal heating degree days down to 48 to 78.
Mm-hmm.
So approximately 500, a 10% change.
Yep.
What I'd like to know is how much bigger would it need to be? But it,
I don't have that answer, but I would like a longer time study to see if there's a reference category to make an effective comparison.
okay. And in terms of the actual weather normalization mechanism, were you in the hearing room earlier today when I was talking about the different measurement areas for temperature with the company witness?
Yes, I was here.
Okay. So given that conversation, do you have any further enlightened understanding of what they're doing, or do you still have questions about what they mean when they say an individual customer?
I still have considerable questions.
Okay, that's good to know. So in terms of what that mechanism is doing, there's some predicted heating degree day, correct?
Yep.
And then there's an actual amount at this individual customer level. And that difference is then what's fed into their formula to come up with the adjustment.
Mm-hmm.
Does that sound correct to you?
Yeah, it does. But
Okay.
again, like I said before, I don't know the specifics of their system. It hasn't been presented, so there's still a significant amount of uncertainty.
Okay. But do you agree that the intent, regardless of what the actual mechanism is to try and collect a certain amount of revenue for a given amount of heating degree days?
Yes, I agree.
Okay. And that, then the second part, what I want to know if you agree or not, is that regardless of what that reference level is set to, there's going to be an adjustment that pulls it back to what they're expected.
Mm-hmm. I agree.
Okay. And then the CET, at a later date, will do a final true-up with respect to all of the costs, not just the commodity costs.
As it should, yes.
Okay. That's all the questions I have. Thank you.
Okay, Mr. Fields, I have no questions. You may be excused.
Okay.
Thank you very much.
Thank you.
Appreciate it.
Thank you.
Before we take a break, I'd like to try to finish all of the division's witnesses. So, Ms. Schmidt, will you call your final witness?
The division would like to call Mr. Matthew Pernicoli.
Mr. Pernicoli, welcome. Would you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you very much. You may be seated.
Good afternoon.
Good afternoon.
Could you please state and spell your full name for the record?
It's Matt Pernicoli, Pernichle.
Thank you. By whom are you employed, and what is your position?
I'm employed by the Utah Division of Public Utilities, and I am a utility technical consultant.
And what is your business address?
160 East, 300 South in Salt Lake City.
Have you participated in this docket on behalf of the division?
Yes, I have.
Did your participation include reviewing the application, the pre-filed testimonies of the company and others, and reviewing and/or preparing data requests and responses?
Yes.
Did you prepare and cause to be filed your pre-filed testimony consisting of 1, your direct, DPU Exhibit Number 6.0 DIR, along with its exhibits 6.01 DR through 6.08 DR. Your rebuttal testimony, pre-marked as DPU Exhibit Number 6.0 R, that had no exhibits, and your surrebuttal, pre-marked as DPU Exhibit Number 6.0 SR with one exhibit, pre-marked as DPU Exhibit Number 6.01 SR.
Yes.
Do you have any changes or corrections to your pre-file testimony?
No.
If you were asked to prepare and file your pre-file testimony today with the same questions, would your answers be the same?
Yes.
Do you adopt the contents of your pre-file testimony as part of your testimony here today?
Yes.
The division would like to move for Mr. Pernicoli's direct rebuttal and surrebuttal testimonies with exhibits as appropriate.
Okay, thank you, Ms. Schmidt. Without objection, we'll admit Mr. Pernicoli's direct testimony into exhibits as rebuttal testimony, surrebuttal testimony with one exhibit into the record.
Thank you. Mr. Pernicoli, do you have a summary to share with us today?
Yes.
Please proceed.
Good afternoon. My testimony in this case focuses on the structure of the general service class, gradualism, proposed changes to allocation factor 230, and one clarification. Regarding the general service class, over 99% of Enbridge's customers are in the general service class, and over 60% of the company's volume is billed to the general service class. In Enbridge's previous rate case, docket number 22-05703, the division noted that the general service class contained a very heterogeneous group of customers with vastly differing load factors, volumes, and infrastructure needs. This creates the possibility of intra-class subsidies, with some general service class customers paying significantly more than their cost of service and some paying less. I noted in my direct testimony that this single class arrangement appears to be very rare among natural gas utilities. In response to a division data request, the company calculated the effects of splitting the general service class by basic service fee, as it recently did in Wyoming, and by annual volume. Excuse me. The company's calculated split by basic service fee showed rate of return indices between 0.998 and 1.1419 for the proposed classes. The proposed volumetric split showed a rate of return indices between 0.59 and 1.4. These disparities are too large and too easily remedied to be left within a single class, especially when that class contains almost all of the company's customers. In discussions during the course of this case, the company stated several times that it would not be able to implement any division of the general service class quickly enough to be effective during the period of this rate case. I was unable to find a reason to question this assertion. I do not propose splitting the general service class now because it is impractical given the time limitations, and no clear alternative has been thoroughly studied. Mr. Daniel testifying on behalf of OCS, noted that it is unclear if the benefits of such a split would exceed the costs. This question also deserves additional study. I propose that splitting the GS class be examined more thoroughly in a separate docket. This should be scheduled to provide sufficient time to study the issue so that changes could be implemented in Enbridge's next general rate case. This is the approach that was used when the company's transportation class was split in the previous rate case. Regarding gradualism, parties recommended that the commission apply gradualism in implementing the company's proposed rate increases to certain rate classes. Mr. Oliver, testifying for the American Natural Gas Council, argues that the proposed increase for the interruptible service transportation bypass firm and transportation classes violated the principle of gradualism because they are too extreme to be implemented at one time. He proposed limiting these increases to 1.5 times the company's overall rate increase. In my pre-filed testimony, I testified that I guess this is my rebuttal testimony. I testified that Mr. Oliver is correct in that the rate increase for the IS class is too large and should be mitigated. I also noted that the rate increase for the TBF class appears to have already been mitigated in the company's recent cost of service study filed after the Phase 1 stipulation. Lastly, I recommended that the transportation classes rate increases be judged as a percentage of their whole cost of receiving gas service and are thus reasonable rate increases. Alternatives to allocation factor 230. Several parties have proposed changes to allocation factor 230 that would result in shifting costs from customers with higher load factors to those with lower load factors. This issue has been extensively studied and debated in Enbridge's recent rate cases. The Commission has been consistent in approving the 60% demand, 40% throughput calculation for allocation factor 230. To provide the Commission with more options, I proposed using the average and peak methodology from the NARUC manual using actual peak day usage for the demand component. The division also proposed this methodology in the company's last rate case. I withdrew this suggestion in my rebuttal testimony because I was unable to get sufficient historical information in the time available to conduct a thorough analysis. Because I was unable to properly support actual peak day allocation, I support using the current 230 allocation factor. And I have one clarification. The division recognizes that prudence is usually judged based on what is known at the time the decision is made, and that there is an ongoing duty to be prudent. And that concludes my summary. Thank you.
Okay, thank you, Mr. Pernicoli.
Mr. Pernicoli is now available for cross-examination questions and questions from the Commission.
Okay, thank you. Let's go to the company.
No questions, thank you, Chairman.
Okay, Mr. Snar.
No questions for OCS.
Okay, Mr. Russell.
No questions, thank you.
Mr. Cook.
No questions.
Mr. Davidson.
I do have questions, Mr. Chairman. Thank you. Good afternoon, Mr. Pernicoli.
Good afternoon.
Just a couple of questions at the beginning about your experience, if I may. Your direct testimony, page 1, lines 10 through 15, outlines your background a bit there. Do you see that?
Yes.
Okay. And as I understand it, you've been with the division for approximately 2 years, is that right?
Yes.
Okay. Did you have any experience with public utility rate regulation before joining the division?
No, I did not.
Okay. And your testimony also references your most recent participation in the Rocky Mountain Power Electric rate case, correct?
Yes.
Is that the only other regulatory proceeding you've testified in?
No, I've tested in other regulatory proceedings, but that's the only rate case I've testified in.
All right, let me have you turn to your rebuttal testimony at page 4.
All right.
And at lines 82 through 83, you state, quote, gradualism is most meaningful to customers when measured against the full cost of the product they are purchasing. Do you see that reference?
Yes, I do.
And in the context of that statement, what is the product that you believe transportation customers are purchasing?
Natural gas.
Okay. So it's not transportation service they're purchasing, it's the commodity of natural gas in your estimation, correct?
It's both.
It's both?
Yes.
At page 4 of your SIR rebuttal, lines 84 through 86, you suggest that the company's proposed charges to transportation service customers cannot be directly compared to the company's proposed pricing service to other classes. You see that reference?
Yes.
And that's because transportation service charges don't include gas commodity costs, while the company's charges to other classes do include commodity costs, correct?
That is correct.
And am I correct that the company's revenue increase request in this proceeding is premised solely on the distribution non-gas costs?
Yes.
And none of the revenue increase the company seeks is based on its costs of gas supplies for firm sales service customers, correct?
That's correct.
Okay. Now, at line 90 on page 4 of your SIR rebuttal, you reference a need for, quote, like-for-like comparison of charges for transportation service and sales service customers. You see that reference?
Yes, I do.
Can you explain why the appropriate like-for-like comparison in the context of this case, which focuses primarily on distribution non-gas charges, does not exclude gas costs for transportation service and sales customers?
I believe the proper perspective to determine if something is gradualism is the perspective of the customer for the service they're being provided. And when the customer gets a bill from Enbridge, it includes gas. If one small component of that bill goes up by a much higher amount than the price change for the whole rate case, we don't judge it on that component, we judge it on the whole bill. I don't believe that transportation customers should get a special dispensation for gradualism because they choose to divide that bill between multiple vendors, if that makes sense.
Well, it does, but let me ask you a clarification on that. You mentioned that customers' bills is what's important with respect to the principle of gradualism, correct?
Yes.
Now, you also said that that includes the commodity and the delivery, correct?
I believe that's correct.
All right. Now, a transportation customer, their bill from Enbridge doesn't include the commodity, correct?
That's correct.
Only the transportation service.
That's correct.
Okay. Am I correct that there's no analysis or supporting exhibit or documentation that you performed regarding specification of the usage characteristics assumed when computing, quote, full costs for transportation customers?
Yes.
And would you agree that the full cost for transportation service will be influenced by the customer's level of monthly gas use and the relationship between their monthly and annual gas volumes and their firm contract demands?
Yes, that's my understanding of how the current tariff is written.
Now, at page 4, lines 88 through 90 of your SIR rebuttal, you reference, quote, using an average gas price of $3 per decatherm. You see that reference?
Yes.
Now, I didn't find any support for the representativeness, if you will, of that assumed $3 per decatherm average gas price in your testimony. Is that correct?
Yes, those numbers are very confidential. I don't have access to them.
So this is just an illustrative number that you use for purposes of preparing your testimony?
That's correct.
And am I correct also that you've not provided any documented quantitative analysis to support the assessment of full costs of the product you believe Enbridge Transportation Service customers are purchasing?
I just multiplied the volume by my assumed price.
the assumed price, the $3 per decatherm we just spoke about?
That's correct,
Okay.
yes.
Likewise, I didn't find any analysis of the quote, full cost, close quote, that firm sales service customers pay under either rate schedule FS or rate schedule GS. Am I correct on that?
Yes, you are.
So I think we established that the primary service transportation customers obtain from Enbridge is the delivery of gas purchased from third-party suppliers, correct?
Yes.
And would you agree that the commission only regulates the company's costs of distribution service for transportation service customers, but not the prices that the customers pay for gas volumes?
That's correct.
So if the commission doesn't regulate the price that transportation service customers pay for their gas supply, why do you believe that the quote, full cost, close quote, of the product purchase should include both the gas commodity and transportation?
I don't believe in any description I've ever read of gradualism, it says it limits it to what the commission can regulate. Now, the commission might not be able to regulate something that it can't regulate, obviously, but I don't think that's what the gradualism analysis is based on.
So in order to, if I understand you, in order to apply the gradualism principle, it's your opinion that you need to apply it to both the commodity and the transportation service combined for a transportation service customer?
Yes, it is. That would be treating transportation customers and other customers equally.
And in your mind, there's no application of gradualism to the transportation function rate at all, without having a commodity component included?
Without understanding it as part of the whole cost, yes.
Okay. Now, at the top of page 3 of your SIR rebuttal testimony, you have table 1.
Yes.
Okay. And that provides 2 sets of percentage increases for customers served under rate schedules IS, TBF, TSS, TSM, and TSL. Do you see that?
Yes.
All right. Those sets of percentage rate increases are based on the company's assessment of revenue increases by rate class that reflect the reduced overall revenue increase from the Phase 1 settlement. Is that right?
EGU's final proposed, the second column do. I believe Mr. Oliver's were calculated before the final settlement.
That was my next question. Okay, thank you. Would you accept that all the percentages listed in the columns of Table 1 are premised on the analysis which assume each class must provide the company with its full requested overall rate of return of 7.61%?
I think Mr. Austin Austin Summers, I'm sorry, Austin.
Mr. Summers.
Went through that earlier. Because this is based on his SIR rebuttal testimony exhibit 16 SR, I believe. And what did he say? Honestly, right now, I can't remember if this was prepared using the numbers under the previous rate case or what was proposed under this rate case.
Okay, I'll refer back to whatever it was he said when I looked at the transcript. But that's what you're based on.
Yes.
You based your testimony on, correct?
That's correct.
Would you accept that the percentages on your Table 1 under the heading EGU's final proposed increase reflect the company's class cost of service summary results, but do not match the percentage increases in DNG revenues by class that can be computed from the information on the rate design 10-year tab of the same electronic model.
I would have to check that.
Okay. All right. At page 3 of your SIR rebuttal, lines 57 through 70, you discuss the increase proposed for the company's interruptible service, the IS class, correct?
Yes, I do.
And you've got several assertions that you've got there I'd just like to walk through. First, you state that the IS class has received a large subsidy for a long time. Is that your testimony?
Yes, it is.
And am I correct that you don't have any evidence that supports either the length of time or the amount of the so-called large subsidy that you believe has been provided?
I guess the proposed increase to get it to its cost of service is evidence of a large subsidy. But other than that, no.
And is it your testimony that the commission has, over time, intentionally allowed large subsidies to the IS class at the expense of customers in other classes of service?
I can't speak to the commission's intentionality on that.
So why do you think the commission has allowed those alleged subsidies over time?
I'm not I mean, I could speculate, but I mean, there is value to having an interruptible class. Even if they don't get interrupted that often. We pay a lot of money as utilities to be able to cover times of extremely high usage, so.
All right, and in your SIR rebuttal, you state that service to the IS customer class has only been curtailed a few times in the last 25 years. Is that correct?
Yes.
Do you have any number of what a few times consists of over that time period?
I do not.
Okay. So is it your understanding that service to the IS customer class must be regularly interrupted or curtailed for that service to provide value to the system that is not attainable from firm service sales customers?
No.
Why not?
It's a reserve capacity for use in times of extreme emergencies, like the liquid natural gas plant that we have on the system, or.
All right, and I'm hoping you can clear up a little confusion on my part at least at page 3, lines 59 to 70 of your SIR rebuttal that we've been speaking about. And I'll represent to you that it appears to me that on one hand, you're concerned about the large subsidies we spoke about a moment ago that have been provided to the IS class, but on the other hand, you suggest that the large increases in rates for IS customers could, quote, deprive the system of the flexibility that results from being able to interrupt a portion of the load. Do you see that?
Yes, I do.
Is it your position that the flexibility to interrupt the portion of the system load represented by the IS class justifies some level of subsidy for IS customers?
Assuming that is not handled somewhere else in their rate calculation, I believe there is some level of subsidy that is worth giving to those folks.
Okay. And do you have any analysis or documentation in your testimony about what the level of the subsidy that you're referring to should be?
I don't make any recommendation as to a specific level.
Okay. But there should be some.
I think there should be some.
All right, at page 3, lines 69 through 70, you referenced an aggregate price increase of 11.18%. Do you see that reference?
Yes.
And you indicate that, as Mr. Oliver suggested, and you provide a footnote 9 that cites Mr. Oliver's rebuttal testimony at page 12. Do you see that?
Yes, I do.
Now, I do have a copy of his testimony here, but do you recall where on page 12 of his rebuttal, there's any reference to an aggregate price of 11.18%.
I do not. The 11.18%, I believe, is the rate increase of the whole system, the aggregate rate increase for all customer classes. And my understanding of Mr. Oliver's recommendations on gradualism, and this is, I've seen this in past rate cases, is to make something gradual, you limit its rate increase to 1.5 times the aggregate.
And do you agree with that approach?
I think it's a workable approach. I'm not going to say it's the only one, but it seems reasonable.
All right, Mr. Pernicoli, those are all the questions I have for you. Thank you.
Thank you.
Okay, thank you, Mr. Davidson. Major Newton,
Briefly, Commissioner,
please.
want to keep you on your toes.
Thank you.
And when you were talking about your experience with, before this commission, is it fair for me to assume that this is your first involvement with this company in testifying in a case?
I believe that's correct.
Okay. Now, when you talked about the class cost of service in your direct testimony, you cited Utah Code Section 54-4 Alpha-6, particularly noting fair cost allocation. You cited it as costs are fairly distributed within and among different customer classes. And of second note, cost causation, that rates and charges should directly reflect the costs that customers impose on the system. Generally, customers should pay for the costs they cause. You cited these, but do you agree with those?
Yes.
Okay. And as I too am new to the Enbridge gas general rate cases, but with your, I'll call them fresh eyes to the evaluation of this, in your
Thank you.
in your rebuttal testimony on page 5, lines 101 to 102, you describe the current allocator factor 230, F230, as a compromise. Is that correct?
I'm sorry, could you repeat that?
Absolutely. On page 5 of your rebuttal testimony, lines 101, which is answering a question regarding the allocation factor F230, you describe allocation factor F230 as a fair compromise.
Yes, that's the way it's been portrayed in recent rate cases. And that's what the commission's approved in recent rate cases.
Okay, thank you. No further questions.
Thank you.
Okay, thank you, Major Newton. Ms. Schmidt, do you have any redirect?
No redirect, thank you.
Okay, thank you. Commissioner Clark.
No questions, thank you.
Commissioner Harvey.
Just a couple. With regards to the general service class, the GS class, is your final recommendation that you would recommend splitting that on both meter size and volume?
No, those were just two possible splits. Can you hear me? Okay. Sorry. Those were just two possible splits that we had the company do the analysis on. When I looked at other tariffs from other natural gas utilities, most of them had different kinds of splits than those two, or those two combined with other ones. But I don't have a recommendation right now. I'd like to go through the process of investigating further.
So the recommendation is some type of a study group or some other type of method to look at the possible
That's correct.
options. Okay. With respect to splitting the class, is the major benefit in your mind that cost allocation would be done better?
Yes. There would be less subsidy amongst the different members of the class. Or at least that would be the goal.
Okay. But there wouldn't, Okay, sorry, strike that. Would there be any change to the actual operations that the company does to ensure that the firm sells customers get the gas they need?
I don't believe so, no. I don't see how, I don't foresee an outcome where that would be the case.
So from an operational perspective, it would have no effect, but an accounting perspective, it might.
That's correct.
Okay, thank you. That's all my questions.
Mr. Pernicoli, you referred to what EGU did in Wyoming.
Yes.
What's your understanding of the split of the GS class in Wyoming?
I believe they did a volumetric split.
Okay. And there were, and into two classes, is that correct?
Yes,
General service, small and large general service?
yes.
Okay, do you know any of the, can you tell me the difference between those two classes? Did you study that?
I'm sorry, I can't recall, and I didn't bring that information with me.
Okay, that's fine.
Apologize.
No, that's fine. I just was curious. All right, I think that's all the questions we have of you, Mr. Pernicoli. We'll excuse you. Thank you.
Thank you.
And that concludes all the division's witnesses. We've now covered 10 of the 15 witnesses, and I propose we take a break. Can we be back here at 12, 13 minutes by 4 o'clock? Is that adequate for everybody? You need a longer break? Seeing nobody complaining about that, we'll be back at 4 o'clock. We'll keep rolling. Thank you. Back on the record. We'll now turn to the Office of Consumer Services. Mr. Snar, my recollection is you're going to be presenting the witness, James Daniel.
Yes, that's right.
Okay, and we'll note again, we're glad Mr. Moore is with us. It's always good to have you here. Okay, let's have Mr. Daniel come to the stand. There's no S on the name, right?
No S.
Okay. Mr. Daniel, will you raise your right arm to swear? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please be seated. Mr. Snar.
Thank you. Mr. Daniel, could you please state your name for the record?
My name is James Daniel.
And could you tell us by whom you're employed?
I'm employed by engineering firm GDS Associates.
And have you been used as a consultant for the Office of Consumer Services in this proceeding?
Yes.
And in connection to that, have you reviewed all of the filings that have been made in connection with this Phase 2 portion of the proceeding?
Yes, I think I've reviewed most of them.
Okay. Now, in connection with that assignment, have you prepared testimony for pre-filing in this case?
Yes.
And did you pre-file direct testimony on September 16 of 2025, including exhibits?
Yes.
And did you file rebuttal testimony on October 16, 2025?
Yes.
And did you also file surrebuttal testimony on November 4th, 2025 with exhibits?
Yes, I did.
And if you were asked the same questions today, would you adopt all these questions and answers as your testimony today?
Yes, the questions and answers are fine. I do have one minor correction that is not related to the questions and answers, if I can.
Let's identify that and get it cleared up.
In my rebuttal testimony, the cover page has the correct exhibit number, which says Phase 2 Witness OCS 3R Daniel. The following pages after the cover page refer the exhibit to as 3D. So the 3D needs to say 3R.
So the header on the numbered pages in your rebuttal testimony needed to be corrected to show R for rebuttal.
Correct.
Thank you. Have you prepared a summary of your testimony for presentation here?
Mr. Snar, do you want to admit the testimony first?
Yes, we would move the admission of the testimony and exhibits. It's OCS 3D Daniel and related exhibits, OCS 3R Daniel and OCS 3S Daniel and related exhibits.
Okay, thank you. We'll, without objection, admit the testimony, the direct rebuttal as corrected with the heading corrected, and the surrebuttal testimony of Mr. Daniel.
Would you present your witness summary, please?
Yes. Good afternoon. My summary will provide a brief description of each issue I address in my testimony. The first issues are related to cost allocation. Some of the parties in this case are wanting to relitigate two major cost allocation issues that the Commission decided less than 3 years ago in docket number 22-05703. The two allocation issues are EGU's use of its allocation factor number 230 and EGU's allocation of large high-pressure mains on the basis of system throughput. Allocation factor 230 has been used for many prior EGU cases. It is based on the sum of 60% of the design date allocation factor and 40% of the system throughput allocation factor. The parties that are opposing these two allocation methodologies that were recently approved by the Commission have not provided any change in EGU's system that would support their proposal to depart from the Commission's order in EGU's previous rate case. the commission should reaffirm its prior ruling on these two major cost allocation issues. Next, the next issue is related to the allocation of interest on past due accounts. Interest on past due accounts is a source of other revenues that are credited to customer classes' allocated cost of service, which reduces the amount that needs to be recovered in base rates. In this case, EGU is proposing to allocate the interest they receive on past due accounts using the distribution non-gas or DNG revenues. EGU's DNG allocation factor is a general allocation factor and is not related to the cause of the past due accounts, which is customers. I recommend that interest on past due accounts be allocated on the number of customers. To be consistent, I'm also recommending that bad debts or uncollectible expenses should be also allocated on the number of customers, as pointed out in the UAE rebuttal testimony. Next issue is allocation of EGU's proposed NGV subsidy to customer classes. EGU is proposing to subsidize its natural gas vehicle program and NGV customer class by approximately $898,000 per year. The company is also proposing to allocate this subsidy using its general DNG allocation factor. This will result in the GS class paying approximately $789,000 or 88% of the subsidy. None of the non-NGV customer classes have caused the NGV class's revenue shortfall, which is the basis for the proposed subsidy. A more equitable allocation methodology, one that does not result in one customer class paying lion's share, should be used. While I oppose the proposed NGV customer class subsidy, if the commission approves of subsidy, I recommend that the NGV subsidy be allocated to customer classes using the throughput allocation factor. In addition to this NGV subsidy allocation issue, I recommend that the company wind down its unprofitable NGV service and that the commission order EGV to file a plan for that purpose prior to its next rate case. The next issue is the revenue distribution. Another contested issue in this case is whether gradualism should be used to mitigate significant rate increases. Several parties claim that EGU's proposed class revenues based on the cost of service results in severe rate increases for certain classes. These parties are proposing that gradualism be applied to alleviate the large percentage increases. EGU's proposed class rate increases are similar to the percent increases approved by the commission in EGU's prior rate case. And the commission did not use gradualism in that case. My position is that since the commission did not apply gradualism in the last case, then it should also not approve it in this case. I support the company's proposal to move all classes to cost of service based rates. Next issue is the GS rate design. ANGC suggests that EGU's current base base service fees, or BSF, should be increased, but does not propose how much. No other party is proposing an increase in the BSF charges. I recommend that the commission approve EGU's proposal to maintain the current level of BSF charges. The next issue is Section 8.03 of EGU's tariff. In its application, EGU proposes to delete a component of Section 8.03 related to eligibility for the HEAT is an acronym, it's capital HEAT, Customer Assistance Program. In my direct testimony, I opposed the proposed deletion and suggested the need for other revisions to Section 8.03 of the tariff. EGU and OCS have since agreed to revise tariff language, and that was included in the surrebuttal of EGU witness Jordan Parks. Next issue is the conservation enabling tariff. An issue in this case is whether EGU should be allowed to continue using the CET. My current recommendation is for the Commission to, 1, accept the DPU's revisions to the CE2, 2, allow EGU to conduct its planned independent third-party analysis of its energy efficiency programs, and 3, have the Commission analyze the need for the CET in EGU's next rate case.
Thank you.
Got one or two more issues.
I'm sorry, did I jump the gun? Oh, I did.
Yep. Next is the weather normalization adjustment. In this case, EGU is proposing to reduce the number of years to determine normal weather by 50%. The WNA currently uses 20 years, and EGU proposes to use 10 years. EGU also refers to as support an American Gas Association survey on weather normalization adjustments. There were 10 respondents to that survey. 5 of them used 10 years, and the other 5 respondents used 20, 25, and 30 years. In my opinion, the reduction to 10% is too drastic given the AGA survey, and the Commission should approve a 15-year period. Last issue addresses large new customers. Due to the huge national growth in data centers, electric and natural gas utilities are experiencing and projecting large increases in energy supply requirements that require large increases in infrastructure facilities. Regulatory commissions need to ensure that the utilities' existing customers do not pay for the costs caused by the new data center customers. The Commission has already begun to address this issue for electric utilities. The issue also needs to be addressed for gas utilities. The Commission should address this issue in an investigatory docket and should temporarily close the Transportation Bypass Firm, or TBF, rate class until the Commission has addressed this issue. I'd also note that I had proposed some tariff language adjustments regarding this issue. One of them was in Section 9.02 and regarding the threshold for large new loads to pay upfront the preliminary engineering cost incurred. The current tariff has a $50 million threshold for system cost increases for the new load. I recommended that that be reduced to $10 million. Thank you. That's the end of my summary.
Thank you. Mr. Daniel is now available for cross-examination and questioning.
Okay, thank you, Mr. Daniel, for your summary, and thank you, Mr. Snar. Turn to the company.
The company has no questions. Thank you, Chairman.
Okay, does the division have any questions?
The division has no questions for this witness.
Okay, Mr. Russell.
I do, but this should be very brief.
Okay, go ahead.
Mr. Daniel, good afternoon.
Good afternoon.
You mentioned in your summary your recommendation that the Commission not adopt gradualism for the transportation classes, and you base that in part on your recollection or your kind of reference to the last rate case. Is that right?
Yes. Yes.
Okay. You acknowledge, I suppose, that the commission did utilize rate mitigation measures in the last rate case due to the rate shock associated with the split of the transportation class. Is that right?
I don't recall if that's right.
Okay, that's all I have. Thank you.
I don't recall.
Okay, that's all I have. Thank you.
Okay, all right, thank you, Mr. Russell. Let's see if that, no, excellent. Mr. Cook?
No questions.
Okay, Mr. Davidson, any questions from you?
I do have some questions,
Okay,
Mr.
please.
Chairman. Thank you. Good afternoon, Mr. Daniel.
Good afternoon.
Let me have you turn to your SIR rebuttal at page 1, line 14, where you begin a discussion of new large customers.
What line?
It starts at line 14. I'm going to ask you about lines 17 through 20.
Okay.
And there you characterize Mr. Oliver's rebuttal testimony as suggesting a wait-and-see approach to addressing additional requirements for new large customers. Do you see that reference?
Yes.
Can you point me to any place in your direct rebuttal or SIR rebuttal testimonies in this proceeding where you've identified or quantified the dollar impact of specific load problems that new large loads had on the Enbridge system to date in Utah?
I have not made that analysis.
Okay. And at page 2 of your SIR rebuttal testimony, line 24, you have a reference to the Utah Legislature's SB 132. Do you see that?
What line?
Line 24?
Yes.
Okay. Am I correct that SB 132 addresses electric utility amendments?
Yes, that's correct.
And would you accept that there's nothing in that statutory provision that specifically addresses new large gas service customers?
Yes, I believe that's correct.
Okay. You also make a reference at page 2 of your SIR rebuttal down at lines 24 through 27 to the Commission's docket number 25-R318-01. Do you see that reference?
Yes.
Am I correct that that docket is focused on large-scale electric service requirements?
Yes, that's correct.
Have you reviewed the comments of the Office of Consumer Services that were submitted in the docket we were just speaking about, 25-R318-01, on August 28, 2025, and October 10, 2025?
I do not believe I've reviewed that.
Okay. Would you accept, for subject to check, that neither of those filings includes any explicit reference to gas service issues for large-scale customers?
Yes, I'll accept that subject to check.
Thank you. At page 2, lines 31 through 33 of your SIR rebuttal, you state that EGU indicates in its 2025 IRP that it's already received multiple requests to serve direct power generation at specific data center locations. And I think you mentioned that a little bit in your summary. You see that reference?
I did.
Am I correct that there is no quantification in your testimony of any specific impacts or problems associated with those, quote, requests, close quote, for gas service for data center locations?
No, the information needed to do that's not available.
Not available?
Correct.
All right. Am I correct that there's no place in your direct rebuttal or SIR rebuttal testimony in this proceeding where you've identified any specific costs associated with large customer loads for which the company seeks recovery in this proceeding?
No, I don't think there is.
And also, is it correct that nowhere in your testimonies have you identified or quantified any specific costs associated with large customer loads for which the company is seeking recovery from non-large load customers?
Are you referring to new customers or existing customers?
New large load customers.
If they're beyond the test year, they wouldn't be included in this case.
Okay, well, what about new large load customers that you were referencing in your testimony? If they were included in the test year, is there any quantification that you've made of any cost impacts from those customer loads that would come onto the system?
I don't believe that during the test year, the company experienced any new large loads.
So this is sort of aspirational on the company's part as far as when those large loads may or may not arise? Is that correct?
Based on the IRP, they've said they've had requests for service by large loads.
Just requests though, right? Nothing has come to pass as far as development of a large load during the test year, I think you just said, right?
I don't know if the company has or hasn't. I don't know the details.
You mentioned gradualism in your summary. At page 3 of your SIR rebuttal, starting at line 50, you address the, quote, proposed revenue distribution and gradualism. You see that reference?
Yes.
And it's my understanding that it's your position all class revenue requirements should move to their full cost of service as long as no class receives an increase greater than the largest increase the commission approved for any class in the company's last rate case, correct?
I don't think that's correct.
What's incorrect about it?
I don't think I limited it to whatever the largest increase was.
You didn't limit it to what?
To whatever the largest increase was. I think it's more that it was in the range of what the commission approved in the last case.
So not a specific number, but a range of impact, is that it?
Yeah, it was I don't think I recommended a specific number.
Okay. Is it your understanding that the Commission's determination of class revenue requirements in docket number 22-05703 included no consideration of gradualism principles?
Well, you previously asked me about the transportation class, and I just don't recall what was done for those.
Okay, I don't think I asked you about that. Well, someone else I think did, but let me ask you this question.
Okay.
Are you aware that in the Commission's order in that proceeding, the docket number I just mentioned, there was a specific provision for a phased implementation of rate increases for the company's transportation class? Does that sound familiar?
It does.
Okay.
I now remember that, yes.
Okay. Are you familiar with the Phase 1 settlement in this proceeding and the overall revenue requirement that for EGU that it produces?
I'm not.
Would you accept, subject to check, that the Phase 1 settlement provides the company an overall revenue increase of its distribution non-gas revenues of approximately 14%?
Yes, that sounds correct.
In the context of the Phase 1 settlement revenue increase that we just spoke about, what's the largest percentage increase you believe would be reasonable to apply to any EGU rate class in this proceeding without violating gradualism principles?
I haven't made that analysis.
Do you have an estimate of what that would be?
I'm relying on the commission's order in the last case.
Okay.
As a limit.
And that order just provided for the transportation class to be separated out, I think we just spoke about, right?
It was a phase-in to get to cost-based rates.
Okay, and where does gradualism for other customer rate classes fit into that, if at all?
Well, I'm not sure I understand your question, but they were not part of the phase-in, so there was no gradualism for the other classes.
Okay. Does your position regarding the maximum increase acceptable without violating gradualism principles vary depending on the rate class in which the increase is applied?
No, I don't believe so.
It's applicable across the board?
Yeah, generally, it doesn't matter what class it is.
Okay. Would you accept that customers in all classes can be expected to have made energy use-related investment decisions such as appliance choices, building insulation decisions, et cetera, based on the company's currently effective rates?
I suppose there are some customers that would have done that.
And when making energy use-related investments, do you believe customers should be able to expect some reasonable continuity in rates and charges for gas service that they'll be required to pay?
Well, that's one of the things you consider when determining a revenue distribution. But
So yes.
Other factors are considered as well.
Okay. Let's look at page 6 of your Sir rebuttal testimony. And the allocation of interest on late payments portion that begins at line 118, do you see that?
I do.
All right. At lines 125 and 126 on page 6 of your Sir rebuttal, you state that, quote, ANGC witness Oliver agrees with my recommended adjustment to allocate interest on late payments on the basis of numbers of customers in each class, close quote. You see that?
Yes.
Can you cite the page and line numbers in Mr. Oliver's rebuttal testimony that you relied on for that statement?
I can't right here.
Okay, I have a copy of this, but would you accept, subject to check, that it was Mr. Oliver's rebuttal, page 22, lines 468 to 477, that you base that recommendation on?
Yes, I'll accept that, subject to check.
Okay. Just trying to keep this going here because I know we're trying to finish up today, and I'm almost done. The only expression of agreement with your testimony on this matter relates to Mr. Oliver's assessment that, quote, large customers are not generally the source of past due accounts, and that allocating interest on past due accounts using DNG revenues most likely overstates the portion of interest on past due accounts that is appropriately attributable to large customers. Is that correct?
I assume you read it correctly.
Okay. Now, can you indicate to the commission any other place in Mr. Oliver's rebuttal testimony where you believe he expresses support for your recommended allocation of interest on past due accounts?
I don't have it in front of me, so I cannot do that.
If I gave you a copy, would you be able to find something in it?
Can look.
Okay. May I approach? I think I picked the page for you here, but please feel free to look through as much as you need to.
All right. I'm sorry, could you ask your question again?
Sure. Is there any place that you can find in Mr. Oliver's rebuttal testimony where you believe he expresses support for your recommended allocation of interest on past due accounts?
His recommendation is if the commission accepts my allocation, then should also allocate uncollectible accounts using the number of customers.
Sorry, your call has gone on longer than allowed. Goodbye.
Oh, that's not good.
Let's go off the record for just a second.
That's it.
Is there a pending question?
I think maybe, but I'll see if Mr. Daniel found anything that's responsive.
Yeah, Mr. Oliver's rebuttal testimony, he says he agrees with me that large customers are not generally the source of past due accounts, and that the allocating interest of past due accounts using D&G revenues most likely overstates the portion of interest on past due accounts that is attributable to large customers. Goes on to say if the commission accepts Mr. Daniel's rationale for his proposed change in the allocation of interest on past due accounts, the commission must also find that the same rationale suggests that EGU's allocation for uncollectible accounts expense in account 904 is also inappropriate and reflective of actual cost causation. So my testimony does mischaracterize what he said.
Okay. And just before we had our technical difficulty, that one more question. Am I correct that you have provided no analysis in this proceeding that demonstrates a correlation between the number of customers in each rate class and the costs EGU incurs for interest on past due accounts?
No, I did not have that information.
That's all I have for you today, Mr. Daniel. Thank you.
Okay, thank you, Mr. Davidson.
Thank you.
Excuse me, Major Newton.
I think I just have one question.
Okay, proceed.
Good evening, almost.
Good evening.
And looking at your rebuttal testimony on page 7, where you're addressing Mr. FEA's testimony regarding the cost allocation factor on on line 150, you note one of your criticisms of FEA's testimony is that we did not point to any change since the last rate case that would support the commission departing from its methodology for determining just and reasonable rates in its recent order. Is your testimony that Enbridge would have to change their system in order for a different allocation factor to be adopted if it was proven to be based on cost causation principles that were just and reasonable?
Well, that would be the primary thing that would maybe support changing how costs are allocated. But I'm referring to the two allocation factors, the 230 and the allocation of the large intermediate high-pressure mains. That's probably, what would need, there would have to be some system changes for those two allocation factors to change, in my opinion. Other allocation factors, there could be other things that could change that might support changing how the allocation was done.
Okay, thank you. No further questions.
Okay, thank you, Major Newton. We'll turn to Mr. Snar for any redirect.
No redirect.
Okay, we'll turn to the commission. Commissioner Clark.
No questions, thank you.
Okay, Commissioner Harvey.
Just a couple. I'd like to explore the new large load concerns that you've expressed in your testimony and your summary. Given the existence of the CET and the rates by class coming out of a rate case being set, what types of costs specifically do you see that there's a danger that they could be misallocated or whatever it is that you're, I guess, explain your concerns to me a bit more.
Well, it kind of ties to the tariff language change as well. That when a large load requests service from the utility does an engineering analysis, determine what the system impact is of that large new load. So it might require additional pipelines, certainly mains. They determine how much it's going to cost, and depending on their tariff provisions, they may be able to charge a contribution in aid of construction for some of that additional cost, but they may not be able to include it all in the CIAC. So those system improvements that would be caused by the large load would be the things that I'm concerned about.
And do you have specific tariff language in their current tariffs that you think would allow a new large load customer to come on without paying all of those costs that they find in the studies?
Well, the biggest concern are these new data centers, and there are other issues related to those. A lot of them could be have multiple applications with other utilities for the data center, so they may or may not materialize, but the company could have already incurred some cost to address that. So, the data center issue is really what I was focused on.
And I guess I'm trying to understand is why you think there could be those unpaid costs. And I want you to point out where you think I'm getting this wrong. When I read that tariff, it seems to me that the company has to write a check before they start the engineering study.
Yes, that's correct for that section .902. That once they go forward with commitment to put their data center connected to EGU's system, then EGU is going to have to start building facilities to serve that customer. And some of those facilities in the next rate case could get allocated to everybody.
So your testimony is there are provisions in the current tariff that allow that potential transfer to happen, that the new large load doesn't have to pay for that construction prior to receiving service?
Yes, that's right. There's a line extension provision that may require payment for part of that, but not all of it, and that's the concern.
All right. Thank you. I appreciate the
Thank you.
Mr. Daniel, I'm tempted to let this go, but since I confused you with Mr. Orton, I think I better ask this question. So when we were talking about preliminary engineering costs for large-scale projects, you made two recommendations. First one was the company may require an upfront payment to shall require an upfront payment. It's my understanding that the EGU agreed with you on that proposed change. Is that correct?
Yes.
And then you made a second recommendation that you lower the cost threshold that the company proposed of $50 million for requiring upfront payment to $10 million for requiring upfront payment. Is that your recommendation?
Yes, it is.
And you've heard Mr. Park's testimony as to the reasons why the company did not agree with your recommendation to lower the cost threshold from $50 million to $10 million. You were here and heard that?
Yes, I believe he said that the $10 million threshold would increase the number of customers that would fall into that category and require them to do a lot more studies than what at the 50 million.
Yeah, so referring to his testimony, well, I won't have you turn there in the interest of time. Just, if you can just take it on faith, he's indicating that lowering it to $10 million would significantly broaden the number of projects subject to the requirement, including many that are routine and that would have minimal engineering costs associated with them, and that can increase administrative overhead and lengthen the overall project siting process. So those reasons that he gave, they're not adequate for you to abandon, if you will, your $10 million threshold argument. Is there any merit to that, to his position there, that it should stay at $50 million?
Well, I think it's a reasonable point. I would say that what we don't know is at 20 million, what does that threshold cause? Maybe it's not an insurmountable, a large number of additional routine accounts. So, you know, between 50 and 10 million, that's a big gap. So if 10 million is going to cause a lot of extra work on their part, you know, maybe a 20 million might be the right number.
Okay.
We just don't know that information.
You don't know whether it could be $50 million is an adequate number or not? It's just, there's a range, you think, in between 10 and 50, where currently is proposed.
Yeah, a $50 million cost of additional facilities is a huge number, in my opinion.
Yeah, which would typically require significant upfront engineering costs associated with it. That's what I think their position is.
Well, it's for the cost of the preliminary engineering study.
Right. Okay.
And I don't think that's significant, the study.
Okay. For a $50 million project, yeah.
Right.
Okay, all right. I think I understand your position. All right. You can be excused, Mr. Daniel. Thank you very much.
Thank you.
Okay, we'll next move on to Mr. Russell and
Mr. Daniel.
I have UAE's witness next, is that correct?
That's right. Utah Association of Energy Users calls Courtney Higgins.
Okay, Ms. Higgins. Thank you. Will you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Good afternoon. Could you state and spell your name for the record, please?
Good afternoon. My name is Courtney M. Higgins. That is Courtney, middle initial M, Higgins.
And could you tell us who you work for and in what capacity?
Yes, I'm an associate principal at Energy Strategies,
And on whose behalf do you offer testimony in this proceeding?
the Utah Association of Energy Users, or UAE.
Did you prepare and cause to be filed direct, rebuttal, and surrebuttal testimony in this proceeding?
Yes.
And let's go ahead and identify that. The direct testimony I have as UAE Exhibit COS 2.0 with UAE Exhibits COS 2.1 through 2.3. Rebuttal testimony labeled as UAE Exhibit COS 4.0 with UAE Exhibit COS 4.1. And surrebuttal testimony labeled UAE Exhibit COS 5.0 along with UAE Exhibit COS 5.1. And in addition, you submitted rate case models with your direct and rebuttal testimony. Is that right?
Yes, that's right.
Okay. And with respect to all of that testimony, do you have any corrections to make?
Not at this time.
And if asked the same questions today that were posed in your pre-filed testimony, would you provide the same answers?
Yes, I would.
Okay. At this point, I will move for the admission of Ms. Higgins' direct, rebuttal, and surrebuttal testimony along with all associated exhibits and work papers.
Okay. Without objection, we'll admit the direct rebuttal, surrebuttal exhibits and work papers.
Thank you, Mr. Chairman. Ms. Higgins, have you prepared a summary of your testimony for us today?
Yes, I have.
Okay, please proceed with that.
Good afternoon, Mr. Chair and Commissioners. I appreciate the opportunity to be here today on behalf of UAE. My Phase 2 testimony offers several recommendations to better align cost allocation with the way the distribution system is designed and built. I also address rate spread and rate design for transportation service classes. The first issue I wish to address concerns both cost allocation and rate design for the Transportation Bypass Firm, or TBF class. It also affects the overall revenue deficiency, which is the increase to current rates necessary to achieve the revenue requirement in the Phase 1 settlement. Enbridge is projecting significant load growth for a TBF customer during the 2026 test period. Although forecasted test periods inherently present some challenges, the way that Enbridge has reflected this load growth creates a particular problem. This problem occurs because there is a mismatch between the TBF cost allocation inputs and billing determinants. The company allocates a full year of demand-related costs to the TBF class based on the higher level of firm demand expected in the latter half of 2026. However, the TBF billing determinants reflect 5 months of the pre-growth level and 7 months at the higher load level. Allocating demand-related costs based on the higher demand level, but designing rates using a hybrid of the lower and higher load periods results in TBF rates that are materially overstated. This would cause all TBF customers to pay higher rates than justified under the established TBF pricing framework, including existing customers who are not associated with the additional load. My adjustment applies the higher TBF load to each month of 2026, which increases the TBF billing determinants for the January to May 2026 period. This increases the adjusted TBF revenue at current rates, thereby reducing the revenue deficiency. Under the Phase 1 settlement, to which UAE is a settling party, the total revenue requirement is $604 million. This corresponds to an increase of $62 million using Enbridge's billing determinants, or $60.2 million incorporating my TBF adjustment, which is a difference of $1.8 million. Phase 2 issues are not foreclosed by the Phase 1 settlement, and I continue to recommend that my TBF load adjustment be adopted in Phase 2. Correcting this mismatch will moderate the TBF increase and help preserve the economic incentive for existing TBF customers to remain on the company's distribution system. It will also modestly reduce the costs allocated to the non-TBF classes. Absent this adjustment, a portion of the benefit from the additional TBF load will accrue to Enbridge during the interim period between the 2026 test period and the next rate case effective date. In his rebuttal, Mr. Summers raises revenue-related concerns about my adjustment, but he acknowledges that the magnitude of TBF growth is significant and proposes to limit the TBF increase to 1.5 times the system average. While I continue to recommend adoption of my TBF load adjustment, if the Commission declines to do so, Mr. Summers' proposal to limit the TBF increase to 1.5 times the system average would be a reasonable alternative, given the unique circumstances of this case. Beyond TBF, several familiar cost allocation issues warrant the Commission's consideration. I'd like to turn to allocation factor 230, which is the blended factor used to allocate the feeder system, compressor station, and measuring and regulating station costs. As I'm sure we're all familiar, allocation factor 230 incorporates both an average or throughput component and a peak component. This is a method which is often termed the average and peak method. Both UAE and the company have long recognized that design day demand is the appropriate measure of demand-related cost responsibility, and I continue to support the use of design day demand for this purpose. I further recommend weighting the throughput component by the system load factor, which is 34%, including the TBF adjustment I just discussed. This results in a 66% design day, 34% throughput weighting. In his rebuttal testimony, Mr. Summers acknowledged that UAE's proposal has analytical merit, though he maintained the company's 60% design day, 40% throughput approach. I also recommend that the allocation of large diameter intermediate high pressure mains incorporate a distribution design day component. The costs of large diameter IHP mains are currently allocated solely based on distribution throughput. However, this system is also designed to meet design day demand, and it is appropriate for this cost driver to be reflected in cost allocation. With respect to interest on past due accounts, the office's proposal to allocate this revenue based on customer counts should be rejected. Interest is assessed as a percentage of arrearages and therefore varies with the size of past due balances, not the number of customers. Any change to this item should be considered alongside the allocation of uncollectible accounts, collection expense, and the bad debt gross up, all of which are closely tied to bad debt incurrence, not necessarily to customer counts. In turning to rate spread, it would be reasonable for the Commission to consider limiting class increases to mitigate the impacts that certain classes would otherwise experience. The refinements I propose better reflect cost causation and reduce cost-based increases for the transportation, TBF, and interruptible sales classes. The case for moderation is even stronger under Enbridge's cost of service study, which produces higher increases for these classes. I would support the Commission's consideration of rate moderation proposals to temper these effects. I don't oppose proposals by the Office, the Division, and ANGC to limit or eliminate the natural gas vehicle class subsidy. If any NGV subsidy is retained, cost responsibility should be allocated based on distribution non-gas revenue, as the company has done, in order to apply the cost of funding this subsidy proportionately across the non-NGV classes. Finally, on the subject of rate design, I recommend that the Commission decline to adopt Nucor's proposal to redesign TSL volumetric rates, which would impose an undue burden on smaller TSL customers. Throughout my testimony, I've recommended that any reduction to the proposed TS volumetric revenues relative to the company's original proposal be applied on an equal percentage basis within each class. I also recommend that the Commission decline to adopt Nucor's rebuttal proposal to greatly increase the TS firm demand charge. A demand charge increase of the magnitude proposed would alter the economics of firm service for transportation customers and could disrupt the stability of this rate element. That concludes my summary. Thank you.
Thank you, Ms. Higgins. Before I make you available for cross-examination, there's one point of clarification I want to make. Mr. Summers, both in his rebuttal testimony and while he was on the stand today, made reference to some assistance that you had provided with respect to some modeling, some sort of a broken formula with respect to Enbridge's rebuttal model, or maybe it's rebuttal model. Does your assistance on that matter indicate your support for the allocation factors of other positions that are reflected in that model?
Not entirely. So I did point out that there was a cell reference error in the company's rebuttal cost of service model, and that particular error was resolved in Mr. Summers' surrebuttal model. I would not want to give the impression that I'm endorsing all elements of the company's surrebuttal model. I provided my own version of the cost of service model alongside my rebuttal testimony. And in that model, I reflect a proxy group of adjustments to achieve the settlement revenue requirement. It also reflects my cost allocation and rate design proposals. There are also switches in that model that can be toggled on and off if the Commission wishes to explore those alternatives.
Okay, thank you. Ms. Higgins is available for questioning.
We do have questions, Chairman. Good afternoon, Ms. Higgins.
Good afternoon.
We haven't met before. I'm Ronit Barrett, and I'm here on behalf of Enbridge. It's nice to meet you today.
You as well. Thank you.
So I would like to discuss, can you hear me? Am I close enough to the mic? Okay. I would like to discuss one aspect of your recommendation to adjust projected load in the TBF class. You are familiar with the concept of a test period, correct?
Yes.
Okay. And would you agree with me that the test period in this case is an average 13-month forecast for the period ending December 31, 2026?
I agree.
Okay. And are you aware that in Utah, a future test period cannot be based on projected data exceeding 20 months from the date a proposed rate change is filed?
I am familiar with that requirement.
Okay. And EGU filed this rate change on May 1, 2025, correct?
Yes.
Okay. And no party has disputed that test period?
Not to my knowledge.
Okay. And so the farthest out data that the Commission can consider in this case is December 2026, correct?
Go ahead.
Go ahead. No, go ahead.
For the purpose of establishing the test period, I agree that data beyond 2026 would not be part of that test period.
Okay. And do you agree with me that under this future test period paradigm, to determine the appropriate rate design, the utility must project things like the load that it expects to serve?
I agree that load projections are part of a future test period.
Okay. And load does not always remain constant throughout the test period, correct?
That's correct.
Okay. One reason for this could be customer growth. That is, anticipated new customers joining the system. Is that right?
Yes.
And another reason for a change in load could flip the other way and be an unexpected loss of load, right?
Yes.
Okay. For example, large industrial customers can experience financial hardship that causes them to curtail their use.
That could be the case. Quickly, when you said an unexpected loss of load, by definition, I guess when you say unexpected, if it is unexpected, it would likely not be included in a forecast of the test period. So it would be, expected load changes might be included in such a forecast.
And unexpected ones would not?
Right.
Okay. Some customers of EGU could even go bankrupt, right?
Right.
Are you aware of any of EGU's large industrial customers that have filed for bankruptcy recently?
I am not personally familiar with that.
Okay. Are you familiar with US Magnesium?
Yes.
Okay. But you are not aware that they filed for bankruptcy on September 25th of this year?
I will accept that that is likely the case based on your presentation.
Okay. So in this case, EGU has projected that its TBF class load will increase over the course of the test period, correct?
Right.
Okay. And EGU has pinpointed the month where it believes that load growth will occur for the first time, correct?
Right, which is June 2026.
June, that was my next question. And that's because EGU anticipates one large load customer will come online in June 2026.
My understanding is that the customer is currently connected, but that the company is anticipating that their load will grow significantly during 2026.
Yes, thank you for that clarification. But would you agree with me that it's not a certainty that the customer will increase its load?
That is true. And like any forecasted test period, there are elements of uncertainty.
Okay. So the project could be abandoned or canceled?
There is the possibility that that could happen. I can't speak to the facts of that particular customer.
But the best available knowledge for the test period at the time EGU filed this case indicated that load will increase for the last 7 months of the year, June through December 2026.
That's right.
Okay. And would you agree with me that no one has offered any evidence that the project will come online sooner than June 2026?
I agree.
Okay. And would you agree with me that you have not put any evidence in the record at all about whether this project will still be contributing to load outside the test period in 2027 and 2028?
Right. I have not put forth specific evidence about the post-test year period. My expectation would be, since the company has decided to allocate demand-related costs to the class as though that load will be there, in other words, bringing a full year of demand-related costs to the TBF class, that if the company felt that load was going to disintegrate, that would not be fair treatment for the TBF class. So I feel that based on the evidence we have in this case, that load is expected to materialize, and I don't have a reason to believe that it will disappear.
But the evidence that you just referred to is the test period only, 2026, right? The company has not made any representations about 2027 or 2028.
Correct. I don't believe we have representations about the post-test year period for that or any other specific customer.
Okay. And in fact, considering data from the post-test year period would fall outside that statutory 20-month period that we agreed ends December 2026, correct?
For the purpose of creating the test period, I agree that looking beyond that period would overreach too far into the future. However, I do think that we should be mindful about what the future implications of the decisions that are made in this case are. And so while it may not be within the strict confines of a test period, we still need to be mindful about whether those customer classes are being treated equitably within the confines of that test period. And as I do think it is relevant to point out that, all based on the information we have in this case, during that post-test year period, Enbridge would benefit from that additional load. And that is not included within the strict confines of the test period, but it's informative. And that's why I brought up that fact.
Okay, I'd like to show you Enbridge Cross Exhibit 2.
Sure.
May I approach, or may Ms. Mitchell approach? Does everybody, okay. Oh, the commissioner.
Oh, I'm sorry.
Oh, so what I've given you is a copy of Utah Title 54, specifically Section 54-4-4, classification and fixing of rates after hearing. And I'd like you to look at it. Unfortunately, it spans the page break, but if you go to 3, you'll see the 3 on the bottom of the first page, and if you flip it over, you'll see under that B, and then a Romanet 1. Could you read B Romanet 1 aloud, please?
Yes. A future test period that is determined on the basis of projected data not exceeding 20 months from the date a proposed rate increase or decrease is filed with the commission under, am I reading the right section? That doesn't sound like a full.
You could start with B.
B,
Sorry, the way
me.
I said it was a
Okay.
little confusing. Start with B
Yes.
and continue through
Yes.
Romanet 1.
Okay, let me back up. In establishing the test period determined in subsection 3A, the commission may use a future test period that is determined on the basis of projected data not exceeding 20 months from the date a proposed rate increase or decrease is filed with the commission under section 54-7-12. Shall I
Okay.
continue?
No, that's okay. So this, what you just read says the commission may use projected data not exceeding 20 months. But your testimony today is, you hear that, you see that, but you still want them to consider some data from 2027 and 2028?
No, I'm not asking for data from 27 or 28 to be considered within the test period.
You're asking for the effects to be considered?
I'm asking for a specific adjustment to be applied to the January to May 2026 period in order to be consistent with the company's allocation of demand-related costs to the TBF class, which is based on an annualized or year-end demand level.
Okay, so, and let me just step back a little. We talked about it a little bit when Mr. Summers was on the stand, and you today, but I just want to clarify what your position is and what his position is. So Mr. Summers recommends using the projected load for 2026, and that means taking an average of the 5 months preload growth and the 7 months post-load growth, correct?
So for the purpose of reflecting the billing determinants in the TBF class rate design, that's correct.
Okay, and you propose something different. You propose using the higher post-load growth projections for every month in 2026, correct?
Correct.
Okay, even though we've established that no one thinks the load is going to start before June.
Right, it's a matter of trying to maintain alignment with the allocation of demand-related costs in order to avoid a distortion where those costs are coming to the class based on this single annualized end-of-year number, but then being recovered over a different set of billing determinants.
Okay, so, and in making that recommendation, you're assuming that the load will continue through 2027 and 2028, correct?
I'm not making a specific assumption about the load continuing beyond beyond the test period any more than I'm making that assumption about the load in general for any class. I mean, we're working within a test year construct, and so my concern is is limited to that for the period for the purpose of establishing the test period.
Okay. Could you turn to your rebuttal, which is UAE Exhibit 5 at page 13? Yes.
I suppose we could take judicial notice of this. What you've had, her review is just section 54-4-4. But you referred to as a cross exhibit. Did you want to admit this as a cross exhibit?
I mean, just to have the record complete, we might as well, yes. So I would move for admission of cross exhibit 2.
Okay, all right. Seeing no objection, we'll admit that, which is really just section 54-4-4 of the Utah Code. Thank you. Sorry for the
You're
interruption.
welcome. That's okay. So your rebuttal, Exhibit 5.0, starting at, just direct your attention to page 13 and starting at line 234, and we're going to go over to page 14, line 239, and you state, if the TBF load adjustment is not made, the incremental revenues associated with a portion of the projected TBF load growth will accrue to Enbridge between rate cases. Since the company's billing determinants capture only 7 out of 12 months at the higher TBF load level, Enbridge would benefit from 5 months of unaccounted for revenue growth in both 2027 and 2028, assuming approximately 3 years between rate cases. Have I read that correctly?
That's right.
Okay, so you are essentially broadening the test period to a 3-year period to include your assumption about this one customer's future use.
I disagree.
But doesn't part of the basis of your recommendation necessarily consider data outside the statutorily mandated 20-month period?
I am not relying on the effect that incremental growth may have on Enbridge's earnings between rate cases as the basis for my recommendation. It is really designed to ensure that the TBF class and really all classes are treated equitably within this case, based on a 2026 test period.
Okay, and let's say, arguendo, that the commission is allowed to look beyond the test period. I'm not representing that they are, I don't think they are, but I just want to explore that with you for a little bit. Your recommendation to include the impacts of this load, or to consider the impacts of this load, doesn't include asking the commission to look at any other elements that might have impacts in 2027 and 2028, correct?
I'm not proposing a broad application of a 2027 or 2028 projections, no.
Okay. And you haven't taken into account any reduced usage due to potential bankruptcies or other reasons?
No.
Okay. You have picked one large customer with increasing volumes in 2026 and extrapolated that to 2027 and 2028 without updating any other forecast information. Isn't that right?
To be clear, I didn't pick this customer. I observed that there was an anomaly in the company's rate case model, in their cost of service model, that bared further explanation. And when I asked about that, the company explained to me that it was based on a single customer whose load was expected to grow, and that was driving the increased cost allocation to TBF. And so I am responding to that data with my recommendation.
Okay. And do you agree with me that one purpose of requiring a test period in rate making is to make sure that no cherry picking occurs?
I agree that a test period should generally reflect an alignment between revenues and expenses and rate base and cost allocation inputs. Cherry picking is, I guess parties could argue that any particular item that another party brings up is cherry picking if they do not think it is significant. So I don't see this as cherry picking. I see this as responding to material load growth that is affecting cost allocation and something that I could not ignore.
So I think we agree, though, that in a test period, part of the purpose of it is that all of the relevant information for that period is considered, and that it's not just the most harmful or just the most beneficial items.
I agree that the test period should be looked at holistically, including all relevant elements.
Okay. You refer to your recommended treatment for the TBF billing determinants as, quote, year-end treatment, close quote, and you testify that this year-end treatment is atypical, that it should not be applied to other elements of this case. Is that correct?
It is year-end treatment in that it matches the company's year-end treatment of demand. And so, you know, gas cases can be sort of unusual in that they depart from how electric utilities, for example, often allocate costs. They may look at loads throughout the year for the purpose of determining demand-related costs. The design day is a singular day, and because of that unique importance of that singular day, and the fact that this load is occurring in the latter half of the year, I felt it was reasonable to align the billing determinants and those cost allocation inputs.
Okay, and I'd like to draw your attention to your direct testimony. That's UAE 2.0 at page 16, lines 266 to 271. And in response to the question that reads, in proposing your TBF load adjustment, are you advocating that 2026 year-end treatment be applied to the other elements of this case? And you respond, no, and then you continue to say, my adjustment is narrowly tailored to reflect the TBF load growth anticipated to occur mid-2026 to ensure internal consistency between the TBF cost allocation inputs and billing determinants. It should not be interpreted as a proposal to broadly apply 2026 year-end treatment to any other aspects of this case. Did I read that correctly?
Yes.
Okay. I'd like to just briefly move on to one other issue related to this topic of TBF billing determinants. Were you listening remotely this morning when EGU witness Mr. Summers testified?
Yes.
Okay. And do you remember the line of questioning that your attorney, Mr. Russell, asked about the two compromise alternatives to EGU's proposed TBF billing determinants?
Yes, I did listen into that portion of the testimony earlier.
Okay. And one of those alternatives was a stepped rate increase, correct?
Yes, I did offer that as an alternative to the alternatives in my direct testimony if my primary proposal were not adopted.
Okay. And the other was a mitigation of the rate increase to the TBF class by limiting the increase to 1.5 times the system average increase, correct?
So in my direct testimony, I offered a couple of alternatives that were based on cost allocation. Those alternatives were either to allocate demand-related costs to TBF based on the average firm demand for over the course of the 2026 test period. The other alternative was to pull out this load growth entirely. And then in response to the company's rebuttal testimony, Mr. Summers' rebuttal testimony, where he proposed moderating that increase to 1.5 times the system average, I agreed that that would be a reasonable alternative as well.
Okay. And so, and this question is directed at the testimony from this morning and the two alternatives that were discussed there, which is the stepped rate increase and the the mitigation of 1 to 1.5 times. In your opinion, are both of those alternatives acceptable compromises to this disputed issue?
There's an administrative advantage to implementing this as a moderated rate increase to TBF as opposed to a step or phased-in increase. I know that can be inconvenient for customers to be experiencing multiple rate changes, and admittedly, this alternative was not fully developed in the record since it didn't really gain much traction in rebuttal or surrebuttal. So I would say that as an alternative to the company's direct proposal, it would be preferable to have a phased-in approach. However, I believe the administrative simplicity of simply moderating the increase for this class would be preferable if my primary proposal is not approved.
Okay. And just, I'm realizing that I just started talking about the step increase without sort of explaining what it is, which would be 2 different rates throughout the year, right? A first rate at the load level for the first 5 months of the year, and then a second rate for the 7 months of the year, so it matches the projection exactly, right?
That's right. And I think in order to implement that correctly, it would actually involve changing rates for all classes, both in that first phase and then in that second phase, because what would happen is that the billing determinants associated with that load growth and the cost allocation inputs associated with that load growth would have to get pulled out of that step 1, and then we'd have step 2 where those are brought in. And so it has implications beyond the TBF class.
Okay. Thank you. I have no further questions at this time.
Thank you, Ms. Barrett. Let's turn to the division. Do you have any questions?
No questions.
Mr. Snar, the office.
We have some questions. As a preliminary matter, I've been advised by my client that we have a public hearing scheduled.
Yes, so let's just talk about that for a second. I don't think we're going to get done tonight. It's pretty obvious that we've got 3 more witnesses. We have noticed a public notice of a public witness hearing that will commence at 6 o'clock. So we'll probably need to, we'll finish with this witness and then we'll have to be through for the day. We'll probably need to commit, we'll commence that hearing at 6 o'clock. There may be nobody will show up. I don't know. Is there anybody here yet who intends to participate in the public hearing? I think I recognize most of you, so you're here as staff and employees. So by the notice, we need to be able to keep that public witness time open till 6:30. I don't suspect anybody wants to continue after 6:30, so we'll reconvene in the morning at 9 o'clock. I think that's what we scheduled.
It would probably be appropriate to have, if not a potty break, a snack break before the 6 o'clock hour.
Yeah, we're gonna stop at 5:45. So that if you've got questions and can do it within that time frame, and we may have some other questions, we'll have Ms. Higgins come back tomorrow, but can't tell. Okay, but just go ahead, Mr. Snar.
Thank you. Good afternoon, or good after evening, as the case may be.
Good evening.
You represent the interests of Utah Association of Energy Users, is that correct?
Yes.
And in the testimonies you have filed in this proceeding, you've raised some questions about Enbridge's cost classification methodology and the allocation of costs to Enbridge's various rate classes. Isn't that correct?
Yes.
In your direct testimony at pages 16 and 17, you explain that you disagree with Enbridge's use of the weighting factor of 60% and 40% as the allocation factor of 230, is that right?
Yes.
And you suggest that the throughput portion of that allocation factor should not exceed the system load factor, correct?
Correct.
And you also acknowledge that Enbridge's use of the allocation factor is consistent with the prior commission order 22-05703, is that right?
Yes.
I would like to look at that order in just a little more detail on the allocation issues. I do have copies of that order that I can share. I think we can take judicial notice of it, but I'd like to use it as an exhibit here.
Yeah, that's fine. Let's pass it out. It's in the record. It's available to anybody who wants to look at it. You don't need to have it admitted. If you want to, we can, but it's not necessary. Thank you, Mr. Moore.
For convenience, I've highlighted a couple of areas that'll ask the witness to zero in on.
Are they highlighted on all the copies too?
Yes.
Okay, that's great. Yes. Okay. I think we can take judicial notice. It's on there in the record. I think that's what Mr. Snar prefers. You don't want to make it an exhibit.
I'm happy to have it be just a judicial notice and
Okay.
use this just as a tool to bring
That's
out the
fine.
testimony.
That's what we'll do.
Can I have you turn to page 36, please, of that order? I'd like you to read the highlighted portion there. I believe that's the part of that order that pertains to the 60-40 allocation factor.
Based on the lack of consensus among the parties, we find the 60%, 40% weighting is consistent with the weightings in prior DEU general rate case applications and addresses the need for facilities subject to the F230 factor to fulfill two functions, including meeting design day requirements and 2, moving gas to all customers 365 days per year. We find this ratio also recognizes the diversity of use of the system by all customer groups. Recognizing the inherently subjective nature of this factor, we find it reasonable to continue to use the 60%, 40% ratio that we have approved in previous rate cases.
Thank you. You've also proposed a change in the way Enbridge allocates costs associated with large diameter high pressure mains, isn't that correct?
Large diameter, intermediate, high pressure mains.
Okay.
Yes.
Would you refer to page 39 of that same document, please? And I have some lines highlighted there. Would you please read that?
We have approved DEU's use of the distribution throughput factor for large diameter mains in previous rate cases. In evaluating that method against the methods proposed by UAE, Nucor, and FEA, we do not find any empirical advantages to the alternatives. They simply shift costs to the advantage and/or disadvantage of specific classes without a meaningful rationale.
All right, thank you. Now I have another area I'd like to focus on. I need to have you refer to the Phase 2 rebuttal testimony of Austin Summers, the Enbridge witness. I'm wondering if Enbridge has that available real quick, or?
Just give us a moment, please. Thank you.
Rebuttal testimony? Thank you for providing that. Now, at page 5 of Mr. Summers' testimony, actually pages 5 and 6, he presents charts representing that that the charts show the revenue requirement of Phase 1 settlement stipulation and showing a comparison of the resulting increases or decreases that would occur if the company were to utilize, for example, at the middle of page, UAE's suggested allocation methodology. Is that right?
I see that.
Okay. And at the top of the page, there's a chart that presents what EGU, Enbridge's allocation methodology would produce, right?
Yes.
And as we look at the two, I just have a question. Would it be correct that utilizing the allocation methodology you suggest, if we zero in on the GS customer class, that would shift an approximate $2.9 million increase to the GS customer class when utilizing your approach to the allocation compared to Enbridge's?
If I may, I'd like to refer to my own exhibit, just because I'm more comfortable with what is in there.
Okay.
So in my rebuttal testimony, I provide an exhibit UAE 4.1. And I'll give everyone a moment if they have access to that. If not, I'll just describe what I see.
Or we're supposed to be looking in your rebuttal testimony.
Oh, yes. So this is UAE Exhibit COS 4.1. And if we look at page 2 of that exhibit, this is a version of the cost of service results that reflects a proxy set of adjustments to get to the stipulated revenue requirement. And it also provides the incremental impact of moving to, of my various cost allocation proposals. And so Table 5 is the incremental impact of allocation factor 230, and I estimate that it results in a $2.7 million increase to the GS class, which is approximately 0.56%. This is after reflecting the discount, the TBF discount. So that is in column F of that table.
So looking at what you've done there and comparing to what is in the testimony of Mr. Summers, we're talking about a ballpark of 2.7 to 2.9 million shift towards the GS customer class.
That looks approximately correct.
All right, thank you. Just another question now, kind of jumping here. Are you aware that there's a Utah statute that requires the commission to adhere to its past practices unless the agency justifies the inconsistency by giving facts and reasons that demonstrate a fair and rational basis for any inconsistency they would embrace in a new order?
I am not familiar with that specific statute. However, that sounds plausible, and I do feel that I've provided such evidence in this case.
Okay. That is all the questions I have.
Okay, thank you, Mr. Snar. Let's turn to Mr. Cook. Do you have questions?
No questions.
Mr. Davidson?
I have just one question, Mr. Chairman.
Okay.
And just to set the stage, Ms. Higgins, you had a lengthy conversation with Enbridge Council about the new load coming on mid-year next year. And would it be reasonable to assume that the new TBF customer that you discussed would be required to sign a contract to establish contract demands for that increased load that's being anticipated?
Yes, I believe that to take service under the TBF schedule, that they would need to sign a contract for firm contract demand.
Would it be reasonable to assume that contract would extend beyond 2026?
While I'm not familiar with the specific terms of such contract for that customer, in general, they are at least 1 year in duration.
Okay, that's all I have, Mr. Chairman. Thank you.
Okay, thank you. Let's turn to Major Newton.
I have no questions, Commissioner.
Okay, we'll turn to Mr. Russell for any redirect.
Yes, thank you. Ms. Higgins, I'm going to ask some follow-up questions related to the discussion you were having with Enbridge's counsel. Do you still have, put those back on, do you still have EGU Hearing Exhibit 2? It was that 2-page exhibit with the reference to Section 54-4-4 of the Utah Code.
Yes.
Enbridge's counsel directed you to subparagraph B. I'm going to ask before we dive into this, in connection with your TBF load adjustment, are you advocating that the commission use a test period that is different than the 2026 calendar year?
No, I'm not.
Okay. If I could get you to read subparagraph A, which is the one before you started, could you do that for me?
If in the commission's determination of just and reasonable rates, the commission uses a test period, the commission shall select a test period that, on the basis of evidence, the commission finds best reflects the conditions that a public utility will encounter during the period when the rates determined by the commission will be in effect.
Okay. So that subsection is dealing with, if you're going to use a test period, you should use one that reflects what the public utility will encounter when rates are going to be in effect. And then subparagraph B says, in establishing the test period determined in subsection 3A, here's what the commission may look at. Is that your understanding?
Yes.
Okay. And then subsection little I is, as you had discussed with Enbridge's counsel, when you're using a future test period, you can only use projected data not exceeding the 20 months, right?
Right.
Okay, so going back to my initial question about this series of subparagraphs is relevant to the question of what is the correct test period. And you've said, I think, that your proposal on this doesn't seek to change the test period. Is that accurate?
That's right. My adjustment is to the January to May months of the 2026 test period.
Okay. I think that's all I have. Thank you.
Okay, because of what Mr. Russell raised, we'll see if the company has any recross. No?
No, thank you.
Okay, thank you. We'll turn to the commission then.
Thank you. I don't have any questions.
Commissioner Harvey.
I think the various councils have covered what I was going to cover, so I don't have any questions.
Okay, great. I don't have any questions either. Ms. Higgins, you can step down. Thank you very much for being here late in the day.
Thank you for accommodating me.
You're welcome. Okay, it is what it is. I think we're going to have the last three witnesses come back. Fortunately, two of them have been allowed to appear remotely, so we may have nobody who'll show up here, but we're going to break now. Those who want to leave and not stay for the public witness hearing, they don't have to stay. That's optional on your part as council. I suspect based upon past hearings that we'll have representation here from EGU and perhaps others. But we'll go ahead and adjourn for the evening on the hearing on the merits, and we will reconvene here at 6 p.m. for any who would like to come back and see if we have anybody show up who wants to testify. Okay? We'll start. Is that acceptable? Starting at 9 tomorrow? Okay, all right. We'll start at 9 tomorrow. Thank you, everybody, for your courtesy to each other and for helping move this along. We're in recess.